ruling next hour in a case that has gripped the nation. The outcome all comes down to how the court defines consent.
A person has to consent to every sexual act with every individual who's involved in the moment.
We'll speak with a pair of lawyers this hour. They'll help break down the case so far and give insight into how today's decision could influence future sexual assault cases. And as we await today's decision, we will look at how toxic behavior became ingrained in Canada's favorite sport and if the national governing body has done enough to change it. And we have in-depth coverage on a story that has certainly been at the center of a national conversation for more than 3 years. We are live outside the courthouse where a judge will give her decisions in the Hockey Canada sexual assault trial as the crowd there in London, Ontario, outside court continues to grow. 5 former players with Canada's national junior team are accused of sexually assaulting a woman in 2018. The judge will decide whether the accused are convicted or acquitted on the charges, and the judge will weigh the evidence heard in the trial, of course, and the law, and give her legal reasoning. Her interpretation of how Canadian law defines sexual consent is expected to be key, but the conversation around this case goes far beyond what was heard in the courtroom. It includes how police and the justice system treat victims who allege sexual assault, how Hockey Canada dealt with the allegations, the culture around the sport in this country, and toxic masculinity. And Ali Chiasson is leading our coverage from outside the courthouse in London, Ontario all morning. Ali, set the scene for us.
So, Chris, as you can see, there is a large group now of EM supporters out front of the courtroom. We have already seen and heard them chanting at some of the accused hockey players as they arrive into the courtroom, or the courthouse, I should say. So far, we've seen Dylan Dubé and Alex Formanton. We've seen the lawyers for Michael McLeod here as well. That is when you will start to hear the EM supporters really piping up and chanting for justice. You will also hear them when more, so to speak, counter-protesters show up. We have also seen people who rally for men who, as they call it, are falsely accused here as well with their own Bristol boards. So when you hear the EM supporters chanting for justice, you hear those Men Too movement supporters chanting not guilty. They're all here for Decision Day, and so are we. This case goes back 7 years to June of 2018. This is when the former World Junior Hockey players were in town celebrating their gold medal win that year. Some of them went to Jack's Bar. That is where they met EM, the eventual complainant in this case. You can see that EM in footage hitting it off with Michael McLeod and agreeing to go back to his hotel room where they have consensual sex. It is what happened after that EM alleges was non-consensual. She said that she was frightened when 10 hockey players ended up in the room after Michael McLeod allegedly sent a text message to the team group chat inviting them to the room. She says this was not her idea. The defense counter-narrative says that it was her idea. So as you can hear behind us just there, probably one of the other hockey players had arrived. I think perhaps maybe just 1 or 2 more to go. We are getting near decision time at 10 o'clock. Just to give you sort of a road this far in this trial, which saw a lot of twists and turns. It started with initially a mistrial within the first week. That was over an encounter between a juror and a defense attorney at lunch. And then a second jury was dismissed after a juror said that they felt like they were being made fun of by another defense team while in court. That is how we got to this point today, where this became a judge-alone trial. And today, in about an hour from now, or less so, we will hear Justice Maria Carroccia deliver her decision for each of the 5 accused hockey players accused of sexual assault, all of whom have pleaded not guilty. Chris.
And Ali, as the momentum continues to build to that decision, those decisions that Canada is really waiting for here, we do know that the judge's decisions are expected to hinge on consent.
That's right. So the Crown said it in their opening statement that this is a case about what is consent and what is not consent. We made mention earlier that the counter narrative among the defense is that it was EM who initiated the sex, even egging it on. This is something that EM has categorically denied. Still, though, we spoke with a law professor in Ottawa, and she tells us that in scenarios like this, there ought to be more steps taken to ensure that consent is given. Have a listen.
The Supreme Court of Canada has been very clear that the reasonable steps requirement will change depending on the context of the sexual activity. So if you're strangers to each other, you have to take additional reasonable steps. If parties are intoxicated, again, more reasonable steps are needed to ascertain consent. I'm hoping that if reasonable steps are an issue here, that we will get perhaps some new and additional clarification on what's required in situations like this, where the parties are totally strangers to each other. There was a lot of alcohol involved, and we had, multiple parties in the room.
So you can hear some excited chants behind me, chanting for justice. Also, there are vehicles that are driving by here in front of the courtroom, honking in support of them. And there is a distinct volley that you can hear. You can hear the EM supporters chanting for justice and calling out toxic hockey culture and how it's got to go. And then you hear also the counter protesters, those of the Men Too movement, chanting not guilty over and over. Chris.
Ali Chiasson there leading our coverage outside the courthouse in London, Ontario. Thank you, Ali. And as Ali just mentioned there, Hockey Canada, those chants for change to happen within the organization is something that we've heard throughout this case. And from even before it, Linda Ward is tracking that part of the story. There was such an outcry back in 2022 when the world became aware of this story. Walk us through all that.
Yeah, at that time, this happened a few years before that, but we just really learned about it in 2022. And that's when it really sort of set off a wave of calls for change to hockey culture, to the culture of sport in Canada. And it's not just about the allegations themselves, but it's about how Hockey Canada dealt with those allegations at that time. So we're learning, and we learned over the last number of years, a lot about that particular aspect. What Hockey Canada's response was to these initial allegations. Back in 2018, they say they contacted police, hired a lawyer, informed Sport Canada, but dropped its own investigation back in 2020 when the alleged victim didn't want to participate, and London police had closed its own investigation as well at that time. But then fast forward to 2022, the complainant suing Hockey Canada and 8 players, Hockey Canada moving quickly to settle that lawsuit without even telling the players that there were these allegations against them. That's when the public really learned about all of this. At the same time, that's when the public learned that this was maybe a bigger problem than just 1 or 2 cases. Hockey Canada, we learned, had what they call a national equity fund for settling lawsuits like these, money that was drawn from membership fees from minor hockey in order to pay for all of this. So it spurred a lot of outcry, and it took that outcry for London Police, Hockey Canada to then take another look at this, reopening their investigations. The effect of all of this is essentially that there were calls for a closer look, more scrutiny on the culture of hockey. But when Hockey Canada took action, when they really felt the heat, is when they started losing the money. The sponsors started pulling out all of the money that they had given them. That was back in 2022, 2023. The federal government froze federal funding, insisting that they make changes.
So 2022 is really when all this hit the ice and that big public outcry happened that led to the images that we just saw there on our screen with all those people going to the courthouse today demanding change from the legal system as well as Hockey Canada. So what changes, though, have we seen, Linda, in terms of Hockey Canada since then? Yeah,
we can't say that they haven't reacted to this. There has been sort of a mea culpa on their part over the last number of years. We go back to 2022, Hockey Canada leadership grilled by the Federal Heritage Committee about their response to the situation. The government then voting for an independent investigation as well into how Hockey Canada dealt with the allegations. Hockey Canada admitted that they did make some mistakes to the Heritage Committee. The entire board of directors was replaced. The CEO was pushed out. And in 2022, they issued an open letter to Canadians that they had reopened their investigation into these allegations specifically. But sort of more broadly, they announced an action plan. All national team members, players, coaches have to undergo training on sexual violence, consent. They track the complaints that come into them now, maltreatment related to hockey. They publish an annual report of the details of this. Then independent governance review happened, and they also became a signatory of the Office of the Sport Integrity Commissioner. That was something that the federal government had been calling for. And Hockey Canada says, hey, we're not going to use that money from those minor hockey league membership fees anymore to pay for any of these sexual assault claims. But whether or not this has changed hockey culture overall, that is still up for debate. Allegations like these specific ones have been out there for years, but it actually took formal criminal charges to pull the accused from the hockey circuit while this is playing out in the courts. There's been little change to junior hockey in this country. The development level, this is where these players come up. This is where they get that culture from. So the ruling's coming down. You can see people walking into the court there, coming down in less than an hour. Regardless of what happens, this is not going to put an end to the scrutiny.
Absolutely. And as the momentum builds towards the judge's decision, Linda, we're certainly watching the courthouse very closely. That image that you just saw of the man walking in, that was Cal Foote. He just arrived. We also know that Michael McLeod and his brother just arrived at court. This is what that scene looked like as Michael McLeod and his brother kind of raced into the courthouse there in London, Ontario. You can hear a lot of screaming from people who are there in that audience. I'll just pause for a second, let you listen to that.
Civilly sue her! Sue EM! Civilly!
All right, and so that is just a bit of the scene there outside the London courthouse. We now know that the accused are there inside the London courthouse waiting to hear the decisions from the judge. We are expecting that to happen at 10 o'clock Eastern time, and that is when our special CBC News Network coverage will begin in earnest. You are watching CBC Morning Live, and we will continue to track this story throughout the day. Later this hour, we'll have a conversation with the executive director of a sexual assault support center to find out what kind of effect this trial has had on their calls. And after that, we're going to check in with a lawyer for some expert insight on the many legal factors at play. But right now, I want to go to Katie Nicholson, who's also part of our CBC News team at the court. She's done extensive reporting on this case and the trial, and she spoke with Paul Hunter about some of the key pieces of evidence as she watched so much of this trial play out.
Well, there is a text that came from Michael McLeod's phone that night with EM without her consent. Now, there is a counter narrative from the defense. They say that EM is the one who instigated this and asked McLeod to invite the players to the room, that she wanted a wild night. This is something that she rebuked and refuted when she was under cross-examination. But the other thing is, we also heard other witnesses say they believed that they were going into the room because there was food. But one of the things that kept coming up is that there was no textual evidence of this. There was no documentary proof that people were going to the room for food. The only thing we saw were the messages from McLeod, this particular one and another one to another player, inviting players to the room for sex with EM. McLeod himself told police initially he didn't know why the players are going to the room, despite the fact that there was this text. Here's a little bit of that exchange he had with his initial investigation sit down with London police.
Do you get the sense that guys are coming because they know there's a naked girl in the room who's doing sexual favors for people?
I mean, like, I don't know how guys kept showing up, because I don't remember, like...
Well, I know everybody has phones and devices in this day and age.
This is, like, probably come over, like this...
Mm-hmm.
There's a girl...
You think that was going on?
Probably, to be honest,
Yeah.
yes.
Okay.
Like,
Were you sending her those messages? or?
No, like I just told the guys I was getting food and there's a girl over. That's all I said to a few guys.
Also entered into evidence, Katie, 2 cell phone videos in which EM appears to have said she was okay with what was happening. How did each side frame those videos?
There's very little sort of evidentiary value in terms of whether this proves consent or not, again, because the law really is about was consent given in the moment. That's not what these videos show, but it is a window into what was happening in that room, a very brief window. And for the Crown asked the court to think about what may have happened before and after these videos were taken. What was the power dynamic like in the room? To think about the fact that there was one woman with as many as 10 men, athletic men, sort of surrounding her. And did she feel that she had to make these videos? Was she fawning? Was she trying to please them as a way to get out of there? For the defense, they used these videos in the same way they used a lot of other videos, and that was really to get a sense of her demeanor. Some of their arguments had included that she wasn't as drunk as she said she was. They were able to use some of these videos to try and counter that. Was she afraid as she said she was? Did she appear afraid in these videos? So again, this is part of the pushback counter narrative that they were able to sort of pull out and tease out from these videos as well.
All right, Katie Nicholson there for us. And Katie has been following along with this trial very closely over the 8 weeks. And so you can read more from Katie. She has analysis on our website for what to watch for in today's decision. Of course, that is something that everybody in the country is watching very closely. And we can show you the scene live outside of London, Ontario right now, where a growing group of people have gathered there. Many of these people supporters of EM, the unnamed complainant. Obviously, there is a standard publication ban on her name, but she is the complainant in this case. 5 former World Junior hockey players are accused of sexually assaulting her, and that incident happened back in 2018. But here we are, and many of the accused have already arrived. We're still waiting for Carter Hart to show up there at the London courthouse. We'll continue to monitor the situation there, as we also have more analysis coming your way as well. Sarah Castleman is going to join me next. She's the executive director of the Sexual Assault Support Center of Waterloo Region. That region has seen a massive uptick in the number of calls that people have been calling in to have support from that center. We'll ask her about that and what the legacy and impact of this case will have. Stay with us here on CBC Morning Live. all eyes are on this courthouse in London, Ontario, where a judge is set to deliver the decisions in a sexual assault trial that dates back for an incident from 2018. That decision is coming in less than an hour, and you are looking right now at supporters of EM, the complainant in this Hockey Canada sexual assault trial. Her identity is protected under a publication ban, and as I was saying, the judge will hand down her decisions in less than an hour for the 5 former World Junior hockey players accused of assaulting EM in a hotel room in 2018. Of course, much of this trial has focused on the issue of consent, and her supporters have certainly been building there outside of the courthouse as we get ever closer to the judge releasing her decisions, now just about 40 minutes away. So stay with us here as we continue to watch for the very latest there, and we will have extensive coverage throughout the day. But joining me right now is Sarah Castleman. She's the executive director of the Sexual Assault Support Center of Waterloo. Thank you so much for being on the program with me, Sarah.
Thanks for having me.
So what kind of emotions or responses are you hearing from survivors as this case gets closer to the decision, as I've been saying, which is coming in less than an hour here, but obviously it's been impacting people in your region and beyond for years now. So how have people been reacting as they're calling in for support?
When early in the trial, we saw a huge spike in calls to our 24-hour support line. Survivors were talking about the trial, processing what they were seeing, processing what they were hearing people say online, public dialogue. And it seems like almost every survivor that's coming into our center, even if they're existing survivors that are working with us, are asking questions and talking about how the trial is impacting them, because they're, you know, if you don't think survivors are listening, they absolutely are. And they are taking in the messages that they're hearing right now about people's attitudes about sexual assault.
I've covered so many of these kinds of cases, and we do certainly see that when there are these kind of high-profile sexual assault cases, survivors do tend to call in greater numbers. How does this case, though, and perhaps the higher nature and the high-profile nature of this one in particular, how have you seen this spike compared to others?
Well, I've been in this field in various capacities for 23 years. And so I remember when Cosby he actually came to our community in Kitchener. It was his first international appearance since the allegations against him had resurfaced and multiplied. And so I remember there was so much attention. The media was here. We were doing international interviews, and every survivor and every community member was speaking about it. And I feel like we've seen these high-profile cases, Cosby, Gameshi, but the difference here is this is Canada and this is hockey, and hockey is so ingrained in our culture and so much of who we are as Canadians. So this is definitely one of the bigger ones that I've seen in 23 years in terms of the impact that it's having on survivors and the impact it's having on public dialogue.
And does that also change the things that they're calling in to say and to ask about?
I think there's definitely some consistent themes. And so one of the themes that we're seeing from survivors is concerns about the justice system. So in a case like this, they're getting exposed to all the pitfalls that are part of our legal system. They know that EM came forward originally in 2018 and police didn't proceed with charges. And so they know that at first the case wasn't, the attention wasn't paid to the case that it should have been. They also know that there was actually 3 trials because the first 2 didn't happen the way that they should because the jury was dismissed. They've just seen so many things around the challenges that EM has experienced within the legal system. But on the other side, they're seeing all those old myths about sexual assault resurface in the trial and then resurface in public dialogue. You know, the things around women regularly lie about being sexually assaulted, or a survivor will react in a certain way if she's really been assaulted. And so all of these things, all of these messages are coming to survivors in our communities across Canada, and they're determining whether they feel safe to disclose their own experiences. They're hearing their friends and family react, and their friends and family might not know that they themselves are a survivor. So it becomes very personal for survivors across Canada.
Yeah, so many people live with and around survivors of sexual assault, and in many cases don't even know it. So an important point that you put out there. And as you say, through this entire trial, which has been quite lengthy, and EM herself taking the stand there for 9 days, a lot of survivors, you said, had been calling in. What do you think is going to happen in the days ahead as we await this decision happening in just about a half hour? We're expecting to get the judge's decisions. Do you think you'll see an even greater flood of calls today and in the days ahead as so many people are aware of this case?
We are absolutely expecting that based on many years of experience of somewhat similar cases. So, tomorrow at our center, we're actually having a drop-in for community care for folks that are impacted by the trial. But what I believe is that there's a lot of people right now wanting to know, like, what they can do, because it feels so overwhelming to watch the case, to hear so much public attitudes that aren't actually based in reality, that aren't understanding the impact of trauma on survivors. And so I think right now there's a lot of folks that need to process, and then there's a lot of folks that want to know what they can do. And your local sexual assault center has lots of ideas around. And so the messages coming out from sexual assault centers across Canada and certainly across Ontario will be giving folks concrete information about what they can do to support survivors in their life.
And Sarah, when we look at this case in particular, what do you think the impact or the legacy will be? Because there's kind of two ways to look at it, really, in terms of the effect of all of this. You talked about the lies and the public attitudes that might not favor survivors, and they might feel some sort of a chill as a result of that. But at the same time, seeing that this has gone to trial and gotten as much scrutiny and public attention as it has, and had that reopened investigation dating back from 2018, could that also empower more survivors to come forward? What do you think will happen?
What I do know is that, our center supports hundreds of survivors every year. And every week we have survivors that are working with our legal system, that are going to court. And I can say that, we've heard from survivors that are in their own cases right now that are watching this and saying to us, why would anyone ever report if this is what they're going to have to navigate? You're talking about something that happened in 2018. We also know that when the police decided to reopen this, Eb was actually upset because she'd spent so much of her life already navigating this issue and trying to move forward, and knowing that now, this many years later, she was going to be thrust back into this. And so I think that there are things. So if survivors are concerned, there are things. So at our center, we have a sexual violence legal advocacy program that will, talk to survivors about all of their options in terms of reporting, support through the court system, all of those pieces. And so I highly encourage survivors who are thinking about coming forward to talk about their experiences or to report their experiences, to connect with their local sexual assault support center, because there's someone there that can talk through all their options and stand with them through the process.
Well, Sarah, it is an important time to speak with people like you who are doing the work that you do, and I appreciate you coming on the program today. I just also want to point out to our audience that your work is not stopping, and tomorrow afternoon, in fact, you're going to be holding a solidarity rally at your office there for any survivors who need support, gathering folks together. So certainly just one example to underscore the work that you are continuing to do. Sarah Castleman is the Executive Director of the Sexual Assault Support Centre of Waterloo Region, joining me today from Waterloo, Ontario. Sarah, thank you.
Thank you.
All right, and let's go back now to London, Ontario, just into the newsroom. The final defendant, Carter Hart, has also arrived. You're looking at pictures of him arriving just moments ago, and as the other accused also had, he is getting shouted at by these supporters who have shown up to lend their support, their voices to EM, the complainant in this case. All 5 of the former World Junior Hockey players accused of sexual assault are now inside that London courtroom as we await the judge's decision here, which we know is coming down in a little less than a half hour from now. And our extensive coverage will certainly continue through this hour and also for the rest of the day here on CBC News Network. I'm Chris Glover. We're back in just a moment. You are looking live at the courthouse in London, Ontario, that has captured the nation's attention today. Inside this courtroom in less than a half hour now, a judge there in London will deliver her decisions on a sexual assault trial that has gripped the nation now for years, really, in the sense that this dates back to 2018, an incident that happened in a hotel room after a World Juniors gold medal game. And certainly it is something that we've continued to watch since 2022, when the incident became public. And obviously this trial took 8 weeks there, with EM, the complainant in this case, taking the stand herself for 9 days there at the trial, as well as one of the accused also taking the stand in his own defense. And certainly we are awaiting the judge's decisions. The 5 players have all pleaded not guilty, and we will see what the judge has to say, as we know that a lot of this will depend on the judge's interpretation of consent in terms of the sexual assault that has been outlined in court. And obviously, the ripple effects from this case are far and wide. They extend far beyond hockey, but certainly today's impact has a potential to impact Hockey Canada. There have been lots of changes that have happened to Hockey Canada since all this first began, and Jamie Strachan is here with me now to look more specifically about the impact of the decision. So as we await here for the judge, who's going to start delivering the decisions in a little less than a half hour now, and we see all those people that have gathered in support of the complainant outside, what are you going to be watching for in terms of the decision?
Well, I think regardless, Chris, of what the decision is in this case, whether these men are found guilty, some of them are found guilty, one of them is found guilty, I think fundamentally it's changed the culture of Hockey Canada. Whether it's going to have an effect on the wider hockey culture, I have some doubts about that. We know initially from a Hockey Canada perspective that, you know, for years, as part of the dues that parents across this country pay, you know, a portion of that was going into a fund to pay off some of these sexual assault complaints, misconduct complaints, before they ever got to trial. So that's changed. Hockey Canada is a national sport organization, so they have a purview over a very small slice of hockey. They get the players when they reach the highest level. So we know that going forward, players involved in the junior program, players representing Canada on the international stage, will go through some kind of training around consent, around sexual behavior, around things like that. That's been implemented. But what effect it will have on the wider hockey culture in Canada is really kind of unsure right now, because the way that hockey exists in Canada, it's very fractured. It's very divided. You have Hockey Canada at the top, and you have all these organizations across the country doing things kind of on a piecemeal level. Remember, the players in this case were teenagers at the time. They were all playing junior hockey in Canada, and they were picked among the best of the best to represent Canada on the junior team. Fundamentally, how we choose elite players in Canada has not changed, and it's different from the 3 other major sports, hockey, baseball, and basketball. The OHL, the WHL, the Quebec Minor Junior Hockey League, the 3 main leagues in Canada, they draft players when they're in grade 10, 15, 16-year-olds. Those kids then go off and play in small towns and small centers across the country, and then eventually, in their dreams, hopefully go off to the NHL. The place for training around consent among these different teams is piecemeal. There's no uniform policy in place that, you know, every player that's playing in the OHL, you know, is going to receive, you know, training around consent. It doesn't exist. So Hockey Canada can do it at the highest level, but the way that we train elite hockey players in Canada, the age that we train elite hockey players in Canada, how it works, how they go away from home, away from their parents, are, you know, heroes in small towns, that hasn't changed. And, you know, when I think of my own son who played high-level hockey, you know, he's in grade 10, and some of his friends this year were drafted. To think of those kids going off, you know, living in North Bay, living in, you know, smaller centers, you know, across the country, what do they know about consent? It's not going to come from hockey. I think if you're relying on hockey to provide that, then you're setting yourself up, and the system's setting itself up to kind of fail again. It's going to come from parents. It's going to come from people in these kids' lives. And sure, you can do a little bit of training, but I think if we rely on hockey culture to fundamentally, you know, shift and change and provide the grounding around what's right and wrong, you're going to see situations like this play out again and again.
Yeah, and certainly conversations around consent have definitely evolved even since this case first became public in 2022. And obviously right now the focal point is the judge's decisions, which we continue to watch very closely for, as they're coming now in about 20 minutes. That will start. It's going to probably take hours, but this case goes back so long. And back in 2022 was another real focal point of this. There was that mass resignation, the Hockey Canada board. Speak to us a little bit about the fallout that they went through.
Yeah, I mean, originally, you know, from the beginning of this case, Hockey Canada, tried to, make it go away. It wasn't investigated properly. The case was kind of existing over here. There was a civil settlement, and then it was only after, years later that the London police reopened its investigation. People realized what was going on with Hockey Canada. Like you mentioned, when a lot of the Hockey Canada executives, appeared before a parliamentary committee, they tried to say, listen, we got it under control. There was a lot of public backlash, and there was a new board. And like I said, there have been changes at the top, and that's the way our sports system in Canada works. These national sport organizations, they can control and exact change on elite athletes. But the way our system is set up, the ability to get down into the grassroots, into where our elite athletes are being developed, that's left to local organizations. In the case of hockey, bigger organizations like the GTHL, the Greater Toronto Hockey League, which is the biggest hockey league in the world. That's where many elite hockey players come from. That's where the real work has to, to get done. And when I look at it, it's being talked about, but it's not a priority.
Right.
A priority in elite hockey is to develop elite hockey players. Things around, consent and things like that, and talking about those kind of things, and bringing in external speakers and doing proper training videos. Those are kind of nice to haves, but there's not a huge demand from it from parents. There's not a huge demand from it, internally from within the league. So these things are happening. They're being pushed. They're happening on a piecemeal basis. But, we see with this trial that's been going on, and as you mentioned, it's kind of captivated the attention of, hockey fans and the wider public across the country. It started a conversation, but to assume that there's been this fundamental shift in hockey culture and how we deal with things like this, I think for people on the ground, they kind of look at that and say, that's kind of a naive notion at this point.
Yeah, interesting, especially when you consider that 4 of the 5 went on to play in the NHL. None of them do now, but they did at the time. Jamie Strachan, thank you so much for joining me here in studio. I know that you've covered this storyline for so many years, so it's nice to get your perspective on such an important day. And I want to take the audience back now live to the London courthouse as we hop on a quick break here. But you can see that there is certainly momentum growing there outside the courthouse. We've been watching as more and more supporters of EM, the complainant in this case, continue to arrive there outside the courthouse, and we are now expecting the judge's decisions in a little less than 20 minutes from now, and you'll see it all live right here on CBC News Network. We are just moments away from hearing the decisions in the Hockey Canada sex assault trial. An Ontario judge is scheduled to begin delivering her rulings in about 15 minutes, and we will take all of it live here, along with a lot of analysis through the day as the 5 former national junior players learn their fate. They face charges tied to an alleged group sexual assault in a player's hotel room in 2018. They have all pleaded not guilty. We know that all 5 have now arrived in that courtroom in London. But obviously, this ruling today comes after 8 weeks of testimony, 2 dismissed juries, and 1 mistrial. There have been so many twists and turns with this case and then this trial. So there's a lot to unpack today here on the program, of course. And Jillian Nachu is joining me next. She's a lawyer who specializes in this area of sexual assault, harassment, and violence. Thank you for being with us on such a important day for the country to learn these decisions.
I'm really happy to be here, and I'm just going to clarify off the bat that I'm not a criminal lawyer. I do a lot of representation of victims of sexual violence, primarily in the civil courts.
Okay, got it. So what do you think will be the impact of a trial like this that has been watched by so many, and then now with this decision day and so many people paying attention to it, what do you think the impact is going to be?
So I think the public impact is really a ton of awareness and a ton of discussions surrounding questions of consent, particularly with young people, and then also questions of sport culture and the environments in which we're raising young people of all genders across this country. So I predict that the impact in terms of public awareness will be far greater than whatever the verdict itself is.
Yeah, I think it's already getting so much public attention. Obviously, we're seeing this growing crowd outside of the courthouse there in London. Obviously, a lot of people are paying attention to it. You mentioned there potentially changes or a lot of focus on consent. Do you think that there might be changes to the law and the ways in which we deal with consent in sexual assault trials?
I think the law itself has already evolved. I think what we're behind on is communicating that to the public, and in particular, teaching it to young people. When I grew up, when I was in high school in the 90s, the slogan was "no means no." And that's actually incorrect. That's not what the law says. Silence does not equal consent. You have to get a yes, either a verbal or a nonverbal affirmative. And I think that that's really poorly misunderstood. I don't anticipate that the law of consent itself will evolve much with this judgment, but I really think that the public's understanding of what consent is, it's time for it to be updated and refreshed.
How about for police forces who investigate these sorts of crimes? What changes? Because we did see that this case was investigated back in 2018. The investigator dismissed the case at that point, and then obviously when it went public in 2022, it was reopened, and now leading us to the day that we're at today. So what changes do you think are possibly coming from police?
Well, hopefully those changes have been in the system and in the works for some time now. I think we're getting a glimpse into the culture of permissiveness that I think also infects sort of hockey culture and the culture around the World Junior players at that time. Shout out to Robin Doolittle of the Globe and Mail for her unfounded investigation, which I think came out in 2018 or 2019, and found that police forces across this country were under-investigating reports of sexual violence, and that the London police, if I recall correctly, was one of the worst offenders. And so I don't think it's any coincidence that EM reported her allegations to this police force, and that their initial investigation was, I would say, woefully deficient.
The other thing that we know about sexual assault trials, when these cases actually do make it to trial, is that conviction rates are very low when you compare it to other serious crimes. Why is that?
I think that there are a number of reasons. First of all, the standard of proof is incredibly high. And what we are getting today is not a finding of guilt or innocence. We're getting a finding of guilt or not guilty, which means that if these players are found not guilty, there wasn't enough evidence to convince the court beyond a reasonable doubt. in cases of sexual violence, they so often happen in circumstances where there's no corroborating evidence. Sometimes it's he said, she said. We hear it described as he said, she said. Really, it's so often it's she said, because it's only the complainant who's called to give testimony and whose credibility is really aggressively challenged, like we saw of EM. In this case, none of the players obviously took the stand. It's an incredibly high bar to challenge. It's one of the reasons that really criminal courts struggle to fairly adjudicate allegations of sexual violence.
Yeah, one of the players did take the stand. Carter Hart did take the stand and testified.
Correct.
No, that's fine.
Yes.
There's so many twisted turns with this storyline. You would be forgiven, absolutely. But one thing that is very clear as we await the judge's decision here in 10 minutes on these rulings is that it is a judge-alone trial. After the twists and the turns and the mistrial and all of that, now it's a judge-alone trial. How do you think that will impact the outcome here?
Impossible to see into the mind of the judge. And of course, we'll never know what either of those juries would have decided. I think one advantage to the Canadian public is that we'll have a very clear set of reasons as to what she was thinking and how she arrived at her decision.
Right, which we would not have gotten from a jury.
Correct.
Oh, yeah, that's a really good point.
Yeah, and so if this is ultimately in part an exercise in education, which is, I know, not the primary purpose of the criminal justice system, but if that's a side benefit, then having a decision, I think, is an additional benefit to sort of parse out the different pieces of evidence that were in front of her.
So then as we get that ruling, what are you going to be looking for to see?
So as a law nerd, I'm looking
That's why we have you on the show, my friend.
I mean, I'm interested to hear what she says about consent. One of the pieces of evidence that was really front and center in this trial was the so-called consent video that was taken after the fact. You know, to me, that's not very persuasive. Consent is supposed to be, well, it's required to be contemporaneous. And a video that's taken after the fact, when the power dynamics surrounding the complainant remain the same, isn't that persuasive to me, so I'm interested to see what the judge thinks about it.
Well, and we know that McLeod is facing that additional charge compared to the other 4.
Yes.
What's the significance of that, and how might that play out today?
Well, so that's an interesting charge. I mean, that obviously arises from the facts before the court this time.
The text, you mean, to the other players?
The text to the other players, and I think it's fairly unusual to have that charge because it's fairly unusual to be able to pinpoint the so-called ringleader in the way that that text enables them to do. So I think in theory, McLeod could be acquitted of the sexual assault, but somehow found party to somebody else's offense if there are acquittals vis-a-vis the other players.
Okay, Jillian, thank you so much for joining us on the program. It's a lot to unpack, but you've helped us a lot.
My pleasure.
Jillian Natchew is a lawyer who practices in the areas of sexual assault, harassment, and violence. And we have a live look at the London courthouse that we've been watching all morning here. In just about 10 minutes' time, the judge in the case is set to start reading her decisions. As I've been saying, 5 former members of the Canadian World Junior Hockey team are facing charges of sexual assault, and the judge's rulings are seen as potential precedent setters. We're watching all of it for you together here on CBC News Network. You're watching CBC Morning Live. We are less than 10 minutes away from hearing the rulings in the Hockey Canada sexual assault trial that has gripped the nation, a case that is certainly getting international attention as well. It has been going on for over 3 years now. 5 former national junior players are accused of sexually assaulting a woman in 2018. The trial itself began in April, focused on the issue of consent during an alleged incident in a hotel room. The complainant herself taking the stand for 9 grueling days under cross-examination from the defense of these 5 players' lawyers as well, former players. And the case has also raised a lot of questions about the justice system's treatment of sexual assault allegations, as well as Hockey Canada's treatment of these sorts of cases as well, and cultural changes within the organization itself. You are looking live right now at the shot of the London courthouse. There's not as many people gathered there as we've been seeing through the day, but that is probably due to the fact that everybody's inside now and the accused are inside, and certainly things are about to get very interesting as we hear the decision now. Linda Ward is joining me to just kind of set the scene a little bit about what we were expecting from the judge.
Yeah, we've been watching that live shot right through the morning. The crowds this morning very sort of full outside there. It's thinned out now. We know that the courtroom is packed. The overflow courtroom is also filling up as well. So a lot of those people who are outside holding those signs in the early morning hours have now moved inside. But when you looked at that crowd earlier today, my goodness, the weight of this decision was evident, right? You look at some of the signs there, justice for survivors, and the system is on trial too. Some of what they had written on those boards, others yelling, "Stay strong," to the defendants as they were walking into the court. So a range of opinions. To understand the weight of today, though, you really have to go back 7 years. Imagine how long this has been going on. June 2018. And just to remind people of the facts of some of what we've learned, Hockey Canada Gala in London, Ontario. The complainant, identified as EM, 20 years old at the time, meets Michael McLeod at a bar. Former World Junior hockey player from the 2018 team. They go to a hotel room. They have consensual sexual activity. And that's when EM says McLeod texted a group chat to invite others to join them. Several others then, she says, joined without consent. Now, she told the court that when she attempted to leave, the player stopped her and convinced her to stay. She says she went on, quote, autopilot as the men demanded sexual acts. And that morning then goes to the police. London police open an investigation. Hockey Canada opened their own internal investigation at that time as well. Both investigations later closed down. April 2022, fast forward, that's when EM sues Hockey Canada, and that's when these allegations really came to light to the public. That's when we all learned about all of this. The story gets out, London police reopen the investigation, and that's when the 5 players were accused of these offenses. Michael McLeod, Carter Hart, Alex Formanton, Dylan Dubé, and Cal Foote, charged with sexual assault. McLeod, additional charge of being party to the offense.
And we are awaiting the judge's rulings here, which are going to get underway in less than 3 minutes now. So obviously things are certainly ramping up. This has been an 8-week trial. Obviously, a lot of people have watched it. EM took the stand herself as well as one of the accused, Carter Hart. But even getting to that point was quite wild. Twists and turns that are very unusual. Remind us of the mistrial and the rest of the twists and turns.
Well, it started in April, and it had a jury back then. We don't have one anymore. There's been a number of missteps along the way. 3 days in, a mistrial declared because there was some communication between the defense and one of the jurors. A second jury chosen just that afternoon, and then EM takes the stand, testifies for 9 days. There's another incident that goes on between the defense and one of the jurors, claiming that they were belittled by the defense counsel. The judge decides, you know what, we're not doing a mistrial. We're not putting her through that again. Let's just go judge alone. So that's where we are today. The trial concluded June 13th. She's had a number of weeks now to put this decision together. So case hinging on consent. We've been talking an awful lot about that. What's she going to decide? Well, we've only got a few more minutes left to go to find out.
Yeah, exactly. Things are certainly ramping up now. Linda, thank you so much for all your coverage this morning, especially around the impact that all of this is going to have on Hockey Canada and organizations like it across this country. And let's take a look back live now at the courthouse there in London, Ontario. As Linda was just mentioning, the crowd here has kind of ebbed and flowed throughout the day here. A lot of people supporting EM have been there, kind of shouting down the 5 accused as they have showed up here at the courthouse to learn their fate as the judge-alone trial is wrapping up today with the judge delivering her decisions in this case. We could get all of the decisions in one vein or another, or there could be a mixed decision as well. A lot to unpack here through the day. Please stay with us on CBC News Network as we continue to learn about this case together and these decisions that have come after 8 weeks of trial, a couple of other incidents along the way. I'm Chris Glover. You're watching.
You are looking live at the courthouse in London, Ontario, where we are bringing you special coverage of a high-profile case that has gripped the nation. Any moment now, the judge in the Hockey Canada sexual assault trial will deliver her rulings. As you can see, there is a lot of interest in this case. And just in the last hour, there were many people gathered both inside and outside the courthouse. We know that 5 players from Canada's 2018 World Junior Hockey team are charged with sexually assaulting a woman in a London hotel room in June of that year. Today's decisions will follow 8 weeks of testimony and evidence that saw numerous twists and turns, including the judge hearing the evidence alone after she discharged 2 juries. The trial is being closely followed because it has put the spotlight on the culture within the sport of hockey, issues of consent, and how the justice system addresses such complaints. Hello, I'm Arthi Pol. Welcome to our special coverage today. I'd like to take a moment also to warn our viewers, much of the evidence and testimony from this trial contains disturbing graphic details connected to allegations of sexual assault. Now, some of it is unavoidable in order for us to provide you with the proper legal context presented in court. As we bring you the latest from the courthouse over the next few hours, you will likely hear some of those graphic details. If you do need any support, there are lots of resources available, and throughout our coverage, we will display organizations that can help you along with their contact information. The crisis resources are for adults and children and are available both locally and nationally. We want to head straight to London, Ontario, in the courthouse there. The CBC's Ali Chiasson leads our in-depth coverage. She's live in London, Ontario. Okay, Ali, set the scene for us.
Well, Arthi, I can tell you that now all 5 of the accused hockey players are inside the courtroom. As they arrived to court today, we saw that familiar scene of them walking past a group of EM supporters. EM is the complainant in this case. They were chanting at them for justice. We also saw a bit of a counter-protest situation unfold. We saw some supporters of what is the so-called Him Too movement, people who rally for falsely accused individuals. At the time, you could hear a distinct volley back and forth. You could hear the EM supporters chanting for justice, and then you could hear the Him Too movement folks chanting, not guilty, not guilty. All of them are here for decision day, and so are we. It's expected to take hours. Justice Maria Carroccia will have to deliver 5 rulings because there are 5 accused hockey players in this case. Along with the rulings, she has to provide the reasonings for all of them. So it will. It's expected to take really all day, and we will be bringing you that coverage.
And as you mentioned, of course, we could be hearing from the courthouse, from the courtroom, any moment in terms of the decision from the judge in this case. Now, you are part of the CBC News team that has been covering this trial over the past few months. Take us through the case.
So, Arthi, this case goes back 7 years to June of 2018 when the former World Junior Hockey team was in London, Ontario, celebrating their gold medal win that year. Some of those hockey players were at Jack's bar, and that is when they encountered for the first time EM, the eventual complainant in this case. We saw EM seemingly hit it off with at least one of the players, Michael McLeod. She agreed to go back to his hotel room where they had consensual sex. It's what happened after that that EM says what was not consensual, including Michael McLeod sending a text message inviting others from the hockey team. We have a screenshot that shows him typing, quote, "Who wants to be in a three-way quick," along with his room number. At one point, there were 10 men in the room. EM said that this surprised her and she felt frightened. She wasn't sure what she could say no to. So she described in her testimony feeling like she just had to go along with the alleged sex acts that took place in that hotel room, which included allegedly oral sex, intercourse, an alleged slap on the rear, and also one of the accused hockey players allegedly doing the splits over her face. Of the 10 hockey players who were inside the room with her at its height, just 5 of them were accused of, or charged, I should say, with sexual assaults. And those are Michael McLeod, Alex Formanton, Carter Hart, Dylan Dubé, and Cal Foote, all of whom have pleaded not guilty to sexual assault. Michael McLeod, though, has an additional charge of being party to an offense, and that, Arthi, pertains to the text message sent to the team group chat.
And as we continue to also follow along live of what is happening, we know that as it stands right now, about 5 minutes ago, the accused men and their families had entered court. Of course, we continue to await the decision from the judge. Ali, what is that expected to hinge on?
So this is a case about what is and what isn't consent. As we heard in EM's testimony, she says she did not consent to the sex acts that were happening in that hotel room with the 5 accused hockey players. But we also heard the defense's counter narrative in which they say that it was EM who initiated the sex and even egged it on, something that she categorically denies. As you can see, there's a lot of he said, she said happening, as is the case with a lot of sex assault cases. But in this one in particular, it's she said, they said.
And now, Ali, you've been at the London courthouse throughout the trial and you've had a chance to speak with people there. Let's talk about the widespread interest in this trial.
Well, Arthi, a lot of people feel that toxic masculinity, toxic hockey culture is also on trial in this case. But we have spoken to legal experts who say that that is actually a lot to put on one case that is 7 years old with a lot of memory gaps and perhaps reasonable doubt creeping into that. Have a listen to a former Crown prosecutor and what they have to say about that.
It's important for people in society to realize, determining whether something is good or bad is not the same as determining whether something is criminal or, not criminal in the sense of an acquittal. Those are very different things. You can have horrible behavior that doesn't, be proven as criminal beyond a reasonable doubt, but it's still horrible behavior. And, if that's where we're at, I think it's important to just separate out, good and bad is not the same as criminal or not criminal.
So last hour, I had a chance to speak with Jesse Roger. They are with ANOVA. It's a sex assault survivors support group. They were among the crowd that was here. And I wanted to get a sense of what they are hoping for, not just in terms of the judge's decision, but beyond this case. Have a listen.
We've seen some pretty frustrating and upsetting moments. We are realizing that rape myths are alive and well in our judicial system, and so I think we have some big, long work to do to address all of that. I'm also looking for justice in different ways. For those of us who work in sexual violence, we know that finding justice is not usually through a verdict or a judgment, because oftentimes those cases, we don't find justice for survivors. So we are looking for it in different ways. We are looking for it in building community and building capacity and making sure that other victims and survivors know that across the country there are sexual assault centers that are ready to take their calls, to support them, to believe them.
So what are the possible outcomes here? Well, it could be anything. We could see all of them found guilty. We could see all of them acquitted. We could see a combination of convictions and acquittals. We won't know until Justice Maria Carroccia delivers her decision this hour. We will be on top of all of it, bringing you the latest in this special. Arti.
Thank you for this, Ali. That is the CBC's Ali Chiasson at the courthouse in London, Ontario. We do continue our coverage, and as Ali mentioned, we are awaiting and tracking for the decision from the justice in London, Ontario. Our reporters on the ground have said that it is a packed courtroom and there is an overflow room as well. We are getting live reporting from inside on what is happening, and we'll bring you the most up-to-date information. We do, of course, also have team coverage on the rulings throughout the day, and part of that is the CBC's Hilary Johnstone. She's in our newsroom. She's standing by for any updates. So, Hilary, tell us a little bit more about what you're watching for this hour.
Well, Arthi, like you're saying just now, we do have a team of people who are on the ground, reporters who are inside that courtroom right now. And we are going to be working throughout the day from here in the newsroom to bring you some of that information that is being relayed to us from our colleagues who are inside that courtroom right now. And to that end, we do have an update that we can bring you, as you have been sharing with us. Of course, we do know that those accused men and their families have been making their way into the courtroom in the past couple of minutes. We know that this particular courtroom, it is on the 14th floor of that courthouse in London, Ontario. And what we are being told by our colleagues who are there is that outside that courtroom, there is a packed lineup of media, but also members of the public, because after the accused and their families are led into that courtroom, we then know that members of the media will be allowed to enter and remaining space for any members of the public who are there and who may wish to be inside the courtroom. And we know from our colleagues who are there right now that at least two of the accused, have shaken hands with a member of the public who describes himself as a men's rights advocate who has been there every single day of the trial. Those two accused shook his hand as they were going in. We also know that the accused were given green cue cards from courtroom staff to identify them as being able to enter that courtroom first. So those are some of the most recent updates that we have. But like you say, along with all of our colleagues on the ground, including Ali, who we just heard from, we will be bringing you information throughout the day from here in our newsroom that has been relayed to us from our colleagues who are inside that courtroom in London, Ontario.
Thanks for this, Hilary. That is the CBC's Hilary Johnstone. As you look at that live shot, of course, it's important to note that a matter of an hour ago, there were many people who had gathered there, those who were supporting the complainant and those who also support the accused in this particular case. It is a case that has really mobilized many members of that community and really across the country when we're talking about perhaps systemic issues with Hockey Canada that were brought to light as a result of this case. So for more now, I do want to turn to Gillian Nachu, who will be with me throughout the next hour. She's a lawyer who has represented victims of sexual violence, primarily in the civil courts. Again, just to set the stage here, we've got 5 individuals who are facing charges of sexual assault. Another one of those individuals facing a charge of being a party to the offense. Right now, there's a lot being considered, or has been considered over the past several weeks by the justice. What is she looking at here?
She'll be looking at the minutiae of the evidence before her, and she'll be applying the law as it's already understood in Canada. There's been an enormous volume of law from the Supreme Court in recent decades that sort of directs judges across the country about the things that they can and cannot consider when presiding over a trial where there are allegations of sexual assault. So I know that the public has been wrapped as the evidence came out over the course of those 8 weeks, and I expect her to be going through that in a very methodical way and ultimately applying those facts to the law.
In the course of the 8 weeks of this trial as well, there were many developments in terms of just the procedural nature of it. Can you walk us through what we saw from start and where we are now that we are waiting for the decision from a single judge, not a jury?
Well, as you know, there was not one but two juries dismissed in the course of this trial. One at the very beginning, they impaneled a new jury. They started the trial afresh. I think they only lost a day and a half of evidence. And then the second jury was dismissed as a result of application for mistrial brought on behalf of one of the accused several weeks into the trial, and at which point it was prejudicial to all involved to start the trial again. And so the judge dismissed the jury, and she'll be deciding the case alone.
You know, one of the sort of notes here that's been reported that it can be a case of he said, she said, and many are saying because in this case there are 5 accused that it's she said, they said, because we do know that it is the accounts of multiple individuals. But I did hear you say that you want to clarify that. What's important to note there?
I don't think there's a they said. Of the 5 accused, only one took the stand. So I think that the singular does appropriately apply. Ian was on the stand for, I believe it was 8 days between direct testimony.
I think it was 9.
9. And so her evidence was scrutinized, doesn't meet the moment in terms of how to describe the degree to which her evidence was scrutinized and tested and retested. Of the 5 players facing allegations against them, only one of them took the stand, so we only know what he said. When a lawyer puts a proposition or a suggestion to a witness in cross-examination, that's not evidence. That's just something a lawyer has said. And so I think it's important to be very clear that there's no they said here, that only one of the 5 accused took the stand, and that's very common in criminal cases of sexual violence. So often it's only the complainant who will testify, and the accused has the right to remain silent under the Canadian Charter of Rights and Freedoms, and we saw 4 of the 5 exercise that in this case.
You know, again, a reminder for our viewers as we want to take you to London, Ontario. We have a shot of the courthouse there as well to share with you. We know that right now we are waiting for the decision from the justice who was overseeing this trial, this sexual assault trial in London, Ontario, stemming from a sexual assault allegation from June of 2018. The complainant is known as E.M. throughout this, and as we heard also from Jillian, she was the one to take the stand. There was one player who took the stand, but it was the complainant, known as E.M., who was in that witness box for more than a week in terms of delivering testimony there. Jillian, I also wanted to ask you, you know, in terms of what is known as a decision in this case, because it is not a jury, so it's not a verdict. Technically speaking, it will be a decision or a ruling from the justice here. It is not guilty or innocent. It is guilty or not guilty. Let's talk about that for a moment.
Correct. There's no such thing as a finding of innocence in criminal laws in Canada. So either there's enough evidence before this judge to find guilt, or there isn't, in which case there's not guilt, essentially. And that's a recognition of the fact that in order to find guilt, you have to do it beyond a reasonable doubt, which is a very high standard. It's not intended, it doesn't pretend to be a finding of truth. This is not about which side the judge believes more. It's really about, has the Crown overcome that very high standard of beyond a reasonable doubt?
And to that end, I also wanted to ask you one final question as we continue with our coverage, and that is, this case has sparked a lot of interest, in particular because there has been somewhat an evolution in the way that sexual assault trials and allegations have been handled. How do you find the progression has gone, and this interest, is that in part because a lot more change is perhaps necessary?
I think a lot more public awareness is necessary. I think that the change needs to start upstream with the way that police forces investigate and handle these allegations. And I think that we've already seen some of that change hopefully start to occur. There's been a lot of talk about hockey culture and sport culture. I do think some of the change needs to start from there. So I think that it's to some extent public awareness. I think sometimes it's judicial awareness. The criminal system was built by men for men. I know that's going to be an incredibly inflammatory statement to many of your viewers, but that's a historically factual observation. Up until 1981 or 1982, doubt towards the complainant was baked into the system. You couldn't bring forward an allegation of sexual assault if you didn't have somebody to corroborate it. And it was the only crime in the criminal code that required a second witness or a second form of corroborative evidence, where they said the word of the woman was not enough. And so in the 4 decades since, we've seen courts and judges try and unpack these rape myths that are very much baked into the system. And there has been progress, but it's a continual process of evolution. And you heard in the questions from many of the lawyers who were cross-examining EM over the course of those 9 days, some of the hangover of those myths. Questions about why she did things, why she didn't things, why she reacted the way she did. Because I think that we as a society still largely believe that if you were really assaulted, you would act in a particular way. But what social science and neuroscience tells us is that that none of that is based in fact or data. Our brains react in very different ways than the law once told us that they expected us to. So
important context to keep as we continue our special coverage. Jillian, I will, of course, continue to check in with you throughout the hours of special coverage that we are going to be bringing our viewers. Again, you're looking at the courthouse in London, Ontario, where we are expecting the judge in a sexual assault trial to deliver her decision in, again, the World Junior Hockey Sexual Assault Trial. It took place over a course of 8 weeks, the trial did, but we know that the alleged incident took place back in June of 2018 in London, Ontario. 5 men stand accused, and there's one complainant known as EM. We did hear Jillian touch on hockey culture. So for more on that, I want to bring in the CBC's Jamie Strachan and how today's decision could affect Hockey Canada. He has been closely following this trial. Hello, Jamie. You're joining us from Toronto. So Hockey Canada has faced a reckoning since EM's lawsuit became public. What impact could today's rulings have on the organization?
Well, I think, Arthur, you've already seen an impact on Hockey Canada itself. I mean, this case brought to light that for years, the hundreds of dollars that parents who have kids who are playing hockey in this country pay in fees towards Hockey Canada, some of that money was being, siphoned away to a fund that was paying off some of these sexual assault, sexual misconduct complaints. That's changed. You saw Hockey Canada, the board at that time, try to kind of weather this storm and say, listen, we have this under control. That didn't work. That board has been replaced. And at the Hockey Canada level, there has been some changes. And just to give you some sense of what I mean by that, Hockey Canada is a national sport organization. It has governance over elite hockey in this country, people representing Canada on an international stage. So at that level where they exercise some control, there have been changes. If you're going to play for a World Junior team, going forward, you are receiving some mandatory training around consent, around sexual behavior, things like that. That has been implemented. But in terms of what Hockey Canada or any national sport organization can do in this country, their reach is really quite limited. I mean, they can put in rules, they can set up complaint procedures, but it's really up to local organizations on the ground to implement training modules for parents, for players, for coaches. Here in Toronto, you have the Greater Toronto Hockey League, the biggest youth hockey league in the entire world, where many NHLers play when they're kids. It's up to organizations like that to put things in place. And I can tell you, it's been very piecemeal across the country. Some organizations are doing it. Some have taken a concerted effort to make this part of being a player in their organization, and some haven't. But I think, Arthur, a key thing in all of this is how do we train elite hockey players in this country? Where do they come from? What kind of culture do they come from? And when you look at boys, teenagers that are playing on a World Junior team in Canada, representing Canada, these are the best of the best. It's the 20-odd best 17, 18-year-old kids that this country has to offer. How did they get there? Well, the way that we develop professional hockey players is much different than the three other major sports, baseball, football, and basketball do. You know, they're drafted into the Canadian Hockey League, so into the OHL, into the Western Hockey League, into the Quebec Junior Hockey League when they're 15 or 16 years old. And then they go off, and if you live in a city like Toronto, you may go off to a smaller center, you know, like a North Bay or something like that. How much information around consent has been part of that player's training? In some cases, a little bit. In some cases, not a lot. So to say that there's been a fundamental shift in hockey culture in Canada, I think is naive, especially you know, if you're on the ground participating in it. I've had two boys, you know, come up through the GTHL. I think it's naive to say there's been a fundamental shift in hockey culture. I think there's steps being taken on a piecemeal basis by different organizations, some, you know, doing a very good job, some not doing anything at all. But I think Hockey Canada, in the areas that they've had control, have taken steps to, you know, to implement more training around consent. And I think that all stemmed from this case.
That is the CBC's Jamie Strachan in Toronto. Jamie, I am going to check back with you throughout our special coverage. We do want to bring our viewers an update to do with the court proceedings. You're looking again at the courthouse in London, Ontario. I want to bring in the CBC's Hilary Johnstone in our newsroom because court has been delayed. Hilary, what do we know?
That's right, Arthi. So court has been delayed. It was supposed to start at 10 a.m. That was when we were expecting that the judge was going to start to get into her reasoning, into her decision. We are now hearing from our reporters who are inside that courtroom, in particular this information coming to us from our colleague Kate Dubinsky, that because of the level of interest in this case, just how many people are wanting to be inside right now, that they are in the midst of trying to find a second overflow room for members of the media. Because of this, there is now a delay. So I will direct our viewers to our website, whether that is through a browser or web page, or you're looking at this on your phone. You will find a live blog. You can see it right now. That is the most recent update showing you from our colleague Kate Dubinsky that court has been delayed. And I would encourage people to follow along with that. That is where all of that information is going to be from our reporters who are inside that courtroom. And what we have here from our colleague Kate is that they are right now trying to find a second overflow room to set up in order for members of the public and members of the media who wish to be there so that they can be there. They say that that main courtroom currently has 50 people inside. We assume that is mostly family members of the accused. That was who was going to be allowed into that main courtroom first. Kate is also saying that by her account, there were about 15 members of the media that are in that main courtroom. Then there is an overflow room, and currently it is at capacity. 150 people are already inside that first overflow room, which is why we now have this delay as they go and find a second room so they can have a second overflow room. So once again, for viewers at home who are wanting to follow along, wanting to have that information as quickly as possible from our colleagues inside that courtroom, inside the overflow rooms, we do direct you to our live blog on our website. You can find that on a browser. You can find that on our mobile app. But just once again, Arthi, we are hearing now that court is delayed because there are so many people.
And actually, Hilary, it looks like court is now underway. Apologies. As we've mentioned to our viewers, things are moving quite fast. And what we understand is the justice has started to read her decision. Reading reasons in writing will be made public after she has presented them in court. Of course, we will bring all of that to you once it becomes available to the public. As we await for more details on that, I do want to bring in Rob Talek. He is the head of the Sexual Abuse Department at Beckett Personal Injury Lawyers. And importantly, he represented EM in her civil lawsuit against Hockey Canada. He's not involved in the case in London, and he no longer represents her. Rob, thank you for joining us today.
Good morning, Arthi.
First, I want your observations as you've been, of course, following this trial. What have you noticed in terms of your former client? How has EM changed over the course of when you were representing her to how you're viewing her now in this trial?
So she's definitely grown. I mean, I'm obviously observing the now through the media reporting, but you know, I did get to know her back years ago when she started this journey, and I describe her as a very timid, quiet woman. I've called her a church mouse before, in the sense of very quiet and not the person who you would expect to have the strength to go the distance as she has and as we see here today.
Talk to us a little bit about the level of preparation that EM might have had to go through to come forward about this alleged sexual assault.
Well, I think, you know, what you're trying to do with survivors is, obviously it's a subject that the body and the trauma response is suppressing and burying, and it is difficult for them to be able to articulate. So that's a slow process. You know, I remind all listeners that the law in Canada is there is no timeline to come forward with a sexual assault complaint because of that biological and psychological mechanism of just, you know, not wanting to deal with it, not being able to articulate it. So she's gone through that on a rather quick timeline compared to some folks that take decades.
In part of what she has said before, and you've relayed through other interviews, is that she has said that some individuals would try to blame her, and that, you know, we worship hockey players, they can do no wrong. That is something that she is saying, and in her conversations with you, I'm wondering if we can speak broadly about how challenging that may be then for victims or survivors of alleged sexual assault to share their story.
Yeah, I mentioned it just earlier today on another interview that the quickest way to shut down a survivor or someone coming forward with complaints of sexual assault or abuse is to suggest blame, is to suggest, you know, to talk about their ownership or their responsibility for it. So, you know, I think the best response for someone that encounters someone that's starting to open about that is just listen. Try not to be judgmental. I mean, as we see, there's processes and arbitrations and adjudications that will really get into the details as we head down the road. But I think in the beginning, you have to listen and be supportive. And you know, it is very difficult for people to communicate this. And I think that we've seen the scrutiny that she's had to undergo, 9 days of testimony, 7 days of cross-examination. And one of the messages I want to get out there is, I hope for any survivor or anyone out there, this process does not deter them from coming forward. I mean, the criminal justice system's not perfect, but it's grown by leaps and bounds in this subject in the last few years. And decades ago, this type of prosecution wouldn't even be contemplated. So I think the fact, regardless of the outcome today, the fact that it was prosecuted and went to trial and everyone sat up and paid attention is a sure sign of progress.
And finally, I wanted to also ask you, in terms of what you've seen of people coming forward to you following the publication of what we're seeing with EM, what have you experienced?
I've heard from a lot of women that have had similar circumstances in hockey, with hockey players. And I am just, you know, look, I've done this 22 years all across Canada in most provinces, and I've never seen in a genre the emphasis on group sex, of sharing, of this mechanism that we're seeing here today in this case. And you know, there's not a lot of disagreement on what unfolded in that hotel room. I think the disagreement is on the issue of consent and perception and permission and all that. But there really needs to continue to be a reckoning and a national conversation about what are we doing with young men that get into junior hockey, since this phenomenon is so specific to that genre.
Rob, I want to thank you for your time. That is Rob Talek. He is the head of sexual abuse department at Beckett Personal Injury Lawyers, and he represented EM in her civil lawsuit against Hockey Canada. We continue to follow this breaking news. Of course, you're looking at the courthouse in London, Ontario, and the judge in this sexual assault trial of 5 former World Junior hockey players has begun to read her decision. And we are getting reporting from our Katie Nicholson inside that from her decision, she's saying, I do not find the evidence of EM credible or reliable. The Crown did not meet onus on any of the accounts before me. I want to bring in the CBC's Hilary Johnstone in our newsroom, who's following along with me as we're getting this live information from our colleagues who are inside the courtroom. What additional information are we learning, Hilary?
Well, Arthi, I think it is worth repeating what you just read out. And again, this information is coming from our colleague Katie Nicholson, who says that Justice Maria Carroccia, as she is reading her decision, has said, quote, "I do not find the evidence of EM credible or reliable. Crown did not meet onus on any of the accounts before me." Remember here that EM is the complainant. That is how she is referred to because of that standard publication ban. Once again, Justice Maria Carroccia, as part of her decision, has said in court in the last few moments, "I do not find the evidence of EM credible or reliable. The Crown did not meet the onus on any of the accounts before me, on any of the counts before me." There is a correction here, on any of the counts before me. Of course, remember here that those 5 hockey players, former World Junior hockey players, were all facing 1 count of sexual assault each. Michael McLeod was facing an additional charge of being party to an offense for his alleged role in facilitating the assaults. There is a final note here as well. We have not officially said, the judge has not officially said that they are acquitted, but at this point, Arthi, the language that is being used as she is reading out that decision is that the judge does not find the evidence of EM, who, remember, is the complainant here, credible or reliable. The Crown did not meet the onus on any of the counts before me. So that is something that we are going to continue to monitor. This is happening as we speak. We know that the judge will not only deliver her decision, but also her reasoning behind that decision. And this is something that will be unique because this is a judge-alone trial. Remember that in Canada, juries are forbidden from discussing anything that went into their deliberations. Because this switched midstream to a judge-only trial, we will be getting the judge's reasoning behind her decision, her legal reasoning behind that decision.
Thank you for this, Hillary. That is the CBC's Hillary Johnstone. Okay, we do want to continue with that breaking news that we are getting from that London, Ontario courtroom, where the justice is saying, "I do not find the evidence of EM, who is the complainant, credible or reliable. The Crown," she says, "did not meet onus on any of the counts before me." So she is beginning to read her decision in this sexual assault trial. I do want to bring in Daphne Gilbert. Daphne Gilbert is a law professor at the University of Ottawa. And what we're understanding from the language that is being used is that while we haven't officially heard of an acquittal here, the language is suggesting that the evidence brought forward was not credible in terms of EM's accounts of what occurred. So, Daphne, I would like for you to weigh in on what we've heard so far.
Yeah, so I can't imagine that language being compatible with a guilty finding on any of the charges. It sounds as if she's heading towards an acquittal. And I guess what we will hopefully next find out is what it was about EM's evidence that she did not find credible. Was it the fact that so much time had passed? Was it the fact that there were, conflicting statements from prior times when she had, given statements that undermined her testimony in court? Or was it the strength of the cross-examination? Was she impressed with what the defense lawyers were able to pull out from her? I'm interested in what it was about her credibility that the judge found probably.
I'm taking a look here at some more reporting that we're getting from inside the courtroom, and I do want to relay that to you, Daphne, so we can further discuss it. What I understand is the justice here has also said in her decision, as she continues to read that out in the London courthouse, that EM alleges that she was sexually assaulted by each of the accused, and that she felt like she did not have a choice to engage in the group sexual activity due to fear, intoxication, or a combination of both. And Carroccia said the defense contended at trial that EM was a willing participant and initiated much of the sexual activity. So that is some more of what we're learning that the justice is reading in this particular decision. We know that it's not just the 5 charges of sexual assault. There is also an additional charge here, and that is for one of the accused of being party to the offense. So when you have the language that we're seeing here that could potentially lead to an acquittal, What is the likelihood of something like accused of being party to the offense being something that is still being considered?
If there were no sexual assaults, then there would be no one who would be party to a sexual assault. So it seems to me that she's heading towards an acquittal on all of the charges. And I think it's important to remember that just because she says that she, doesn't find EM credible, it doesn't mean that she is saying that EM lied in court or that the men all told the truth. I mean, beyond a reasonable doubt is a really high standard of proof. And, if all it means is that on the balance, when she looked at the evidence, she was not convinced beyond a reasonable doubt that a sexual assault occurred. But it could be that she still found aspects of EM's testimony compelling, or that it was, there were parts of it that she believed to be true. It just, on balance, was not enough to overcome that really high burden of proof.
Daphne, I want to thank you. And of course, you're going to stick around because we will continue to have discussions with you throughout our special coverage. Daphne Gilbert is a law professor at the University of Ottawa. Now, outside the courthouse, we have our Ali Chiasson in London, Ontario. She continues to follow the live reporting that is coming from inside the courtroom. We're understanding from our reporters that there have been gasps and tears within the courtroom as the justice is reading her decision. Ali.
That's absolutely right, Arthi. Audible gasps and family members of the accused hockey players embracing each other and crying when Justice Maria Carroccia said, "I conclude that the Crown did not meet its onus on any of the counts before me." Here's another quote. "I do not find the evidence of EM to be credible or reliable." While this is not an official ruling, it does sound like potentially acquittals for the 5 accused hockey players, but we will be covering it moment by moment. Even as we speak, I'm getting more information from our reporters inside the courtroom. Justice Maria Carroccia says that this was based on evidence, which included testimony and arguments put before her. EM's own testimony pertaining to that. Justice Carroccia says, quote, "In this case, I have found actual consent not validated by fear." And you'll remember that EM was testifying that she felt she was not able to consent. She was not in her right mind. She says because she was drunk. She also said that she was acting out of fear. But as we just heard Justice Maria Carroccia saying that she found that actual consent occurred according to how she heard it play out in the court. So let's see, with respect to the charges before this court, I have found that I cannot rely upon the evidence of EM. And then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me. Specific name call-outs we heard from the reporters inside that Carter Hart's mother was crying. The entire family that's been showing up day after day for Michael McLeod also in tears, and also reports of the accused hockey player's shoulders dropping. More news to come as the ruling unfolds. It's going to take hours. I know a lot of this, or this sounds like a lot of information coming at us fast, but reasonings have to be given for each of the 5 accused pertaining to Justice Carroccia's rulings on this. So it's expected to take the rest of the day, but we'll be on top of all of it for you.
Thanks for this, Ali. That is Ali Chiasson reporting. I do want to bring back Jillian Nachu. She's a lawyer who's represented those who have been victims of sexual assault, primarily in the civil courts. Okay, so let's talk about what we are hearing that is coming out of our reporters who are live in the courtroom. I want to go through some of that again with our viewers as we were just listening into Ali Chiasson. She said that there were audible sighs of relief when the justice said that she didn't find EM, the complainant in this, credible or reliable. McLeod, one of the individuals who is an accused, that his parents who've been through the trial and the entire trial were crying. Another parent also in tears as they are hearing that. The judge read her words that some of the men turned around and looked at their family members in order, of course, to look for that support, of course, that they have been receiving during the the course of this trial. But essentially, what I wanted to hone in with you, Jillian, here is that the justice is saying that the onus of the Crown was not fulfilled here.
Correct.
Tell me a little bit more about that.
The onus is on the Crown, acting on behalf of the public to prove their case. So you've heard a lot of talk about proof beyond a reasonable doubt, that's the standard that the court has to use. So what she's saying is that the Crown didn't clear that high bar. They didn't meet their onus. The Crown, in simple words, hasn't proved their case, and there will be acquittals.
In terms of that and what we've heard so far, where, we're interpreting this language here. And when it's not credible, not reliable, is there any sort of surprise in terms of what we've heard so far? We are going to be getting a lot of detailed reasoning from the justice. That is all part of that.
You always have to wait to hear what the decision maker says about whether they find the complainant credible or not. Cynically, having done this work for more than 2 decades, I'm never surprised when there's an acquittal in a criminal trial. It's an incredibly high burden, and the rules of evidence are, weighted in favor of the accused, and that is because they are facing, potential imprisonment. So the system is built in a particular way, it works in a particular way, and more often than not, we see acquittals. We all know the statistics. Obviously here, the judge did not find EM to be credible. I imagine that she will explain that finding in greater detail as she continues to read her reasons, but there's not a lot of detective work to be done at this point in time to anticipate what the verdicts will be.
Now, in terms of the reasoning, it is important here, and this is different because it is a judge-only decision. So let's talk a little bit about how important it is that everything is sort of read through, and it has to be incredibly detailed.
Correct. Yes. Judges' decision-making is open to scrutiny from higher courts, but you don't get that from a jury. A jury is really just asked straightforward yes or no questions, and they come back and deliver answers to those questions. So if there was still a jury impaneled in this case, it would have opened with the jury reading its verdict, and we would never know what the 12 individual jurors were thinking and what their particular reasons were for either finding guilt or not guilt. Here we will get a look inside the judge's mind, really, and what she thought of each piece of evidence. And that's what I understand she'll be doing for the next possibly several hours as she reads out all the pages of her decision.
We were talking about how there's the sexual assault charges, but then there's also the party to offense charge. And I was discussing that also with Daphne Gilbert, who's a law professor. In terms of that specifically, there needs to be a separate conviction for that to even be something to consider.
Correct. It would be hard to be party to an offense if the offense itself didn't happen.
Right.
You can't abet a crime that never occurred. So I know that I'm sort of going further than probably the CBC or its journalists feel comfortable doing right now, but I anticipate strongly that there's going to be acquittals on all accounts. I don't see how it could be otherwise.
Also there, of course, as part of this is there are processes for appealing a decision. And part of that, if it's the Crown or if it is the, lawyers for the accused, there's a 30-day deadline. Let's talk a little bit about that process and what it might look like, because it's not an easy process to walk through if you do want to call into question the legal decisioning of the justice.
Correct. It's an extremely challenging process. At this point, it would be, I think, the Crown who would be seeking an appeal within 30 days. They would need to point to some kind of error of law in the judge's reasoning. So if the judge said, I don't believe EM because women are inherently untrustworthy, then I anticipate the Crown would appeal on that basis. But I want to be very clear, I also don't anticipate that the judge will say that. So there would have to be some sort of erroneous and impermissible application of the law to the facts.
I want to remind our viewers, of course, we are continuing our special coverage of the judge's decision in the trial of 5 former World Junior hockey players who were on trial for sexual assault. And there was a complainant. EM is as she was known. What we've heard so far from the justice is that she does not believe that there was a credibility in the counts when it comes to what we heard from the complainant in this specific case. Again, I want to read just in part some of the decision from the judge that we have heard so far. I continue to wait for more information from our reporters who are live inside that courtroom. And at this stage, the justice has said that EM alleges that she was sexually assaulted by each of the accused. She felt like she did not have a choice to engage in the group sexual activity due to fear, intoxication, or a combination of both. And the justice went on to say that the defense contended at the trial that EM was a willing participant and initiated much of the sexual activity. Important to note here that the justice started with saying, "I do not find the evidence of EM credible or reliable. Crown did not meet onus on any of the counts before me." We are continuing our special coverage on this. And of course, also a reminder for our viewers that much of what we may discuss here will be graphic in nature. So please do seek support and resources if they are required. I do want to go back to the CBC's Hilary Johnstone in our newsroom. What more can you tell us about what we know coming from that decision?
Well, we do have a few more updates here coming from one of our colleagues, Kate Dubinsky, who is inside, who is there. All of this on our live blog on our website as well. Right now, Justice Maria Carroccia is going through some of her reasoning. And as we have been saying, she has already said, it's already been read out, that she did not find EM, the complainant here, to be credible or reliable. According to our colleagues who are there and are listening to this, the judge is now pointing out various inconsistencies as she saw them in EM's evidence as she goes. So as the judge is reading through her reasoning, is pointing out some of those inconsistencies, including the fact that the judge points out that EM, the complainant, had told police that she fell outside the bar's bathroom, that Jack's Bar, back in June of 2018, when she alleged that all of this had happened. She had told police that she fell outside the bar's bathroom when she was alone. She then told Hockey Canada investigators she fell while McLeod was there, one of the accused. So these little inconsistencies that the judge is currently pointing out as she's going along. Also going through evidence that EM gave about what she said happened at Jack's Bar in London, Ontario in June of 2018 when she first encountered those hockey players. The judge is pointing out that evidence that she gave evidence, including the fact that she had kissed one of the accused, Michael McLeod, and said that she had seen a bouncer that she knew from high school. The judge pointing out in her reasoning that that was something that she then did not mention to police when making her initial police report. So all of this, of course, coming back to that information from a few minutes ago where the judge came out and said that she did not find EM to be credible or reliable and that the Crown did not prove its case. And just one more update. I know we have gone through some of these, but worth repeating a little bit of the scene inside that courtroom when the judge started to read some of this out. We know that there was an audible sigh of relief when the judge said that she did not find EM to be credible. We know that some of the players' families who have been there from the beginning, in this case, Michael McLeod, whose mother and father were there, who have sat there through the entire trial, according to Kate Dubinsky, our colleague, saying that they were both crying, as was one of McLeod's brothers. We also know that Carter Hart's mother was there and was crying as the judge started to read some of the decisions here, or some of the reasoning into her decision here. So those are the updates that we have at this point for you, Arthi. And like we say, we do have this information on a live blog on our website with our colleagues who are inside that courtroom. They're able to relay us information in real time about what is happening.
Thanks for this, Hilary. That's the CBC's Hilary Johnstone. Okay, so for more of our special coverage now, I do want to turn to Greg Gilhooly. He's a sexual assault survivor and a former hockey player. He's also the author of the book I Am Nobody, which details the sexual abuse he suffered as a hockey player at the hands of convicted hockey coach Graham James. Thank you for making time for us today.
Thanks for having me on today.
You know, we are, of course, learning a lot more about the decision from the justice as she's delivering it as we speak right now, pointing to what she calls inconsistencies in the evidence that was brought forward by the legal representation for EM, the complainant of this. In a broader sense, Greg, though, I'm hoping we can talk a little bit about how difficult it is, how challenging it is to bring forth these cases of alleged sexual assault.
Well, it's incredibly difficult. Look, I'm a lawyer too, right? And I didn't come forward for decades. And one of the things that held me back was I knew what the process is. The legal process doesn't get at any truth. The only people who know what happened were the people in the room. The legal process is a system that kicks out a legal decision and nothing more. That's it. And there are rules in place, very good rules put in place for very good reasons to ensure that the state doesn't step in and incarcerate or sanction somebody without having absolute bulletproof, beyond a reasonable doubt evidence of the committal of a crime. So it's an incredibly difficult process. And for a victim to subject themselves into that system is incredibly difficult because the cross-examination only goes one way. There were inconsistencies across the board with respect to evidence, but boy, it sure focused on the story told by the alleged victim, right? So it's an incredibly difficult process.
In a broader sense, too, we know that this case really sparked a wider discussion about culture in hockey in Canada. Tell us a little bit from your experience about that and what you've seen from your situation to now, how you've seen perhaps conversations change.
Sure. Hockey reflects society. These issues happen across the board. It's just that we tend to focus on them in the world of sport because the concepts are heightened. We have heroes, and so with heroes comes power. And whenever you have power imbalance, you have the ability or situation where power can be exercised improperly, unfairly, to take advantage of those without power. And that's what happens. People are put up on pedestals, especially in the sporting world, especially with these hockey players. And they probably lived in an environment for a long time where they'd never been told no. And again, whatever happened that night, only the people in the room know. But what is absolutely certain is that there was a fundamental lack of character in that room. Nobody stepped up and said, look, just because we can doesn't mean we should. And that's very different from the legal process. And so unfortunately in the hockey world, there's not enough consideration of the concept of just because we can doesn't mean we should. There's a responsibility to be a good character, to be a good actor, to be a leader, to set an example, especially when you're put up on that pedestal. What better chance to push society forward than to be that good actor, that good character?
And also, in terms of the changes that we could potentially anticipate, do you think that something may be accelerated now that there has been so much awareness during the course of not just this trial, but it coming to light, this situation coming to light?
Culturally, things are getting better, and they're going to keep getting better because of the highlight put on these things. But as your commentators have been saying all day long, there's a lot more work to do. My fear is that coming out of this decision, victims will be less likely to come forward knowing the grotesque process that they face. And I use the word grotesque not objectively, subjectively from the position of someone coming forward. It's a very difficult, incredibly difficult process. And the process has to exist because we don't want the state going around and putting people in jail who don't belong in jail. There should be, rightfully be, that incredibly difficult standard to prove where the state can come in and send someone to jail. The problem is, when you focus on that aspect of it, you're not focusing on what's good for an alleged victim. And so if you're a victim out there, whatever happens in this court system doesn't change that or not. And that's why I think we all should take a step back and not cheer for sides during these processes. We don't know what happened. We have no idea what happened. All we're doing is watching a legal process play out pursuant to legal rules. Today is not any assertion or definition of truth. It is a legal result.
I want to thank you for your time on this, Greg. That is Greg Gilhooly. He is a sexual assault survivor and a former hockey player. A reminder for our viewers, we are bringing you special coverage of the trial, of the decision being read by the justice in London, Ontario, of a sexual assault trial involving 5 former World Junior hockey players and 1 complainant known as EM. It is an incident, an alleged incident that dates back to June of 2018. There have been many developments over the course of the past few years leading up to an 8-week trial earlier on this year, and today's decision being read by a judge only after an earlier mistrial and the dismissal of the jury, a second jury, earlier on during the course of the trial. We are getting some more updates as well from inside the courtroom. We understand that the justice is speaking about texts EM from a friend who had been with her at Jack's bar that night. This is all part of the decision that she is sharing with the court. I want to bring in the CBC's Hilary Johnstone, who's in our newsroom, and she's reading those updates that we are getting from our reporters inside the court.
That's right, Arthur. These up-to-the-minute updates that you can also find on our website and on our app as well, our news app. And like you have been saying, this is unique that we're even getting this sort of insight, this reasoning. We're only getting this because this did become a judge-only trial. The most recent updates coming from our colleagues who are inside that courtroom and are listening as Justice Maria Carroccia goes through her reasoning. She is speaking about those texts that EM, the complainant, had sent to a friend who had been with her at that bar in London, Ontario in June of 2018, the bar called Jack's. Those texts asked EM if she needed help getting away from McLeod. In this case, of course, that would be Michael McLeod, who is one of the accused. If she needed help getting away from McLeod, but EM said she was fine. This was in response to a text that had been sent to her by a friend. She also didn't respond to 3 more Facebook messages from that same friend or a phone call. The next day, and this is the judge reading this out as part of her reasoning here, the next day EM told the same friend that she hadn't been, quote, lit enough that night. That is what Justice Maria Carroccia is reading from her decision. Another update for you here as we're listening to the judge reading her decision here. Carroccia, the judge, has also gone through EM's version of what happened in the Delta hotel room after the bar. And remember here what had been alleged, that this had started at Jack's bar. There had been an encounter when the complainant had met Michael McLeod. They go back to that hotel room, the Delta London Armories Hotel, where the alleged assault was said to then take place after the accused, or where the accused had been staying. The judge, as part of her reasoning here, is recounting defense lawyers pressing the complainant multiple times during cross-examination about whether she was the one who suggested having a, quote, wild night, and asked McLeod to invite his teammates back to that hotel room, back to room 209. The judge says that EM told the court she didn't think that was something she would say. EM next remembered McLeod leaving the room and 2 other men coming in. Quote, this shocked her and she was surprised. So Carroccia here reciting back some of EM's testimony. So all of these updates, Arthi, these up-to-the-minute updates coming from our colleagues who are inside that courtroom, who are listening to this. As we have been saying, it could take a significant amount of time for the judge to get through her reasoning here, her legal reasoning. But the key part here, of course, we know from about half an hour ago, hearing there that she did not find EM's evidence to be credible or reliable. We are now getting those updates as to her reasoning for how she is coming to some of this, but still not an official decision yet. That is something that we still wait for.
Okay, thanks for those updates, Hilary. That is the CBC's Hilary Johnstone. I do want to bring back to our coverage Gillian Nachu. She is a lawyer who's represented victims of sexual violence primarily in the civil courts. Okay, so some of the updates there that we are receiving from inside the courtroom, the justice delivering the reasons behind her decision. A reminder for our viewers, the context of all of this. At the outset, the justice said here, I do not find the evidence of EM credible or reliable. EM is the complainant here, and the Crown did not meet onus on any of the counts before me. There are 5 charges of sexual assault against those 5 players, and also a secondary charge of party to an offense. Now, while we have not heard specifically of an acquittal, the language suggests that that could be the direction that the justice is heading in. We did just also get some updated information there from inside the courtroom as the justice is reading the reasons for her decision, talking about EM's version of what happened in the Delta hotel room after the bar where the accused was staying. The justice recounts the defense lawyers pressing EM multiple times during the cross-examination about that. What do you make of what we're hearing from the courtroom right now, the reasons behind the justice's decision?
Her decision is going to rise and fall on her scrutiny of EM's evidence, which is why you hear time and time again from lawyers like me a frustration about the system, because it's important to remember that nobody got on the stand and testified that EM said she was looking for a wild night. There's no evidence of that before the court. There's only a suggestion of that came from the lawyers, and the judge is sort of scrutinizing how EM responded to that and trying to decide if there's any room for the possibility that maybe it occurred that way. That's what's called reasonable doubt. So.
And what's important, too, is, of course, we heard from the Crown that they believed a lot of this case hinges on consent and whether or not there was consent. Let's talk about that for a moment, because for the justice to say that she didn't find the evidence of EM credible or reliable, part of the premise here of the Crown's case is that EM, it was argued, did not consent to the activities.
Correct. Yes. I mean, she consented to the first sexual encounter and not the one that followed. So this is a case that really turns on a question of, was there consent, or was there a reasonable and honest belief in communicated consent? And there's no question about whether or not the sexual acts themselves occurred. So sometimes you see in defenses to sexual assault cases people alleging that either it didn't occur or that it was the wrong person. Obviously, that's never been a theory before the court. Here, it's really a question of, did EM consent, or did the players have an honest belief that she had communicated consent, both of which would lead to an acquittal? And it sounds like from the snippets of the decision we've heard so far, the judge has made an affirmative finding of consent, that she found that on the facts before her, she believes that EM consented.
And again, for our viewers, we just had the images a minute ago that were up of the 5 who were accused in this particular case in the trial, in the sex assault trial that was underway in London, Ontario. The alleged incident dated back to June of 2018. The complainant, known as EM, during the course of this trial and during the course of all of the reporting of this particular incident, we are listening to the judge's decision that is being delivered right now in a courtroom in London, Ontario. Some of the updates we are receiving right now is the justice delivering the reasons behind her decision. And part of what she has said here is that there seems to be some inconsistencies as well. Let's talk about that, because we know that at the start she said the Crown did not meet the onus of the counts before me, and inconsistencies would be a key part of that.
Yes, I mean, she's finding that the evidence was neither credible nor reliable, as I hear it. And so she's looking at different versions of what EM has said over the years. And so there are 2 reasons that the evidence of a witness might be found unreliable. First, the judge might say she's not being truthful. But secondly, she just might say your memory of these events is not trustworthy for innocent reasons, that it's changed over the years and I can't rely on it. So it sounds like that's why she's going through with great care the different versions that we have heard.
You know, very finally, I wanted to ask you in terms of the broader impact here. We do not have the final decision from the justice, and that is important for our viewers to know. We continue to wait for the final decision. The language, though, however, that is being used suggests the one particular outcome in this case when we're hearing the justice say that she finds that the evidence brought forward by the Crown representing EM, the complainant, is not reliable or credible. That's important in terms of a direction that we may see here. What is the broader impact of that when you're a lawyer who typically represents individuals who have endured sexual assault?
So I typically represent victims of sexual violence outside the criminal system, and candidly, that's because I find the criminal system to be an incredibly blunt instrument that is often the agency of further re-traumatization to victims. It's a very high standard to meet. It's a very difficult process to navigate. And at the end of the day, there's not a lot in it for a complainant. I find it fascinating when people speculate that people make up allegations like this for attention or out of regret. It's an incredibly rigorous process to endure, as we all observed EM on the stand for more than 8 days. So a lot of people worry that it will deter victims from coming forward with their allegations. Generally, I do share that worry, but I think it's important to remind people that there are outlets for accountability that go beyond just the criminal system, just the police force. Obviously, there's civil cases, but there are also other ways to seek validation, healing, justice. There are people who will believe you. It really doesn't all boil down to what a judge decides in terms of guilt or not guilt.
Gillian, I want to thank you so much for your analysis and for joining us for the past 2 hours in terms of the special coverage we're bringing our viewers. That is lawyer Gillian Natchez. She has represented victims of sexual violence, mostly in civil cases. Thank you so much for joining us for this coverage. We do now also want to get some more updates on what's happening inside the courtroom as the justice continues to read the reasons behind her decision. For that, I do want to bring in the CBC's Hilary Johnstone. Part of what we're hearing here is what EM had testified that in her own mind she felt she had no other option in that particular scenario than to go along with what the men wanted. That is something that Justice Carroccia is noting as she continues to read her reasoning behind the decision.
That's right. That's the latest in these up-to-the-minute updates that our colleagues inside the courtroom are providing. That Justice Maria Carroccia is currently going back through EM's testimony, including the fact that she had testified that, quote, in her own mind, she felt she had no other option other than to go along with what the men wanted. The justice has also said that EM also didn't know the men and didn't know how they would react if they said no. The judge also saying here that EM had testified about adopting a, quote, porn star persona in order to get through the night, and also saying that no one physically forced her to participate, but the number of people and the atmosphere in the room made her feel as if she didn't have a choice. That is one of the latest updates. There's also another one here. Again, this from the judge's reasoning as she is going through it right now, saying that on several occasions, EM had testified that she had tried to leave the Delta hotel room, but would stay when the men told her not to leave. EM also told the court that the men likely wouldn't have physically stopped her from leaving, but she also testified that it was made known to her that she should perform oral sex acts on one of the accused, and that when she did not, and told the men to stop, which they did. So basically going back here through some of the testimony that we had heard from EM. Of course, that had come over a number of days that EM was on the stand, both testifying. We know that the cross-examination from the accused defense attorneys had gone on for a number of days as well. Just one final update here, Arthi, that I'd like to bring you. Again, this is these up-to-the-minute updates that our colleagues who are inside that courtroom, inside the courthouse, are bringing to us on our webpage and on the CBC News app right now, saying saying that each of the 5 men is currently sitting at a table with their respective defense teams as the judge is speaking. According to our colleagues, those 5 men are listening with their hands folded, alternating between looking down and looking at the justice. And we are still waiting for a formal decision here. But as we have been saying, the language that has been used with the judge saying that she did not find the complainant to be credible, we certainly know after that had happened that those men, their families who were in the courtroom, that there had been gasps. There had been, according to our colleagues there, looks on faces that seemed to indicate that they were feeling quite relieved. Family members of the accused who are there today and who have been there over the course of that more than 8-week trial, in some cases were also in tears. So those are some of the most recent updates. The judge is continuing to go through her reasoning. At this point, seems to be going back over some of EM's testimony, some of the things that she told the court, and also this most recent update that the 5 men, each sitting at a table with their defense teams, listening with their hands folded, either looking down or looking at Justice Maria Carroccia.
Hillary, thanks for this. That's the CBC's Hillary Johnstone. We continue for our viewers our special coverage of the decision being read today by a justice in a London, Ontario courtroom in the sex assault trial involving 5 former World Junior hockey players who were accused of sexually assaulting a complainant known as EM. As we've heard, the judge, as she's reading her reasons for her decision, says that she does not find the evidence of EM, the complainant, to be credible or reliable. You're looking at the images there of the 5 who stand accused. As we heard from my colleague Hillary Johnstone, what we're hearing from inside the courtroom is that each of these 5 men is sitting at a table with their respective defense teams. They're listening with their hands folded inside court to the justice who's reading the reasons for her decision, alternating between looking down and looking at the justice. For more analysis, I do want to bring back Daphne Gilbert. She's a law professor at the University of Ottawa. You know, we are listening, Daphne, to the justice, or getting the information of the justice giving the reasons for her decision, that we are waiting still to hear the final decision in this case. And part of what the justice is going through is she's going through the evidence that was heard not only during the course of this 8-week trial that took place earlier this year, but also the evidence of the civil lawsuit in 2022. And she is saying, she's pointing out there's inconsistencies in EM's testimony between these 2 cases. We do know that it was April 2022 when there was the statement of claim that was filed by EM, and in May 2022, the Hockey Canada had settled that lawsuit out of court to do with this case. But that was a civil suit that the justice is referencing here. Based on what we've heard so far in terms of the reasoning on whether EM knew how these individuals would react if she had said no, that's something that we've heard from the justice. What do you make of the reasons that we're hearing?
So it's probably pretty confusing for people who are what I call normal people and not law people to be reading the blog, because the way that a judgment is set out, the first thing that a judge does is go through all the facts that were relayed in the case to set the stage. And then she will talk about the law, and then she will apply the law to those sets of facts. So right now we're seeing her essentially just summarize the evidence that EM gave. We already know that she has said she found that evidence not to be credible or reliable, and we're not really sure yet on what basis that decision was made. It seems like she is going to be pointing to inconsistencies in the statements over time, and that's really hard because it is the problem of bringing a case 7 years after the alleged offense, that memories will change, details will become fuzzy. You say something in one statement in 2022, you're tested on it 3 years later, and your memory might not be as sharp as it was before. And that's always going to be a problem when you have a historic sexual assault case like this. And it's one of the downfalls to also having parallel proceedings where EM gave a sworn statement, a statement of claim in the civil case that can now be used to undermine her criminal case. Really, it shows the problem of having these parallel processes. But it must be remembered that at the time that she filed her civil statement of claim, there was no police investigation that had happened into that night. The police had unfounded her initial criminal complaint. So, you know, it's unfortunate that the way the timing worked, that this has come to this, and now she's maybe paying the price for having multiple statements out there. But she couldn't have known, you know, that the police were going to reopen the case as they did.
And of course, part of this, because the consequences are so high when it comes to a case like this, there is this ultimate, very high scrutiny of every single word and piece of evidence and testimony that is brought forward. And I just want to ask you about one piece here that we are looking at that is coming out again from our reporters who are in that newsroom, from the reasons behind the justice's decision. Again, for our viewers, we are still waiting for the official decision from the justice in this case. But part of what she has brought forward here is she's speaking about texts that the complainant exchanged with a friend who had been at Jack's bar, where this all allegedly began at the night when we're talking about June 2018. In those texts, this is according to the justice, those texts, the friend asked EM if she needed help getting away from McLeod, one of the accused, but EM, the complainant, said she was fine. She also didn't respond to 3 more Facebook messages from the friend or a phone call. This is all, again, part of what the justice is reading here. The next day, EM told the same friend that she hadn't been lit enough, quote, that night. And that is part of what Carroccia is reading as the reasons behind her decision. How critical is information like that? Because as you mentioned, the justice is going through each and every part of the evidence that she heard to give the reasons for the decision that ultimately we'll learn.
Yeah, I'll have to see what use she makes of this text exchange when she's actually applying the law to the facts. We know that EM herself admitted that she went back to the hotel willingly with Michael McLeod, that she intended to have sexual intercourse with him, and that part was consensual. So those initial text messages to her friend about being fine might have been in the context of, at that moment, things being fine and as she had anticipated. Later on, when there's all the men in the room, I'm not surprised she wasn't responding to later messages. It seems to me that she wasn't, on her phone for the entire evening. But the expectation the next day also that she would react a certain way to what happened to her is a stereotype about sexual assault victims, that they will respond uniformly in a certain way, that they will automatically, raise a hue and cry. That's a long-standing myth that has been expressly repudiated in the criminal code, but still haunts the system, that women will immediately go to the police and immediately have a coherent story to tell about what happened to them. So I don't know what use she's making of those text messages, but on their face, to me, they don't seem to be probative of a credibility problem for EM.
Daphne, I want to thank you for your thoughts and analysis. Of course, we will be coming back to you during the course of our special coverage here. Daphne Gilbert is a law professor at the University of Ottawa. Here on CBC News Network, we continue to offer you special coverage on the delivery of a decision by a justice in London, Ontario, in the case of a sexual assault trial involving 5 former World Junior hockey players. And it's a sexual assault trial where a complainant had brought forth allegations of sexual assault. These are the 5 men who stood accused during the course of an 8-week trial that took place earlier this year. There was one mistrial, and a second jury was ultimately dismissed, which is why it is now the justice that is delivering the decision. I want to bring back the CBC's Hilary Johnstone, who's in our newsroom. She's going through all of the information that is coming into us from the courtroom. What other updates do we have this hour?
Well, at this point, Arthi, we do know that the 5 accused, that they're each sitting at a table with their defense teams listening to Justice Maria Carroccia speak. Those are the 5 men there. It might be helpful here just to take a few moments to go over what we do know, a little bit of a brief timeline here as we do await further updates from our colleagues inside the courtroom. Those 5 men who were between the ages of 18 and 20 years old at the time of the alleged assault, all of this dating back to June 18th of 2018 in that southwestern Ontario city, London, Ontario. We do know, according to the complainant, EM, as she has been known due to a standard publication ban, that she had met one of the accused at Jack's, a bar in London, Ontario, that she had gone back to his hotel where he had been staying, that was consensual. It is what happens after the fact, after that meeting at Jack's bar, which of course has been the subject of this trial, which we have now been following for many weeks. That trial going on for about 8 weeks or so in London, Ontario. That is the hotel where all of this was alleged to have happened, the Delta Hotel, the London Armories, where we do know EM and one of the accused went back. And then, of course, it's alleged that the other members of that 2018 Hockey Canada World Junior Championship team came into that hotel room. And of course, we know it is the events that happened in that hotel room afterwards, alleged events, that has been the subject of this trial over a course of time here. Of course, we know that after this had first been reported to police in London, Ontario, there was a brief investigation. It was eventually closed without charges. It was then after, when the civil case that had been brought came to light, that the media started to understand more of what had happened leading up to all of this. We learned about what had been called that National Equity Fund, that money that had been used to quietly settle, in this case, this alleged assault. That after EM had come forward, there was that civil lawsuit, there was a settlement, a quiet settlement. That all came to light. We know that there were high-profile parliamentary hearings. We know that Hockey Canada, for example, lost sponsorships as some of this started to come to light. High-profile sponsors who pulled back some of their support from Hockey Canada. We know that Hockey Canada lost some of its federal funding as well over concerns that sometimes player registration fees had been used to quietly settle this case. Of course, after all of that, there was a period of time where we know that the board of Hockey Canada resigned, change in leadership there, and that it's in January of 2024 that we learned that those 5 hockey players, 5 accused, 4 of which who were playing in the NHL at the time, the 5th had been playing hockey in Europe, when we learned that they had been ordered to surrender to police in London, Ontario. We then learn about the charges. And of course, remembering here that each of those 5 men had been facing 1 count of sexual assault each, a charge of sexual assault. And then Michael McLeod had been facing that additional charge of being party to an offense for his alleged role in facilitating the assaults. That charge, that additional charge, had been something that legal experts, lawyers, have been commenting on, that it's not often that you would face a charge being a party to an offense for a sexual assault, that was unique here. Of course, this does eventually go to trial. We know that started in April, at the end of April. Within just a matter of days of all of that starting, we know that a mistrial was declared because of an interaction that had happened at the lunch hour between one of the defense attorneys and one of the jurors. A mistrial is declared. Later that same afternoon, a new jury is brought in, and then we know that jury is dismissed as well after one of the jurors on that second jury comes forward and tells the judge that they believe that members of one of the defense teams had been mocking members of the jurors. There were concerns about how that could prejudice the trial going forward. Decision is made not to declare a second mistrial, instead to continue on with a judge alone. We know that the Crown has expressed concerns about that, the fact that this did become a judge-only trial, because evidence, or their case rather, had been presented with the anticipation that a jury would be making that decision, not a judge. So there had been concerns about that. All of this, of course, leading up to where we are now, though, as we are waiting for Justice Maria Carroccia to give us her official decision. And what we heard quite quickly after she started to read from her decision, shortly after 10 a.m. Eastern Time, was that she did not find the evidence that EM, the complainant in this case, the evidence that she had presented to be credible or reliable. So we do not have an official decision yet, but certainly the language that has been used up to this point, it does lead you to believe that this could possibly be heading in a certain direction. Where we're at right now, though, Arthi, of course, is that Justice Maria Carroccia is giving us her reasoning. And as our guest there, Daphne Gilbert, had been telling us, something important to keep in mind here, that as she's reading that decision, what she is going to do to start is she is going to go back over some of that testimony. And certainly that is what we have been seeing some of these most recent updates, is that Justice Maria Carroccia is going over what we had heard before we do eventually get to that decision.
Thanks for this, Hillary. That is the CBC's Hillary Johnstone reporting for us. And we do want to also take a moment to warn viewers, much of the evidence and testimony from this trial contains disturbing graphic details connected to allegations of sexual assault. Some of it is unavoidable in order for us to provide you with the proper legal context presented in court. So as we do bring you the latest from the courthouse over the next few hours, you'll likely hear some of those graphic details. If you do need any support, there are lots of resources available, and throughout our coverage, we will display organizations that can help you along with their contact information. The crisis resources are for adults and children and are available both locally and nationally. We are continuing to get some updates from inside the courtroom. As we've heard, we do know that the justice is going through the evidence that was laid out during the course of the trial. That will be referred to as reasons for her decision, which we continue to wait for here. What we've heard, our Katie Nicholson is inside the courtroom right now. She's reporting that as the justice walks through her evidence, the secondary overflow courtroom is absolutely silent at this stage for nearly an hour in, that we know that this has begun, that we know the justice has been speaking for nearly an hour at this point. The second overflow courtroom, had to be opened at the last minute because of the wide interest, the great interest in this particular case involving, again, 5 former World Junior hockey players who were being accused of sexually assaulting a complainant known as EM in London, Ontario, back in 2018. For more now, I do want to turn to Lydia Riva. She's a criminal defense lawyer and founder of Riva Law. Lydia, thank you for joining us.
Thank you for having me.
You know, I want to talk about some of the updates that we're seeing here as well and bring them to our viewers as this is part of what the justice is reading. Just bear with me because I'm reading it for the first time as well as we try to parse through what we're understanding. The justice in this case, we understand from our reporters inside the courtroom, is addressing the consent videos, which are 2 clips that one of the accused had recorded after the alleged assaults. And in the videos, one of the accused asked the complainant, EM, if she's okay with what is happening or consented to the acts that had already happened in the hotel room. And EM did not display any signs of intoxication, is what we're hearing from the justice in the videos, and had no difficulty speaking. This is what we're hearing from the justice this hour. The judge says that she's also not sloughing her words and speaks clearly and coherently. So that is part of the very latest update that we are receiving now from inside the courtroom. Lydia, I would love to hear your observations and analysis of what I've just shared with you.
So the judge is actually addressing the Crown's argument that EM was not of capacity to consent to the sexual acts. The Crown must prove beyond a reasonable doubt that there was a lack of consent in this case. And if a person is too intoxicated to have the capacity to consent, then they cannot consent to sexual acts. So she is doing the analysis, and what she's saying is that those videos show the level of sobriety or lack of intoxication sufficient to find that she didn't have capacity. And she's really doing that analysis. We had heard other arguments about this video during the course of the trial. For example, the prosecution had argued that the video was showing that the defendant, Mr. McLeod, was insecure about whether or not, in fact, there was consent. And it basically showed that he was concerned that what happened was not appropriate or potentially criminal. The defense had argued that if you look at her demeanor, it really shows clues about her demeanor. And the judge is using it now to look at the issue of intoxication and whether or not she, in fact, has the capacity.
Important to note, of course, during the course of this 8-week trial that took place earlier this year, that the complainant testified for more than a week, and we heard from one of the players, one of the accused, was in the witness box, was facing questioning, and the complainant had testified at the time that one of the accused, Michael McLeod, had told her what to say on camera, and although she said on video that everything was consensual, that it is not how she felt at the time, and it was just another example of her going along with what the men wanted. That is the account from the complainant in this case, and that is specifically what the justice is honing in on at this particular time. We also know that Carroccia, the justice here, is going over the text messages between Michael McLeod and EM. So Michael McLeod is one of the accused. He is the individual that we heard through the course of this trial that the complainant went to the hotel with, that she believed that she was going to the hotel with this one individual. That's her account. And after Hockey Canada began contacting players because of the report made by the woman's family, court heard that McLeod found EM on Instagram a day after the alleged assaults and that the two started texting. How important are those conversations when we're waiting again for that official decision?
The judge is going to want to be looking at, or is looking at, the communications between the defendant and the complainant, because of course this case is about the complainant and whether or not she had the consent, and her interactions with the defendant before and after or during the event is very crucial to her analysis. I should say that at the outset of this decision, the judge had said that she found that the complainant was not reliable or credible, and that's a key issue in this case. In order for the Crown to prove beyond a reasonable doubt a lack of consent, she really has to rely on the credibility and reliability of the complainant. So when the judge is looking at whether or not she's credible or reliable, she's going to be looking at her correspondence with the defendant to see whether that matches up with her version of events about what she says happened and about her state of mind at the time.
And I just do want to make a clarification here so that our viewers are absolutely crystal clear of what we're hearing from the justice. And that is specifically that the justice is saying she didn't find the complainant's evidence to be credible or reliable.
Correct.
Not necessarily the complainant. So I do want to make that clarification there, that Justice Carroccia has said, as she continues to read the reasons behind her decision here, that she didn't find the complainant's evidence to be credible or reliable, and said the Crown in this case did not prove its case beyond a reasonable doubt. We continue to wait for the official decision here, but Lydia, given that sort of language we're hearing from the justice at the outset, what do you anticipate over the next hour or so?
The Crown, in order to secure convictions in this case, has to prove beyond a reasonable doubt the guilt of the defendants, and that the evidence of the complainant basically sufficient for the Crown to meet that high burden. And if she's saying that the evidence of the complainant is not reliable or credible, which is something that the Crown basically has to prove in order to prove this case, and that they have a reasonable doubt, that the trier of fact has a reasonable doubt, her honor is on her way to acquitting these defendants. In my view, it's impossible to get around that. If you don't find the main Crown witness's evidence to be credible or reliable when she is the main Crown witness, and when the trier of fact is saying that there's a reasonable doubt, basically there's no route for conviction if that's the case.
Okay, and we are continuing to see all of this evidence as it comes through, or rather the reasoning behind the decision. We will continue to speak with you for analysis. We appreciate your time today, Lydia. That is Lydia Riva. She is a criminal defense lawyer and founder of Riva Law. I do want to continue to bring our viewers coverage, special coverage of the decision that is coming out from the justice who was presided over the sexual assault trial in London, Ontario, involving 5 former World Junior hockey players and the allegations put forward by complainant EM. I do want to bring forward our CBC's Hilary Johnstone here, as she's been looking through all of the updates. You know, I was talking with Lydia Riva there, the lawyer, in regards to some of those more recent updates about the text messages involving the complainant and at least one of the accused here.
Well, then let's go through some of those text messages, Arthi, and what they say, what they show, because we know that they had been submitted into evidence. They are text messages between between Michael McLeod and between the complainant EM. And here they are, just to show you. So that M that you're seeing, that is McLeod, that is Michael McLeod, one of the accused, and then E is for the complainant. We understand that this text exchange came about after Michael McLeod found the complainant on Instagram. So you can see here that he says hello. She then replies with, I talked to my mom about it and she called, I think, but I told her not to. I don't want anything bad to come of it, so I told her to stop. I'm sorry, I didn't mean for that to happen. Michael McLeod then responds there in that text message thread saying, you said you were having fun. And just to go over some of what we're hearing from court, some of these updates again that maybe help give you a little bit of context behind these texts. We know Justice Maria Carroccia going through some of EM's testimony here. We know that after all of this allegedly took place, that the complainant's mother heard her crying in the shower and phoned police. Her mother's boyfriend contacted Hockey Canada after figuring out who the accused were, who the men were. It's at that point that the judge points out that EM went to the police and to the hospital. We know that after Hockey Canada started to look into this, it is then that this text exchange happens between the two of them. We see here at McLeod, the accused, asked her to put an end to the police investigation. The exchange, like we say, this text exchange that you had just been looking at was triggered when Hockey Canada and police were first alerted about these allegations. I see that there is another update that is coming on our up-to-the-minute sort of live feed here, coming to us courtesy of our colleagues, our reporters who are in the courtroom right now. Our viewers can find this on our website and on our app as well. But the judge is currently outlining differences as she saw them between a statement that the complainant gave to Hockey Canada back in 2022 compared to the testimony that she delivered at trial just a few weeks ago, so a little bit earlier this year. Some of those differences, some of those discrepancies that the judge points out, and I will just read them here as they're coming into us from our colleagues, include the fact that in 2022, the complainant had stated that she didn't initiate any of the touching at Jack's bar where she first met McLeod, but acknowledged she did initiate some touching after being shown video from the bar. So that's one discrepancy that the judge is pointing out right now as she is going through her legal reasoning for how she is going to eventually come to that official decision, which we are still awaiting. Another key difference that she is currently outlining. In 2022, the complainant claimed to have fallen in front of McLeod, which was not true. During her testimony at trial, EM said she had made a mistake about which time she was talking about. And Arthi, just finally here, one more discrepancy that the judge has pointed out here. In 2022, she identified someone else, one of the other men who had been in the hotel room, as the one who put the bed sheet down on the floor. Then during cross-examination during the trial, she said she wasn't sure and couldn't say that that person she had previously identified in 2022, if he was the same person, the same man who put down the bed sheet. So as we are awaiting that official decision, these are the updates that are currently coming into us as the judge is going through that reasoning. She had started by going back over a lot of the testimony that we had heard from EM, and now it seems pointing out discrepancies.
Okay, thank you for this, Hillary. This is CBC's Hillary Johnstone. As an update here, we understand that court is now in recess, a 15-minute recess. So with that, we want to get some analysis from someone who was in the courtroom. Sam Pucella is a criminal defense lawyer, and she wasn't involved in the case, but is familiar with the judge and has followed the case from the start. She was in the courtroom. She's joining me now during this recess. Okay, first, I would love for you to exchange with our viewers what it is that the courtroom is like right now, what the mood is like right now.
Yeah, so it's a very busy day. In fact, there are so many people here today. There was a long lineup from early in the morning, and I just looked out of the courtroom here just before the break, and they had to actually open up an extra courtroom. So not only is there the actual courtroom which has a lot of seating, it's a big courtroom that can accommodate all of the 5 accused and the various parties. They have the full jury deliberation room on the main floor, which can accommodate 150 people. And there were so many people, they had to open up another courtroom, courtroom number 19 on the 11th floor, which can accommodate another 150 people. So it's a very busy day.
In terms of the reactions within the courtroom, what are you watching closely? What are your observations?
So I'm in the media room, and I just personally find that it's easier to observe there. The acoustics are better, but certainly there was a lot of reaction. Justice Carroccia came right out of the gate and indicated that that EM was not credible or reliable, and that gave clarity with the decision. And so there was visible reactions to that. I know that there were visible reactions in the courtroom as well. This is a very big moment that had a big determination for a lot of people, and so that's often normal. That you see such reactions. I've experienced that oftentimes in my cases as well. So a lot of emotions, lots of tears, sighs of relief. Obviously, this is a big decision that impacts a lot of people. So yeah, it's been, the reasons that are following, which are still underway. So we're under a recess now, but this was a lengthy trial. And so it's not unreasonable that the decision is lengthy. But yes, there's been, it was a lot to take in for a lot of people.
There was the potential here for this to be precedent-setting. And I'm wondering, for you as a criminal defense lawyer, what are you watching closely as we continue to hear the reasons behind the justice's decision in this case?
Yeah, so a lot of people, because I think how high publicity this case is, a lot of people are of the view that it might be precedent setting, but Justice Carroccia made it very clear at the outset. She said this decision is not a case that impacts, precedent setting or changing of the substantive criminal law as it pertains to consent. And she really made sure that was clear from the outset, because this is not a case about, the law of consent in terms of something that's changing that law. It really is a case about, and she made it clear, and now she's getting really into the reasons as to why this is a case, and I think it's important for the public to note the difference. Yes, consent is an essential element of sexual assault, but this is a case that comes down to the credibility and the reliability of the complainant, which was not sufficient for Justice Carroccia, and that is why there's a reasonable doubt and the accused individuals are being acquitted.
And I did mention this with my previous guest as well, that the words from Justice Carroccia specifically said that the credibility was called into question when we're talking about the evidence heard from the complainant. So Carroccia said she didn't find the complainant's evidence to be credible or reliable, not necessarily speaking about the complainant in this case. Now, in terms of what we're seeing the justice lay out here for the reasons behind her decision, there were discrepancies that were brought forward here, and I assume that you were listening very closely to that, because Carroccia, the justice, outlined here differences between the statements that were given by EM during the course of this trial earlier this year and also a 2022 trial that occurred. And in 2022, she stated that she didn't initiate any of the touching at Jack's bar, but acknowledged she did initiate some touching after being shown video from the bar. In 2022, she also claimed to have fallen in front of one of the accused, which was not true. During her testimony, EM, the complainant, said she made a mistake about which time she was talking about. And then there was another discrepancy that we're hearing from inside the courtroom, and that was from 2022 testimony that is being compared to the testimony that we heard earlier this year, where she identified an individual as one of the men in the room and the one who put the bed sheet down on the floor. But during cross-examination, she said that she wasn't entirely sure that he was the person or who, in fact, did put that bed sheet down. How critical is that, those discrepancies, when we're looking at the outcome today?
So yes, earlier when you asked, what is it that we're paying attention to, the credibility and reliability of any witness, and certainly here the complainant, it really is about inconsistencies. And so when you have a situation where there are multiple statements like that, there are some inconsistencies that may be less important than others, but certainly Justice Carroccia is going through all of them. And that's why these reasons will certainly take some time because there is a lot of evidence to go through. And it really is evidence in a case because That is how criminal trials are determined. And earlier when you said in terms of a different trial, so I believe it was a settlement. So in terms of statements that were adduced in the civil settlement through Hockey Canada and the investigations there, that's of course, information that's going to be separate. So when I look at that, and in any case that I'm looking at, certain inconsistencies will have a lot of weight. So for instance, whether or not you can remember who was around when you fell, for instance. So when she's talking about whether Mr. McLeod was there or not, that's obviously an inconsistency, right? But when we really get into the really hard facts in terms of the differences of what she characterized in her statement in 2022 through the civil suit, we're really seeing major differences that come to light in this trial, where, for instance, she's talking about, you mentioned the touching and things like that, who's initiating conversation, but also, how much alcohol she's drinking, whether her friends abandoned her at the bar. There was text message correspondence that was referred to with her friends about how they're looking for her through the night. And indeed, she, in the course of the trial was talking about how she hadn't seen that footage. And obviously her memory, is refreshed upon seeing footage. And so when certain assertions were put to her in this trial, that, her responses were different. And so those types of inconsistencies where you're painting a picture and an overall narrative from, the best of her ability from her memory, from her version, is clearly contradicted, not only in some of her answers from previous statements, but also with hard footage, for instance.
And, as we continue to follow the decision and the reasons behind the decision, we're also following our reporters who are inside the courtroom. And we know that court right now is on a 15-minute recess. And so some of the reporting that we are seeing here from inside is that Carroccia says she's about halfway through reading her decision right now. And in that case, we will learn what her final decision is in several moments' time. But we do understand that there's a lot of hugging and back patting going on as family members get up and file out of the courtroom for this recess, which is why we are able to speak with Sam right now, because she is in the media room of the overflow courtroom as well. Michael McLeod, one of the accused, we're learning is sitting in the front of the courtroom with his legal team, reached out for the hand of another one of the accused and gave him a handshake as he left for the break, and that accused remains seated at the back of the courtroom with his legal team. I did want to finally ask you, Sam, before you have to head back in because the recess will end soon, in terms of an appeal, how challenging might that be given the language we're hearing right now from the justice?
So really, when it comes to appeals, in the case of an acquittal of the accused, it would be a Crown appeal in that case if they saw it. So they have 30 days, as I understand, to launch an appeal if that's something that they would like to do. And appeals, I think it's important for the public to understand that if that happens, it's not just because the Crown would be upset with the decision. It really has to be grounded in legal reasons. So if there's an error in law, so obviously the decision is not done, but and also it's important to note that there is a written decision that has the fulsome cites to legal case law, which are not being read out to assist with the time, the time that it takes to read out this decision. So the Crown will obviously need to read that full decision. But I think that if there was an appeal, it may also come down to some of the pre-trial and mid-trial applications that were done, because these were litigated in advance of trial and in the middle of trial. And anyone who was watching the trial may recall there were some contentious applications about evidence that they wanted to have in. There was a Stinchcomb application in advance of the trial, but there was also hearsay applications. And so certain evidence that the Crown was really trying to adduce in this trial was not admitted at trial, and they may look to appeal that decision. But that, of course, will be up to the Crown and the various authorities that give approval to that. And whether or not it would go to the Court of Appeal is, of course, based on the law. And then from there, it would be to the Court of Appeal if an appeal was heard. But in my view, if there was an appeal from the Crown, given that if the accused are acquitted, which seems to be the case here with the clear comments from Justice Carroccia out the gate from the beginning of this decision, then I think that it would be based on their perceived any legal errors in those types of decisions.
Sam, I want to thank you for your time. I know you've got to head back too. That is Sam Pucella. She is a criminal defense lawyer, and she joined us today from London, Ontario. As we continue with our coverage of the justice reading out the decision to do with the sexual assault trial involving 5 former World Junior hockey players who were accused of sexual assault involving an incident dating back to June of 2018 in London, Ontario. The allegation or accusation was brought forward by a complainant known as EM. An 8-week trial took place earlier this year. There were 2 sets of juries. There was one mistrial and then a second jury, and that jury was then dismissed following some developments involving one of the accused lawyers. And now it is carrying forward with a single justice, whose decision, of course, we are continuing to hear this hour. I do want to bring back Daphne Gilbert. She's a law professor at the University of Ottawa. We continue to look at the reasons that were being laid out this morning so far by the justice. And part of what she talked about were discrepancies, but also tackling the issue of consent, because there were consent videos that were shot and admitted as evidence. And we heard from the justice as she addressed those consent videos. There are 2 clips that one of the accused recorded after the alleged assaults. And in the videos, one of the accused asked EM, the complainant, if she's okay with what is happening or consented to the acts that had already happened in the hotel room. And as the justice says it, the complainant in this case, in these videos, did not display any signs of intoxication in the videos and had no difficulty speaking. And the judge says that she was not slurring her words and spoke clearly and coherently. Meanwhile, we did hear testimony from the complainant who said that she was being coached what to say by one of the accused and that she didn't even remember recording the video. How important, Daphne, is this, what we're hearing from the justice in terms of the reasons behind her decision?
Well, so first of all, all she's doing right now is describing what she sees when she looks at the consent videos. We have yet to hear her actually talk about what she thinks legally about those, the legal impact of those videos. And I am still hoping that she will say that those consent videos were irrelevant to her determination around consent, that, a video of someone after the fact is not helpful to ascertaining consent. I'm also still hoping that, because you keep saying, and it's so true, she has said that the evidence is not credible, not that the complainant isn't credible. And so it might still be that we're going to get into a discussion about whether the players had an honest but mistaken belief in consent. She may agree in the end that EM wasn't subjectively consenting to what happened to her. And then we will have to hear what she says about what the steps were that the players took to ascertain consent, the reasonable steps. It seems if she's going to acquit them, she felt they did take adequate, reasonable steps. And that's what I'm really interested now in finding out is what she thinks they did that satisfied that legal burden of taking reasonable steps to make sure they had consent. But I'm also hoping that she dismisses the video as being irrelevant to her ultimate conclusion.
Daphne, thank you for this. Of course, we're going to continue to come back to you during the course of our special coverage today. There's much more straight ahead. We know that the justice has said she's only halfway through at this stage, going through the reasons for her decision. With that, I do want to head to London, Ontario. The CBC's Ali Shiasan is outside of the courthouse. Tell us a little bit more about what you're observing where you are.
Well, Arthi, right now, court is on break. They'll be resuming in about 10 minutes from now. And as we have been reporting, it looks like it's going to be possibly 5 acquittals here. At the outset, Justice Maria Carroccia said, quote, "I do not find the evidence of EM to be credible or reliable." And the bar for proof beyond a reasonable doubt, in her eyes, was not met. Quote, "I conclude that the Crown did not meet its onus on any of the counts before me." As soon as that was said, Arthi, there were audible gasps in the courtroom. Family members of the accused hockey players turned to each other and embraced one another. Some of the hockey players as well looked back and provided a reassuring smile at those family members as they watched along. Then the gallery went silent. The accused were holding on to every word that Justice Maria Carroccia was saying in providing her reasonings for her rulings, although their shoulders were really quite tense when the day began in the courtroom. And then they started slouching. You could tell that they were indeed relaxing. Michael McLeod started looking at his phone. Members of the public who are in the court overflow room, I'm told that you could hear a pin drop in there because they too were holding on to every word of Justice Maria Carroccia's rulings. This was already a very high-profile case given the allegations and given the high-profile hockey players who were accused here. It's going to garner even more attention now of this potential big ruling that they all perhaps will be acquitted. But more to come. The court will resume in any minute now, and we'll see where things go from here, and we'll bring you the latest.
And we're about halfway through, we understand, from the Justice. Thank you for this, Ali. That is the CBC's Ali Chiasson at the courthouse in London, Ontario. Now, of course, there has been so much interest in this case because there could be a potential impact from this decision on Hockey Canada. I want to bring in the CBC's Jamie Strachan, who's been following this story. And of course, it already has had an impact on Hockey Canada when we're talking about the previous case, the settlement from 2022, and how this has all made hockey culture come into the forefront and spotlight. So let's talk about the impact we've already seen so far because of this case.
Well, I think there's a couple of things to unpack here. I think there's the impact on Hockey Canada. Let's look at that first. I mean, when this all came to light, a lot of things were exposed about the internal workings of Hockey Canada. We know that, for example, if you play minor hockey in this country, if your child's registered for hockey, you pay dues that go to Hockey Canada. We know that through this case, some of those dues were being used to pay off the kind of settlement like was seen in this case. That's been changed. It changed the board of Hockey Canada, who tried to weather the storm here, and were told, no, there needs to be fundamental changes. But we also have to look at what Hockey Canada actually has purview over, what it can control. It's instituted better training around consent for the programs and the players that it controls, which are the very elite programs in this country, teams that are representing Canada on the international stage. They've put in place increased training, modules, speakers, seminars, mandatory training in those areas. But in terms of the wider hockey culture, let's call it the rest of the country, the hundreds of thousands of boys and girls that are playing in minor hockey leagues across the country, it's really going to be hard to discern what has actually changed at that level from a house league hockey player to a player playing, AAA hockey that aspires to get drafted, play junior hockey. It's really piecemeal. We know that some organizations have started to bring some speakers in, to talk about things like consent, some of the issues that this case, brought up. But it's important, I think, to also realize, how do we develop elite hockey players in this country? How does hockey develop elite players? It's different than the three other major sports. You have a situation where, you have the three main junior leagues in this country, the OHL, the WHL, and the Quebec Minor Junior Hockey League. You have kids, boys who are being drafted at 15, 16 years old. They're going away from home. What do they know about consent? What have they learned at home? What have they learned in school? What have they learned from their local organization? It's really piecemeal based on where that player's coming from and what level of dedication their local organization has given to these very important topics. So I think at the top end of Hockey Canada, when the best of the best go represent Canada in international tournaments, there's been a level of training and learning that's been implemented. But in terms of affecting the wider hockey culture, I think it's naive to think that there's been, a fundamental shift, because I just don't think that's been the case at this point.
And perhaps there hasn't been a fundamental shift, but there's certainly a lot more awareness, and there was sort of forced transparency as we saw, of course, members of Hockey Canada had to come forward and face questions and a grilling, really, from lawmakers as well. And, you touched on this when we're talking about those registration fees from Hockey Canada teams across the country, these sort of camps, training camps, and essentially, and for our viewers who may not have been following following this through the years, but it was in 2022, in fact, that the public became aware of this National Equity Fund that we heard Jamie make mention of there, which covered a broad range of expenses related to safety, wellness, and equity initiatives. But part of that also included costs with physical injury, harassment, and sexual misconduct. And it was millions of dollars that ended up being spent. And this was hockey parents who were outraged to learn of that. Can we talk about just the implications of that and how important it was that during the course of this, parents and the public learned about that?
I think that was very important. I mean, I think, when I look at my own situation, two of my boys came up through the GTHL, which is, the largest youth hockey league in the world. You pay dues to be part of a team, but you also pay this registration fee that goes to Hockey Canada that's then distributed back throughout the various provincial organizations, and it's a lot of money. And I think every year, you kind of go on this portal, you click a box, you give them your visa number, the $800 or whatever dollars goes off, and you never really have a true understanding of where it's going. It's going to insurance. You hope it's going to, things that will make the game better. But it was always quite opaque. And I think there's now been a level of transparency, in terms of breaking down every dollar as to, letting parents know where that money is going. I think that's been an important thing. But I just go back to what I said before, Arthi, whether on the ground it's fundamentally changed things. If you are playing elite hockey in the city of Toronto and any city across the country, I mean, the goal of these hockey organizations is to develop elite hockey players that could potentially be drafted, that can potentially, play junior hockey at a high level and maybe one day play pro. I think what this case has given an awareness to things, important topics that surround the sport, but I think they're just starting, to be given a seat at the table alongside development as things that are also important as part of the game. I think that's what this case has done. It's made the conversation more important. It's given the conversation more credibility by those within organizations that are looking to exert change that maybe for years before have said, listen, that's not the place of a hockey coach or an organization to teach kids about consent. That's for the schools, that's for the parents. I think it's given those people a seat at the table in minor hockey organizations across the country. But I think, the transition to where this is an integral part of, just as important as, teaching kids about, what makes a power play good or how to kill a penalty. I think until it becomes, equal to those kind of things, the on-ice part, I still think there's a, based on what I've seen and heard in hockey circles, there's a long way to go there.
Jamie, I want to thank you so much for your thoughts and for your reporting on this. That is the CBC's Jamie Strachan in Toronto. And for our viewers also, we want to take a moment to warn you that much of the evidence and testimony from this trial contains disturbing graphic details connected to allegations of sexual assault. Some of it is unavoidable in order for us, to provide you with the proper legal context presented in court. And as we bring you the latest from the courthouse over the next few hours, you will likely hear some of those graphic details. If you do need any support, there are lots of resources available. And throughout our coverage, we will display organizations that can help you along with their contact information. Now, the crisis resources are for adults and for children and are available both locally and nationally. So, special coverage we're bringing you today on CBC News Network. Ontario Superior Court Justice Maria Carroccia is delivering her decisions in the London sexual assault trial of 5 former players with Canada's 2018 World Junior Hockey Team. Carroccia says she didn't find the complainant's evidence to be credible or reliable and has said the Crown did not prove its case beyond a reasonable doubt. The Justice, while court is in a recess right now, it is about to resume, and the Justice has been going over the evidence heard at trial in detail, pointing out inconsistencies between the complainant, EM's evidence this year in the trial and her civil lawsuit in 2022. The accused are Michael McLeod, Carter Hart, Alex Formanton, Dylan Dubé, and Cal Foote. They had all pleaded not guilty. We continue our coverage, and we know court will be resuming any moment, and we'll continue to bring you updates as they become available to us. For now, I do want to turn to Lydia Riva. She's a criminal defense lawyer, founder of Riva Law. Lydia, we know that the judge will have to decide whether consent was absent beyond a reasonable doubt here. She has pointed to her observations of the consent video. What's the threshold as we know it when it comes to consent?
The Crown has to prove lack of consent beyond a reasonable doubt. And in order for the defense to raise the defense of consent, there really has to be, the consent is not something that can happen at the beginning of an interaction or at the end of an interaction and then just apply for the entire event. Consent is ongoing, and an individual has to consent to specific acts. So because this case engages 5 defendants and there are multiple acts that are alleged in the Crown's case, the judge really has to address whether or not the Crown has proven beyond a reasonable doubt that the complainant had a lack of consent for each and every act. And as I think was said by one of your previous guests, the judge did say at the outset of this decision that this case is not going to reformulate the law on consent. So there's nothing going to be novel in this decision about consent, but really consent is the main issue, and whether or not the Crown has proven that high burden of proof that there was no consent in this case.
We do understand that court has resumed this hour and that the justice continues to read the reasons behind her decision, which, of course, we officially await, although we've been parsing the language that was used in her opening statement, so to speak, where she said that she did not find the complainant's evidence to be credible or reliable, and also said that the Crown did not prove its case beyond a reasonable doubt. Part of what we're seeing her go through here, too, Lydia, is those discrepancies between EM's statements that were given in this 8-week trial that wrapped up earlier this year and the 2022 civil case. And in part, she's talking about discrepancies that EM, the complainant, has put forward about whether or not she initiated any of the touching. In 2022, we heard from the justice also that she claimed, EM, the complainant, claimed to have fallen in front of one of the accused, which was not true. And during her testimony during this trial, she said she made a mistake about which time she was talking about. How important are those sorts of factors when the justice is trying to make a decision here?
When the issue in a case is whether or not the complainant's testimony is reliable or credible, it's very common for the participants in the case to look at whether or not there's any contradictions between the complainant's viva voce evidence, that is their evidence at trial, and other statements that were made either in other proceedings, in other contexts, or even statements made to police. So it's very common for the players to look to see whether or not there are contradictions in order to examine whether or not that impacts reliability and credibility. And it seems here, because the judge has found that the evidence of the Crown's main witness is not reliable or credible, and she's going through these contradictions, it seems as though that has impacted her assessment. Now, I must say, sometimes witnesses can give contradictory pieces of evidence. Sometimes there can be minor inconsistencies, but the judge ultimately has to determine whether or not those inconsistencies are major enough or important enough to ultimately affect the believability or reliability of the witness. So it seems that it has made an impact here. It doesn't always, but it seems that it has for the trial judge in this case.
Okay, Lydia, of course, we'll continue to have conversations with you during the course of our special coverage. We understand that court has resumed, and so we'll continue to bring our viewers updates. Thank you for this. That's Lydia Riva. She is a criminal defense lawyer and founder of Riva Law. I do now want to bring in Christy Alain. She is a sociology professor at St. Thomas University in Fredericton. She's also Canada Research Chair in Physical Culture and Social Life. She's been studying men's hockey culture for decades. And of course, we know that part of the reason there's been so much interest in this case is because it is putting a spotlight, shining a spotlight on the nature of hockey culture in this Canada, or in this country, rather. So let's talk about what sort of conversations you're seeing as a result of this case.
I think what, for me, I think in the initial reporting of this case was really exciting is that we've seen allegations of sexual abuse in myriad forms linked to men's hockey culture in Canada for generations. I think what was unique and is important that we not lose sight of in this case is that this was the first time we saw people move from talking about bad actors, bad actions, and started to really look at the culture of men's hockey in the country and ask for deeper changes. And so, in light of the verdict today, we have to ask, we've had 7 years since EM launched her complaint against the World Junior Hockey team and launched complaints with Hockey Canada. They've had 7 years to address chronic problems in their system. We've had 3 years since this has become public, and there's been a real push. I think now people want to know what's happened. People are really upset and angry about these allegations. This is a sport that's meant to represent the country and the nation, and we should always be asking if it's doing that in the best way possible. And I think in light of what's come forward, it was always, these allegations were always bigger than the verdict today. And I think we need to think about what kind of hockey culture we want to see and if we're taking the steps to get there. And I'm not sure that we are.
In terms of what we're seeing come out right now from court, and it is the reasons behind the decision that we're hearing the justice read out at this stage, do you believe that some of this may be a catalyst for greater sort of introspection within Hockey Canada and perhaps the topic of consent?
I would hope so. I mean, these are issues that have been going on, as I said, for quite some time. We saw in the 90s, CBC well covered a book by Laura Robinson that documented histories of sexual violence in the game. And they've continued to do that since then. These issues haven't gone away. Issues of consent, how seriously leagues like the Canadian Hockey League are taking these issues have always been in question. The CBC themselves reported quite recently that the London Knights haven't had their gender-based violence training that's been mandated by the Ontario Hockey League since 2022. And in spite of that, we've seen Hockey Canada put the Hunter brothers, leaders of that franchise, in charge of the new World Junior Championship team coming up this winter. So I think when we ask these questions, we have to really look at the evidence that's on the table. Has Hockey Canada moved the needle? Do they seem interested in moving the needle? And, the selection of the Hunter brothers in particular, given some of the things we know about them, their history of old-time hockey, they've been, suspended from the Ontario Hockey League for condoning certain forms of violence that we should find troubling, I think is extremely concerning.
I do also want to bring our viewers an update here, and I wanted to also ask you about it, and that is, we know that court is back in session, and part of what we're learning here is that one of our reporters, Kate Dubinsky, did get a chance to have a conversation with the lawyer for the complainant in this case, with EM's lawyer, and she said that the complainant is watching the decision and the reasons behind the decision as they are being read out, but is watching remotely. And I'm wondering if you would be able to sort of tap into what it must be like to be watching this when the opening statement was that the justice did not find that the complainant's evidence was credible or reliable.
I think that must be incredibly hard. I really don't know how to speak to that except to remind people that EM's complaint, EM is not the only complainant, that's brought forward these kinds of issues against players at this level in this country. And these are the things we need to be concerned about. I think it's incredibly brave to bring this forward in this way. And I don't really know what else to say about that.
And very finally, I did want to ask you too, because we were talking about shifts within Hockey Canada. And when we're talking about the National Equity Fund, which was brought to light during the course of the past few years when Hockey Canada was under scrutiny as a result of this case being brought forward, we understand that those registration fees from parents across the country that were going to Hockey Canada, some of which were being put towards this fund, and that the Hockey Canada Chief Financial Officer testified that $7.6 million had been put into 9 settlements regarding sexual misconduct involving those within the organization. So When that's been going on, and that's since 1989, so when that's been going on for such a long time, how difficult is it to turn that around, to switch that culture?
I think that's an important question. It's incredibly difficult, and we have to think about what might need to happen. We've seen generation after generation that hockey has been an institution that's closed to the public, that is really resistant to change, that hires from its own, it hires from the inside repeatedly, and that we've seen these problems sort of perpetuate generation after generation until there is true wholesale change in hockey. And that we're talking coaches, managers, board officials, beyond just the board at Hockey Canada. I don't think that we can expect real change. The culture of hockey, the culture of men's hockey and its ties to lots of forms of violence, from hazing to sexual abuse to physical violence, runs deep. And these are engendered in this system and reproduced generation after generation. If we keep the same people in power, we can't expect there to be different results. If the same kinds of people are coaching, if we're using exemplars who promote that kind of hockey masculinity at the highest levels, we can't actually expect there ever to be change in the system.
Kirsty, I want to thank you so much for your time today. That is Kirsty Allain. She is a sociology professor at St. Thomas University in Fredericton. As we've been reporting, we know that court is back in session this hour as the justice continues to read the reasons behind her decision when we're talking about the final decision of the trial into sexual assault against 5 former World Junior hockey players. I want to bring back the CBC's Hilary Johnstone, who's in our newsroom following along there. And we do understand that the complainant, EM, has been watching the reasons behind the decision as they're being read out remotely.
That's right, Arthi. Watching these proceedings remotely, that information coming to us courtesy of our colleague Kate Dubinsky, who did have a brief conversation with the complainant's lawyer, who is sharing that she is watching this via video, also saying that she spoke with her client during the break. Of course, we know that court did go into a brief recess a short time ago, saying that she didn't want to disclose any of their conversation, but also saying that she does plan to speak with EM once again today at the next break. We're also anticipating that the lawyer representing EM, the complainant, will make a statement after the judge is finished bringing us her decision and gives that official and final decision as well. Also important for our audience to note that we're anticipating there could be something similar from both the defense lawyers and then as well as the Crown attorney, that they might come out and speak with the media once we have a final decision here. Just want to go into a few more details that we have as well from the accused and how they have been in court today as they have been listening to Justice Maria Carroccia read out her reasoning behind that decision that we're gradually working our way to. We know, of course, as you've been saying, that 5 players facing the charge of sexual assault, Michael McLeod facing that additional charge as well. We know that both Michael McLeod and then also Alex Formanton have been sitting back, slouched in their chairs, according to our colleagues in the courtroom, appearing relaxed next to their lawyers. And then we also know that Carter Hart, who is apparently wearing a burgundy suit, according to reporters in the courtroom, has been sitting up and has been watching the judge, as has Cal Foote. Finally, here we know that Dylan Dubé has been sitting, leaning forward, all of them listening intently as Justice Maria Carroccia goes through her decisioning here. Like we say, there was a brief recess, a brief break. When that happened, according to our colleagues here, there was a lot of hugging and back patting going on in the courtroom as family members got up and filed out of the courtroom for that break. We know that Michael McLeod, who was sitting at the front of the courtroom along with his legal team, reached out to Cal Foote, and gave him a handshake, we're told, as he left the courtroom for the break. We know that Foote remains seated at the back of the courtroom with his legal team. So just to sort of give you an idea, I believe we've been showing some video as well from earlier on today when the 5 accused went into the courtroom. We know that the accused, along with their family members, were sort of given sort of first options for sitting in the courtroom. After that, members of the media and the members of the public as well, which is part of the reason why there was a bit of a delay off the top, because there was such an interest. There are now 2 overflow rooms full of people watching this. Just finally here, because I see as I've been speaking, Arthi, another update has come here from our colleagues who are providing us with these up-to-the-minute updates on our website and also on our news app, that there has been a return here to the evidence, the judge going back over evidence that we heard from EM's testimony as well, talking about some of the other former teammates of the accused who, some of them, their statements were part of this trial, going back over some of what we heard, like we say, all of this leading up to that official decision, which we are still anticipating. We know that when they took a break, when court took a break, probably 25-30 minutes ago now, at the time we were told the judge was about halfway through her reasoning. So if you do the math there, it would stand to believe here that there's still going to be some more time before we do reach that final decision.
Okay, thank you for this, Hillary. That is the CBC's Hillary Johnstone reporting for us. As we continue to go through and give you special coverage of the decision as it is being read by the justice right now in the case of a sexual assault trial that was underway in London, Ontario, involving 5 accused former World Junior hockey players and the complainant EM. I also want to bring in Nick Cake because he is an experienced criminal defense lawyer who's based in London, Ontario. We have had many discussions about this particular trial. You have been watching it very closely, although you've not been involved in the trial specifically. We understand now that the justice is looking back at the evidence, focusing on the accused specifically. But on the onset, we know that there was a statement given that the justice did not find the complainant's evidence to be credible or reliable and did not feel that the Crown proved its case beyond a reasonable doubt, which is very important. I'm wondering if we can start perhaps, Nick, by you giving our viewers a better sense of how this process unfolds. I've heard you explain it as sort of really giving the reason behind a math problem, for example, that it's very important to outline all of this.
Right. Essentially, if you imagine yourself back on writing the math test when the teacher said, please show your work, it's not necessarily the answer that is the primary concern, but in the legal system, it's how you got to that answer. And so what Her Honor did essentially is come out right off the bat and say, hey, this is my answer. Now I'm going to show you how I got there. And that's what Her Honor is doing right now. She's taking her time and she's going through all of the evidence and she's explaining her position as it relates to all the evidence. And it is taking some time. But remember, this was a 6+ week trial that she's now trying to summarize in essentially a couple of hours. So she's showing her work and she's providing a roadmap to the ultimate judgment that she will deliver.
In terms of the discrepancies we're seeing the justice bring forward as well, how critical is that? Because essentially she is comparing the evidence that was brought forward during this most recent trial in London, Ontario, to a 2022 civil case as well. How critical are those discrepancies in what she's saying EM testified in 2022 versus what the scenario was when she testified in 2025?
Well, her role as the trier of fact is to determine the credibility and the reliability of everything that's happening. And so ultimately what she's trying to do at this point in time is go over what EM had said previously versus what EM now says and compare what she said at one point in time to what she said now. And that is at the heart of Her Honor's decision, because ultimately Her Honor needs to determine whether or not EM was credible and reliable. And she's come out and said that she wasn't. So now she's going through the evidence and showing to everyone who's listening and providing a record as to why she believes that.
In terms of the developments that we saw during the course of this trial as well, and I spoke to you as some of that was happening, because we know that we saw a mistrial and then we saw jurors dismissed, and then this became a judge-only trial in the end. Did those developments, what sort of a difference did those developments perhaps make in what we're seeing today?
Well, I think that the biggest development here is that we get to see what Her Honor has determined. In other words, if it was just a jury trial, the jury would come in after doing their deliberations and they would simply just say guilty or not guilty. And then that would be the end of it. We don't have a right in Canada to hear what the jurors determined and the reasons behind it. It's actually illegal for anyone to inquire, and it's illegal for a juror to say so. So now that it's a judge-alone trial, what we're getting is a roadmap as to what Her Honor decided. In other words, it's a blessing in disguise that we don't have a jury, because it's far more transparent now. And I think that the public needs to hear that. They need to hear Her Honor's reasons. They need more than just guilty or not guilty. They need to hear why. And so I think it's far more preferable now that we have a judge alone, because Her Honor is required by law to give those reasons.
You know, Nick, we know that there has been so much interest in this case during the course of the trial, and even at the start of the day, we saw that there were demonstrators, those who were in support of the complainant, and there were some individuals also who were in support of the accused as well. We know that there has been a secondary overflow room just because of how much interest there is in this particular case. And I'm wondering if you can hone in on for us, some of the reasons why that is. Of course, there's Hockey Canada, hockey culture, also the discussion of consent videos.
Certainly. I mean, there's a lot of interest in this case, I think, because of who the defendants were. But ultimately, this is a sexual assault case. And so the interest comes in relation to the evidence that's been given and this whole notion of consent, which the public should pay attention to, because, of course, consent is an important aspect of our day-to-day interactions when we're interacting in that type of way with other people. And so what the public needs to take from this is that consent is something that doesn't necessarily, I suppose that yes doesn't necessarily mean yes. And that's what the Crown is essentially saying, right? We have these videos where EM is saying, yes, this was all consensual, but the Crown's whole theory was that, well, that yes doesn't necessarily mean yes, which boils down to the fact that anyone who is seeking to have someone else's consent needs to take all reasonable steps to ensure that that consent is present. And there may be times wherein you can't simply just rely upon a yes, because yes may not mean yes. And so this is playing out in the public eye. This, of course, is a case that has seen international attention, and it's very important because it shows that consent is not necessarily a black and white issue when it comes to how consent can be determined. We know that consent has to be there, but the color, so to speak, comes with how it is articulated.
And in terms of that, we know the Crown had said that consent is really the key issue at the heart of this trial, and said that essentially that is a lot of what the allegation is here, is that these things happened and EM alleges that she did not consent to them. With all of this, as you're describing, potential gray area rather than it be black or white, how much of a challenge is it to bring forward and try a case like this?
Well, every case is going to have its challenges, both for prosecution and for the defense. You know, the Crown has the duty to look at each of their cases and determine whether or not they have a realistic prospect of conviction. And they have a duty to do that at all of the twists and turns. And here, it's clear that the Crown thought that they had a reasonable prospect of conviction, despite the consent video that existed. And ultimately, what the Crown is attempting to do is convince the judge that there was things going on behind the camera, that consent may not have been actual consent because of maybe the oppressive nature in the hotel room. We know that there was at one point in time up to 10 individuals in that hotel room with EM. And so that was the Crown's theory. It's just up to Her Honor to determine whether or not she's buying what the Crown was selling.
Nick, I want to thank you so much for your time. And of course, we will have more conversations as our special coverage continues. We know that court is back in session. And as we get developments, we'll bring them to our viewers. That is Nick Cake. He is a criminal lawyer based in London, Ontario. He's been following this trial involving 5 former World Junior hockey players closely and provided us with some analysis. I do want to bring back the CBC's Hilary Johnstone because we are trying to follow along with our colleagues who are inside the courtroom right now in London, Ontario, and we know that they are giving us some of the details of what the justice is reading right now in terms of the reasons for her decision, and that we're refocusing now back on evidence that focuses on the accused or the 2 teammates who spoke, who were in the room but were not accused.
That's right, because there were a number of teammates who did testify at this trial, even though they had not been charged. They were not, even though they were teammates of these 5 accused men, they had not been charged, but they did testify during the trial. And the judge is currently going back over some of their testimony that they testified via video at the time. And like we say, they were not charged in the case. But what we are hearing, the judge going back over the testimony of one of these 2 men, in particular, Tyler Steenbergen, saying that EM, the complainant, was acting vocal about what she wanted sexually in that London, Ontario hotel room back in 2018. That is what the judge is currently going back over right now. She says that another one of these men who testified but who was not charged, Brett Howden, that his memory was affected by alcohol, the passage of time, and a concussion. He testified that the complainant was chirping some of the men and egging them on and calling them out for not engaging her sexually. So going back over that testimony that we heard from some of those accused former teammates. So that's what we're currently hearing. And as we've been saying, just to sort of bring our viewers back up to speed here with where we are, there had been a brief break, maybe about 30 minutes ago or so that started. And at the time of that break, our understanding from our colleagues in the room was that Justice Maria Carroccia was about halfway through delivering her reasoning. And as we were just hearing there, Arthi, from your previous guest, that is unique, that we are going to hear the judge's reasoning into that eventual decision that we're leading up to, because of course, if this had been a jury delivering a verdict today rather than a judge delivering a decision or a ruling, we would not know what their reasoning was. We would never be privy to any of their deliberations, any of their thought process that went into that. So that's where we're at right now. There have been updates from our colleagues who are inside those courtrooms talking about the demeanor of the 5 accused when that break happened, saying that there had been hugging, back patting, 2 of the accused even shaking each other's hands when that break happened, when they were getting ready to leave that courtroom for a brief amount of time. And as we have been also saying, our colleagues inside that room says that it does seem that the players and their family members who are there have been expressing relief ever since Justice Maria Carroccia first started into her decision and saying that she did not find the complainant EM's evidence to be credible. And as you have been rightly pointing out, Arthi, of course, and as our guests have been pointing out, it doesn't necessarily mean that the judge is saying that she doesn't find the complainant to be credible, rather the evidence and her testimony. So an important distinction there as well. So that is where we are at now. It would seem that we are halfway, or at this point a little bit more than halfway through hearing the judge's legal reasoning for that decision that she is eventually going to come to. But certainly the signs, the nature, the tone of the language that she used off the top, saying that she did not find the complainant's evidence to be credible, would lead you, as we've been hearing from some of those legal experts you've been speaking with, to believe that this might be heading in one direction. And just finally, one of the other more recent updates that we've had, Arthi, is from the lawyer of the complainant, EM, saying that she has been monitoring, she has been watching today's developments via video, so not in the courtroom, that the lawyer spoke with her at a break, did not disclose to our colleagues the nature of that conversation, but that she also is anticipating, or this lawyer, I should say, is anticipating reading a statement once the judge does come to that conclusion, does deliver her final ruling.
Okay, thank you for those updates. That is the CBC's Hilary Johnstone reporting. We do continue to bring you special coverage as we continue to cover the sexual assault trial in London, Ontario, involving 5 former World Junior hockey players. An allegation of sexual assault was brought forward by a complainant who has become known as EM. Today, we are hearing the reasons behind the decision given forward by Justice Carroccia, and that is taking place right now in a London, Ontario courtroom. You can see the image of it there. Of course, we've got reporters inside the courtroom who are relaying back to us what is happening right now in court. We know that we are a little bit more, as we heard Hilary mention, a little bit more than halfway through the reasons behind the justice's decision, which we are still waiting to hear in its entirety. But on the onset of her statements and the reasons that we're hearing now, she did say that she didn't find the complainant's evidence to be credible or reliable. I do want to bring back to our coverage Daphne Gilbert. She's a law professor at the University of Ottawa. We understand that we are, of course, hearing now a little bit more from Justice Carroccia, not only about the evidence that has been entered from the teammates, but also when it comes to the statements that was provided from the players, from the accused to police. We know that there were some conversations about whether or not that should be admitted in this particular trial. What did you make of the decision and the impact that had?
So the decision was made not to allow those statements into the courtroom, as the judge found, a previous judge on an application found that they had been obtained in a coercive manner, that the players had been threatened with being banned for life from hockey, and that threat was sufficient to make it a coerced statement. And so that's one of the things that, is underlying this trial too, is that, we are now getting sort of a list of all of the inconsistencies on EM's side, all of the things that she misremembered or changed her story on. But because of the right to remain silent and the fact that only Carter Hart testified in the trial, the players have never had their stories or remembrances put to the same level of microscopic examination. So, what they said is allowed to stand and not end up in court to be dissected. And it's really only EM's memory that has been taken apart. That's the system. That's how our system is, that the accused don't have to testify. But it does, put an added burden on the Crown, who has to try to, cope with whatever inconsistencies EM has without having an ability to point it out on the other side.
And when we are to that point, looking at the statement that was put forward by the justice, she had said that the Crown did not prove its case beyond a reasonable doubt, which of course is incredibly important when we're looking at this. And, I've asked this of a previous guest as well, but I think it's important for our viewers to understand as well that this isn't going to be a decision that is guilty or innocent. It is guilty or not guilty. And that's an important distinction as well.
That's true. There is no way to find out about pure innocence. That's a muddy concept. And so it is simply a finding that the Crown did not overcome the very high burden of beyond a reasonable doubt, which is an incredibly difficult burden. There were multiple pathways here for the accused to end up being acquitted. And, it's not necessarily that the judge will believe that EM lied about what happened to her. It could be that she just cannot reconcile competing stories and that there's just too much confusion in the narrative and she wasn't confident on a beyond the reasonable doubt standard. But I'm still hoping for some language in the decision that points to the behavior of the men and perhaps offers some reflections on how they might have handled that night differently. I'm hoping that we are going to see her look at the men's behavior and point to what it was that they did affirmatively to make sure that they had consent, so that we have a stronger understanding of what it is that she thought took place that night that would have conveyed to them that they had consent.
Now, when we're looking at this particular case, the alleged incident took place in 2018, and then there was a civil case that came forward in 2022, and that is the testimony and the evidence that is being compared against what we saw in the 2025 trial. How important is it for those two cases to be compared when the judge continues to make this decision? Because she has laid out several discrepancies here.
So all that we have from that 2022 civil case is the statement of claim and some of the written evidence that was put in. But that claim was settled without a trial. It was settled very quickly, within a month, is my understanding. And so that evidence was never put to a test in any kind of case. The men weren't even aware that it had happened. It really happened outside of this whole context. It was really about Hockey Canada and Hockey Canada's responsibility for what happened that night. But unfortunately, it did mean that EM had a sworn statement and a sworn affidavit that she could be confronted with in this trial. And in the 3 years since she made that statement, which in and of itself was 4 years after the incident, her memory was not completely consistent. I don't think that's, unreasonable, or that any of us would claim that we would have better memories over 7 or 8 years that would remain completely consistent, especially about an incredibly traumatizing evening and when there was alcohol involved, which impacted her memory. But because we had that statement, she had to admit that she had some inconsistent recollections. And as I said, because the accused don't have to testify aside from Carter Hart, there was no one else who was put under that same microscope.
Daphne, thank you for this. That is Daphne Gilbert. She's continuing to help us navigate the special coverage of that sexual assault trial underway in London, Ontario. I do want to go back to what is happening right now in court. And for that, I want to bring in the CBC's Hilary Johnstone, because we are looking at the live updates coming into us from our colleagues who are in the courtroom right now in London as the justice is reading out the reasons behind her decision in this particular case. And we're speaking specifically about one of the only accused who did speak, or who did testify, rather, was in the witness box. So, Hilary, what have we heard so far on that front?
That's right, Arthi. So Justice Maria Carroccia has now turned to reading out what we heard from Carter Hart, who, like you correctly pointed out there, was the only one of the 5 men who testified in his own defense at trial. He was 19 years old at the time of the alleged assault in June of 2018. Remember that these men were between the ages of 18 and 20 at the time. The complainant, EM, was 20 years old. But Carter Hart was 19 years old. And as we are now hearing, as the judge is going back over some of his testimony from when he took the stand here in his own defense, or when he testified, he had texted when Michael McLeod had allegedly sent out this invitation for others to come to his hotel room at the Delta Hotel in London, Ontario, that Carter Hart had replied in a text message, quote, "I'm in," and also that Carter Hart had asked the complainant if she would perform oral sex, something that EM went on to do, according to that testimony from Carter Hart. Hart had also texted another teammate, a teammate who is not charged in this case, to come to room 209 quickly because he believed that the complainant, EM, wanted to have sex with more men based on what she was saying. Mr. Hart, according to the judge here, also testified that the order of things, the sequence of events, was difficult to remember, also pointing out that Hart, during his testimony, drew a picture for the court showing where each man in the hotel room, where they each were at the time, in relation to the complainant who was on the bed sheet on the floor. He also testified about seeing the complainant, EM, leading one of the other accused, Alex Formanton, to the bathroom, and also testified about seeing one of the other accused, Cal Foote, doing the partial splits over the complainant here. So this is something that we're getting from our colleagues who are in the room right now. Of course, this has been very graphic at times. And as you have been rightly pointing out, Arthi, throughout the broadcast here, that there are resources for people who do wish to seek out resources. Of course, this is quite graphic. I'm just hearing here that there is a new update as well that we're going through. Like we've been saying, this is coming to us from our colleagues who are inside the courtroom. In this case, from our colleague Kate Dubinsky, once again going over Carter Hart's testimony here, saying that he testified that none of the players approached him to compare statements at any time after the alleged assault. Also saying that he learned about the civil lawsuit settlement in 2022 after it happened from his agent. And do remember here, and that's something else that we've been speaking about, that after all of this was alleged to have happened, there then was that settlement, that Hockey Canada settlement, as part of a civil lawsuit brought by EM, brought by the complainant here. Just finally here, Carter Hart had testified that the mood in the hotel room in 2018, in June of 2018, was one of, quote, excitement and awkwardness, and said he would have left the room if anything disrespectful was going on. So those are some of our most recent updates. And of course, if we do have anything else, we will come back and we'll share it with our viewers.
Thanks for this, Hillary. That is the CBC's Hillary Johnstone reporting. And of course, as Hillary mentioned, we do want to take a moment to warn our viewers that much of the evidence and testimony from this trial contains disturbing graphic details connected to allegations of sexual assault. Some of it is unavoidable in order for us to provide you with the proper legal context presented in court. As we bring you the latest from the courthouse over the next few hours here on CBC News Network, you will likely hear some of those graphic details. And if you do need any support, there are lots of resources available. And throughout our coverage, we will display organizations that can help you, along with their contact information. And of course, that help is available for adults and children locally and nationally. Again, some of those numbers are up on your screen now. This is special coverage here on CBC News Network of the decision being read by the justice in London, Ontario, to do with the sexual assault trial involving 5 former World Junior hockey players who were accused of sexual assault by a complainant known as EM. We are right now hearing from the Justice, Carroccia, as she is reading her reasons behind the decision that we are still waiting to hear in its entirety. So as we wait for that, I want to bring in Lydia Riva. She's a criminal defense lawyer and founder of Riva Law, and she's been helping me navigate through what we are hearing in court in our special coverage today. We do understand that the court had turned to the evidence, the testimony from one of the only accused who did testify in court, Carter Hart. How important is it to see here that there was one accused who testified? Meanwhile, we know that the complainant must testify.
One thing that's interesting about this case is that there are 5 defendants. Most sexual assault cases don't involve multiple accused, and it does seem that the defendants in this case did have a uniform defense. In other words, they had the same theory of the case, they approached the case similarly. So it's, given that that's the case, it's not surprising that one of the defendants testified, given that they gave some exculpatory or exonerating evidence about the other defendants. But on the point about the complainant testifying and not the accused, in Canadian law, the defendant has a right to remain silent. It is the Crown's onus to prove its case. The Crown must prove its case beyond a reasonable doubt. The defense does not have the obligation to prove anything. The defense does not have to prove the innocence of the defendants. So because of that, in order for the Crown to prove a case like this, a sexual assault, where the Crown is seeking a finding of guilt that the complainant did not have consent, then the Crown has to call witnesses. And it's not for the defense to then have to rebut the evidence by giving their own evidence. That's not the law that we have.
Now, part of what we understand right now is happening in the courtroom, and I continue to look at the updates from my colleagues who are in London, Ontario right now, and Kate Dubinsky is one of those reporters, and she's saying that at this stage, the Justice, Carroccia, is turning to evidence involving Alex Formanton, who is one of the accused, and he was interviewed by London police in 2018, and he suggested that everything that took place in the hotel room in June of 2018 was instigated by the complainant, EM, including the sex the two had in the bathroom, because that was one of the accusations against Formanton. Also, he told police that he watched McLeod taking a video of EM at the end of the night. McLeod, another one of the accused, is the individual who we understand EM said she initially had gone to the hotel room with. In terms of the comparisons we're seeing here, Lydia, how important is it that we're watching as the Justice dissects all of the different testimony, evidence, statements that have been entered during police interviews, previous statements of claim or civil cases, and then the trial itself?
This is what makes this case complicated, because there's multiple defendants. One of them has testified in their own defense. There's previous statements related to the Hockey Canada investigation, some of which were actually not admitted at the trial. So there's a lot of moving parts in this case, and the judge really has to assess all of the evidence that was admissible to determine whether or not the Crown has proven its case beyond a reasonable doubt. So when it comes to the actual testimony of an accused, the judge has to consider whether or not that evidence is to be believed. If it is, that she must acquit. Then she has to look at whether or not, if she doesn't believe it, whether it raises a reasonable doubt. And if it raises a reasonable doubt, she must acquit. But even then, even if she finds that the evidence does not raise a reasonable doubt, the accused evidence, she still has to look at the evidence of the complainant. So, and that's in the context of the evidence of the viva voce, or the testimony of a defendant. That's how she has to treat that. But then there are statements that were admitted as substantial evidence on the case. She has to determine how that impacts the Crown's case and whether or not that evidence raises a reasonable doubt. So she has to do all of that with all 5 defendants, with all specific acts that have been alleged in this case. So that's what makes it so complicated.
Lydia, I want to thank you for joining us for a special coverage today. That is Lydia Riva. She's a criminal defense lawyer and founder of Riva Law. As we continue to monitor developments, I want to bring back the CBC's Hilary Johnstone. She's in our newsroom, and I was just mentioning one of the updates that we saw there to do with police interviews from both the accused Alex Formanton and Michael McLeod.
That's right. So let's talk a little bit more about that, because what the judge is currently going over right now, according to our colleagues who are in the courtroom, is the testimony that we had heard from the Crown's witness, Stephen Newton. He was a retired London police sergeant, and he was the original detective that originally looked into those allegations in June of 2018. That case was closed in early 2019 without charges being laid. But he also testified as part of this trial because he had gathered voluntary statements at the time from some of those players. And some of his interviews, such as his interview with McLeod, Formanton, and Dubé that were conducted in the last couple of months of 2018, they were then played in full in court. And that was the first time that we'd actually heard from some of the accused players in this case. So as we understand it right now, currently going back over some of that London police sergeant's interviews. And I can bring you a little bit more here. I'm just letting this sort of update here from our colleague, Kate Dubinsky, that Justice Maria Carroccia is going over in particular right now Michael McLeod's interview with police, including those 2 consent videos that had been recorded, that he had recorded of EM, of course, which have been central to this case at times. I believe what you're looking at right now, you heard a little bit of volume there, was McLeod and Formanton, some of these accused, as they were coming into court this morning. But what we know from the testimony of that London police sergeant was that McLeod had told police that he took those videos to ensure he had proof that she, as in the complainant EM, wanted everything that happened that night. He also told police that EM was instigating the sexual encounters, and he was, quote, shocked at how sexually forward she was being. So that is one of the updates that we're getting at this point. Michael McLeod also told police that his teammates came to to his room because they wanted food and he had denied sending a text message inviting them over to have sex with the woman, with the complainant that was in the same hotel room. So what we have here, quoting McLeod as he was saying this to this London police officer, quote, "She was leading the way and was asking for things." So that is what the judge is currently going over right now. And I just see another update, Arthi, that's come in from Dylan Dubé, his police interview. During his interview, an audio recording of it was played out in court during the trial. He told police he was shocked at how EM was talking to the men, and that if quote, if things were bad, he would have stopped and kicked the guys out. So this is sort of what we're going through right now, just to sort of give our viewers a sense of what is currently happening. We are more than halfway through the judge's reasoning at this point, because we were at the halfway point when they took a break more than an hour ago. And right now they are getting into the testimony, what we heard from some of those players in those original police interviews from that first investigation that did not result in charges back in 2018. And just remember here that Carter Hart was the only one of the 5 accused to testify in his own defense. A few minutes ago, the update on that point was that they were going back over some of his testimony. So just a few more updates for you there, Arthi, and of course we will continue to monitor them as they come forward. And certainly that video, those consent videos, I know you've been speaking with your guests, with your legal experts about them, about what consent means in Canada, what it does not mean. A lot of your guests, of course, have been pointing out that you cannot in Canada give consent after the fact, which is part of the reason why legal experts are so interested to see how the judge uses those videos as part of her reasoning or her decision as we lead up to that final ruling.
Okay, thank you for this, Hillary. That is the CBC's Hillary Johnstone. And as we continue to special coverage of the reasons being read out by the justice as she makes her way to the final decision when we're talking about the sexual assault trial involving those 5 former World Junior Hockey players. I do want to bring in Nick Cake. He's an experienced criminal defense lawyer based in London, Ontario, and he's provided his expertise to our program many times in the past when there have been so many twists and turns around this as well, and you've been following this closely. Nick, thanks for joining us again. We know that the judge is more than halfway through reading out the reasons behind her decision. It is important to note here, of course, that she hasn't weighed in on the evidence, so to speak, but is listing it out at this stage as what it is that she is specifically looking at. But a reminder for our viewers that as she began reading this all out, her first statement was saying that she did not find the complainant's evidence to be credible or reliable. So, Nick, as we know that right now the evidence hasn't been weighed in on, what are we leading up to as we get close to the end where we will hear the decision from the judge?
Well, what Her Honor is doing right now is she's laying out the foundation for her decision. So these are the facts, the evidence that she heard over this 6+ week trial. And she will then take a turn and now start applying those facts to the law, to the precedent-setting cases that have come before this case in order to establish what weight she gives to credibility and reliability. We know where she's going to go, at least as it relates to EM, because she already says, as we know, she came out of the blocks and said, I don't find her credible or reliable. So now she's laying the groundwork, and now she'll apply the law to the facts and ultimately show why she has found what she has found. But she needs to do that. Her Honor has a responsibility, a legal responsibility to show her work, to provide that roadmap. And you can't do that until you show that you have an understanding of what it is you've heard throughout the trial.
Is there anything that stands out to you specifically in this case? Because certainly we have read a lot that this could potentially be precedent setting. We have seen the submission of consent videos, which we do not know whether or not the justice found them to be of value in this particular case, because there have been a lot of questions about them specifically, but also the individuals involved and the fact that there was testimony from 2022. How does this complicate everything as we head towards that decision from the justice?
Well, I don't think that this case is going to be precedent setting for any type of new definition of consent. Ultimately, what Her Honor is doing is she's looking at all of the evidence, both what was said in the courtroom as well as what was said in past cases, in that civil case, or back when the original interviews were given contemporaneous to the event happening in 2018. All of that is open season, so to speak. It's all available to Her Honor. So she's going to use that and determine whether or not consent was present. Again, I don't think that this is going to change the nature of consent. We know what consent is. Consent has to be present at all times throughout. It cannot be given after the fact. It can certainly be affirmed after the fact, but it needs to be present before the activity starts. It needs to be present at every change of direction, so to speak, during the activity. But ultimately, what I think will change here is the culture surrounding sexual assault and sport, and the fact that, there may be reasons not to get involved in that hotel room scenario, and maybe we'll look to our athletes, both our male and our female athletes, to conduct themselves in potentially a more appropriate manner. It may not have been the most appropriate thing to do in that hotel room, but I think what we're learning today is that it was not a crime.
We do await the decision from the justice. I want to thank you, Nick, for weighing in. That is Nick Cake. He is a criminal lawyer based in London, Ontario. We are continuing our special coverage this hour of the decision to come from Justice Maria Carroccia, who's delivering her decisions in the London sexual assault trial of the 5 former World Junior hockey players in 2018 involved in an alleged incident that was brought on by the complainant EM, as she is known. What we know is the justice has said that she didn't find the complainant's evidence to be credible or reliable, and that the Crown did not prove its case beyond a reasonable doubt. To that end, though, we do not yet know the full decision that will be laid out by the justice. We know that the justice has spent much of the time so far going through evidence heard at trial earlier this year, and also focusing on discrepancies between EM's evidence this year and her civil lawsuit in 2022. There will be implications for Hockey Canada, as there have been already. Our special coverage of the decision being read out by the justice continues now on CBC News Network with my colleague.
Hello, I'm Andrew Nichols. This is CBC News Network. We continue our breaking coverage of the judge's decision in the Hockey Canada sexual assault trial. This is the courthouse in London, Ontario, where Justice Maria Carroccia has been delivering her ruling. We have reporters and producers there bringing us all the latest information. And the CBC's Hilary Johnstone is at our breaking news desk tracking the latest updates. So Hilary, take us through the latest threads coming out.
Well, Andrew, these threads, this information is courtesy of our colleagues who are inside the courtroom and the overflow room as well, and they are providing us with these up-to-the-minute updates, which I do encourage our viewers who do wish to follow this along in greater detail. There is a live page on our website and also on the CBC News app. But at this point, Justice Maria Carroccia is going back over some of the police interviews, some of the testimony that we heard in some cases from the one accused who did testify in his own defense, in other cases from their former teammates who testified as well, going back over some of that information. One of the more recent updates we have is Dylan Dubé's police interview. Justice Maria Carroccia going back over that audio recording right now as it played out in court during that trial, during that 8-week trial. Dylan Dubé had told police that he was, quote, shocked at how the complainant, EM, was talking to the men, and that, quote, if things were bad, he would have stopped and kicked the guys out. Referencing here, of course, that alleged assault that took place inside that London, Ontario hotel room at the Delta London Armories in June of 2018. after the complainant, who is known as EM because of a publication ban, had met Michael McLeod at a bar called Jack's in London, had gone back to his hotel room. That encounter is not what was focused on here. What was focused on was what happened after that, allegedly inside that hotel room. So some of the most recent updates, like we say, involving that. Now, I'm just seeing, Andrew, as we're speaking, another update here coming to us from our colleague Kate Dubinsky, who is inside, saying that the judge here, so Justice Maria Carroccia, is currently summarizing the Crown's position, including the prosecution's position, that any inconsistencies in the complainant's testimony were minor and on peripheral issues, saying here that the Crown had contended that other evidence corroborated by EM's evidence, also saying that EM didn't have any motive to lie and that the consent videos prove McLeod, one of the accused, knew she didn't consent and made her record them. So just a reminder for viewers, of course, who might only just be joining us right now, that one of the things that has really been focused on in the last 20 or 30 minutes or so were those videos that Michael McLeod had taken of the complainant EM after the fact, where she is asked on video, or where, according to her, she was told what to say, saying that she was okay, essentially, to paraphrase, with what had happened. And what we have known from legal experts who we've been speaking with out the day, that in Canada, of course, that consent is not something you can give after the fact. So that has been something that has really been focused on in the past 20 or 30 minutes here, Andrew, talking about the police interviews, talking about those videos that were taken as well, and all of this leading up eventually to the judge's final ruling. That is something that we do not have yet, but certainly at the outset, when this started shortly after 10 a.m. Eastern, she had said that EM, the complainant here, the evidence that the complainant had presented, in her view, was not credible or reliable. So certainly that tone, that language would lead you to think that this might be heading in a certain way, but that is something that we will continue to monitor and to look for updates on.
Yeah, absolutely, Hillary. It was certainly interesting that that was how this judge began her remarks, with those comments to the court, but we are waiting for her decision, and that is something that we'll be watching all afternoon as she, as is custom, goes through the testimony of this important trial. Recap what else the judge has said.
Well, and something you just said, which is important to point out as well, Andrew, when we're talking about what we've heard from the judge over the past couple of hours, is that this is unusual. This reasoning, this sort of insight into how she is coming to her decision, is something that we would not have seen if this had been a jury delivering a verdict today. And that is because after a mistrial, the second jury is brought in just a couple of days after this trial first got underway in late April, and after an interaction, or after one of the jurors, I should say, went to the judge and had said that a member of one of the defense teams, in their view, had been mocking the jury, it was decided that this trial was going to proceed, but with a judge alone. And in Canada, juries are not allowed to talk about their deliberations, what went into their reasoning, but because this is a judge, that is why we are hearing this reasoning. And as we've been saying, we've now been listening to it for nearly 3 hours at this point. And she, right off the start, right off the top, had said that she did not find the evidence of EM to be credible or reliable. As legal experts throughout the day on our programs have been noting, that doesn't necessarily mean that she's saying she doesn't find the complainant reliable, rather some of the evidence that she presented to be unreliable or not credible. So after she said that, from our reporters in the courtroom, we understand that it would seem that the players were acting in a way to show that they were relieved, that there were gasps, that the parents of some of the players who have been there, who have been following this trial in the courtroom, that they were in tears at some point. So that was certainly sort of a dramatic development at the start. And now, since then, since we heard that from the judge at the start, we've been listening to the details of her reasoning, starting off by going back over what we heard from the complainant EM, and then going over what we heard from the only one of the accused who testified in his own defense, going back over what we heard from some of the former teammates of the accused who were not charged in this case, and more recently been going back over the police interviews that some of them had done. Because remember, this is alleged to have happened in June of 2018. In the days after that, the London Police, Hockey Canada, all notified. The London Police sergeant who originally looked into this had interviewed a number of the players in early 2019, had closed that investigation without charges, but had been going back over that London Police sergeant's testimony as well. That's a lot of what we've been hearing. And finally here, Andrew, something else today. At the break, because there was a break about halfway through the judge giving her reasoning here, and one of our colleagues in the courtroom spoke briefly with the lawyer representing the complainant here, EM. EM, we're told, is watching all of this today via video link. The lawyer did not disclose the nature of their conversation during that break, but also said that the lawyer anticipating that they will read out a statement on behalf of EM once we do have the judge's final ruling here.
And Hillary, let's just talk a little bit about the courthouse that we're looking at and the interest in this case. It was supposed to begin at 10 a.m. Eastern time, but the interest, there are overflow rooms. I mean, that courthouse may not look like it from this shot, but that's because so many people are inside watching. I think 150, something like that, people in the courtroom. There's overflow rooms. Tell us just a little bit about we can see the barricades outside. I mean, this is really quite a moment.
That's right. So they're on this particular courtroom where all of this is happening is on the 14th floor. So quite a large courthouse. There are 2 overflow rooms. One of them has at least 150 people in it because we know it hit capacity. There was then a bit of a delay at the start while they opened a second overflow room for other members of the media who weren't able to get in at the first overflow room, and for members of the public as well. And when you're talking about some of the interest here, Andrew, even before this started today, when the 5 accused and their family members were coming into the courthouse, we know from our colleagues who were on the ground reporting that there were people there outside who were supporting the complainant, and there were at least 2 people who were there supporting the accused as well at times. So that's sort of a bit of a scene of what it's been like inside the courtroom. And I understand that there is just another update coming to us. And once again, just for people at home who are wanting to follow this in greater detail, our colleagues, of course, there is a bit of a live feed on our website right now. The most recent update from just a couple of minutes ago shows that the judge is currently going back over Michael McLeod's defense team's position, saying, and that defense team had said that the Crown's case rests entirely on EM's credibility and that she is not credible or reliable. So that's what's currently happening right now. The judge going back over McLeod's defense team's position. Remember here, Andrew, that of the 5 who were accused, who were charged, Michael McLeod was the one who was facing that additional charge of being party to an offense for his alleged role in facilitating the assaults. And all 5 of those men have maintained their innocence. All 5 pleaded not guilty.
And just as a reminder, the 5 men we're talking about are, of course, former members of Team Canada's World Junior Hockey team back in 2018. Hillary, thank you. The CBC's Hillary Johnstone live in our newsroom. So for some legal analysis, we're joined by Rishi Gill. He is a criminal defense lawyer and a former Crown prosecutor, and he joins us now from Vancouver as you look at the scene outside that courthouse in London, Ontario, live. Rishi, good to see you. Thank you for taking the time. Based on what we know so far from the judge's statements, especially the judge's statements almost from the very beginning. I mean, for her to come out and say that she didn't find the complainant's evidence to be credible or reliable and said that the Crown did not prove its case beyond a reasonable doubt. What did you make of those comments coming out early as the judge began delivering her decisions?
I think because of the high-profile nature of this case, I think the judge wanted to, right off the bat, so to speak, say what the ultimate finding is going to be. Most times when lawyers are receiving decisions or decisions are coming off the bench, the court will not do that whatsoever. They will go through the evidence, and you can kind of glean where the judge might be going by what evidence they're accentuating or not accentuating, where the ultimate result will be. But in this case, I think the judge certainly wanted to get that off the table and then deal with the evidence and just lay it down. I think that's not a normal course of events. I wouldn't make much of how she did it off the top. I would say that certainly in sexual assault cases that I've been involved in, and I have nothing to do with this case, that it's not common oftentimes for the judge to dismiss the reliability or credibility outright. Oftentimes it'll be the court saying, well, I just don't know what to believe here. In this case, there was a specific finding that dealt with the reliability and credibility, but that's not saying this person, the complainant, came here with a negative intent, or that she's, this is some sort of con. I think that she is just saying, based on the law and the evidence that's gone through, there's some problems that the court is facing, making it.
So, Rishi, I think you're making an interesting distinction. So let me just ask you more on that. What you're saying is that the judge can say the complainant's evidence is not credible or reliable, and the Crown can't prove its case beyond a reasonable doubt. That is not saying the complainant herself is not a reliable or credible person. That's not what she's saying, right? This isn't just strictly in a kind of a legal realm.
Exactly. This is all in a legal realm. It's not the real world in one sense. And I don't mean that in a respectful way. When you're in court, especially in criminal courts, it's not the way that the evidence has to play out is very technical. There's a lot of different rules. It's very strict because of the consequences. So I think what the audience needs to understand, and this is crucial, is that there's this misconception oftentimes that this is about finding out what happened absolutely. And it's not. The criminal trial process is about the Crown being able to prove their case beyond a reasonable doubt or not. When somebody is acquitted, that is not a complete exoneration insofar as saying this person did not do that, this should have never happened, they are as innocent as snow. It is saying the Crown has a heavy burden, that burden never shifts, and the Crown wasn't able to meet that burden. That's as far as it goes, and there's very few cases where a judge is going to come out and say, this is outrageous, it should have never got here, and this complainant was a liar, the other side is completely telling the truth. That's not how the system works.
It should be pointed out, Rishi, but I'll ask you your opinion. I think you're implying this. We have not heard the judge's decision, but based on what she has said so far, tell me what you expect her decision to be.
Well, I would be shocked. I mean, unless I've missed something. I've been following the coverage, and I would be shocked if there was anything other than acquittal at this point.
On all charges?
So, well, the only charge I would say there could be something, but I would think that would be difficult given how this is played out, is potentially on Mr. McLeod being a party to something. But I think that right off the bat, the judge making those findings of credibility do indicate that this is going to be an acquittal.
So you've been both I just want to ask you, because you've been both you're a former Crown prosecutor, now you are a criminal defense lawyer. So just as you've heard this and followed this trial, tell me about how you feel both sides presented their cases.
I think that I know by reputation some of the defense counsel, and I think that the defense counsel is quite well regarded. I think what I'd say is they're all very competent lawyers. I think that they would have assigned their top prosecutors to a high-profile case like this. I think the case came in as best it could. There's a saying in law that the lawyers don't build the planes, they fly them. And ultimately, both sides are left with facts that have been determined. And I think what's crucial about this case is when it started, it had a profile just at the outset when the investigation started at the very nub of it. But there were some evidentiary gaps that happened, and this case became quite complex because then you had the Hockey Canada investigation. There was a separate proceedings. Then the police decided not to recommend charges, and then they went in a different direction. So it was an unwieldy set of facts, and it was not going to be the easiest prosecution.
All 5 of the players' defense teams agreed to a judge-only trial after the discharge of the second jury. Do you think things could have played out differently if there was a jury?
Possibly. I think that was if I was the defense on this case, I would have certainly been quite happy with the judge alone trial by that point.
Mm-hmm.
I'm not going to say that the jury would have gone a certain way, because I think the evidence was problematic at the outset, and I do think juries get things right ultimately, but I would have certainly been happy if I was defense counsel running this case, taking the judge alone trial.
If the players are found not guilty, do you think it's likely that the Crown will look to appeal the decision?
Appeals are hard from the Crown perspective, especially on cases like this, because when it comes to credibility and reliability issues, the field is very narrow as to what the grounds of appeal would be, and especially for the Crown. The Crown has a different obligation and burden in some of when they're doing appeals on acquittals. I think that they will look at this extremely carefully, and if there's an appeal to be had there, they'll take it. But the Crown generally has an extremely high quality control on what they appeal. They certainly don't want to be setting a precedent if they can avoid it, whereas defense counsel will be, I would say, respectfully to my colleagues in the defense bar, they'll be a bit more haphazard, less strategic on what they appeal, because it's more independent operators running different offices, whereas the Crown speaks with one voice.
Rishi, good to speak to you. Thank you very much. Rishi Gill is a criminal defense lawyer and a former Crown prosecutor live in Vancouver.
Thanks, Andrew.
You're looking at the scene live outside of London, Ontario, the courthouse, where we are continuing to follow the judge who is delivering her decision. And we've heard her go over it right now. She has been going over the testimony of the accused and indicated, as we mentioned at the beginning, that she did not find the evidence presented by the complainant to be credible or reliable. So we'll see what her decision is. She has not delivered her decision. That is still to come. I now want to bring in Cassandra DeMello. She is a criminal defense lawyer and joins us live from London, Ontario. So Cassandra, from what has come out in court so far, what has stood out for you from both the prosecution and defense perspectives?
Yes, good afternoon. Thank you for having me. I can tell you that from the prosecution side, they certainly were trying to take a case that was not clear in facts in terms of what we've ever seen before, and definitely not at this scale, not on this global scale or even this national scale, if we want to not get too ahead of ourselves, and probably push the envelope a little bit. It's about when is something consensual and when is it not, and even if it sounds like consent, you know, how many more steps do you have to take before that is a reasonable assumption to come to if you're the defendant, right? And so I really do think they were pushing the envelope here, and I can understand it in some facets, but I also think that it was a tall order for them in a lot of ways. For the defense and the different defense counsel, their job was quite simple and quite straightforward. Look at all of the different statements from all of the different people, including the various statements from EM, and show why, poke holes in why that is not credible or reliable or shouldn't be trusted. And so what I often explain to clients is that the Crown is trying to build a brick wall, and what we are doing is trying to take away a brick here or there, enough that the wall is just unstable enough that there's doubt about whether or not that wall should be relied on. And so that's the defendant's job, if there's any job. Again, reminding everyone listening who might not be so familiar with the justice system that it's proof beyond a reasonable doubt, and the Crown has to get there themselves. They have the onus of showing that. The defense theoretically could show up and do absolutely nothing. It's the Crown that needs to prove that. But as defense lawyer, who's of course our job is important, and our job is to help the judge see what we are trying to say or see what the defendant is trying to say, that's how we effectively do that job.
And so, Cassandra, tell me why, from your perspective, you think, and again, we're still waiting for the judge's decision, but for her to come out and say that she found EM's evidence not credible or reliable, why do you think the judge seems to be heading into the direction of what could be an acquittal?
I think that there was a lot of issues with the complainant's evidence, and that was starting to become clear early on as her evidence played out. The slow changing of the storyline, how it started with it wasn't consensual because I was too drunk, and then the Crown having to wrestle with the fact that, well, how is she consenting to sex with Maddie McLeod the first time? How does she have enough of her wherewithal to consent to that, but then not to the things after that? And as I understand it, that's why the first investigator didn't lay charges at the first instance, because that was a really tricky and gray area that he was like, I don't understand how you could consent here but not later, especially when there's been no added inclusion of alcohol. Some time has passed since her last drinks. It didn't quite line up. And so then when Hockey Canada settled the case, then the narrative changed a bit. By this point, EM has had an opportunity to see the other pieces of evidence, or perhaps hear about them at least. She's been confronted probably about some of the things that aren't quite lining up with her narrative so far. And you see a shifting of the narrative to, well, I actually wasn't consenting because I was intimidated and I felt overwhelmed, or I felt like I had to say yes because they were intimidating. And I took on this porn star persona, right? And maybe that is true. Maybe that is absolutely a trauma response. And that is now, with time and with healing and with counseling, she's been able to come to that realization that that's what that was. But when you start with one kind of narrative and it starts to slowly shift to another, what that does is it helps the defense show or highlight, hey, which one is it? Because it seems to be that it was this first, and now it's slowly evolving and slowly shifting to this other thing, and you know, she's clearing up things, or even sometimes being completely inconsistent or contradictory on other things that we're suggesting to her. That's enough to probably show you some reasonable doubt, Judge. And I think that's what's happening here.
And I want to ask you, Carter Hart, the former, one of the 5 former players, is the only one to have testified at this trial. What kind of role do you think that could have had in the judge's decision-making that's coming today?
Yeah, that was a great call by the defense. And I say that because the statements from the other players that were taken, not all of them gave statements to police, but the ones that were, those were entered by the Crown as part of their case. And those get to be accepted at face value, both for the good parts and the bad parts. The Crown has to take those statements as they come. What Carter Hart was able to do was go in and provide an opportunity for the judge to hear some evidence right off the hop from one of the players directly, and then have that evidence tested in court in a way that was showing that perhaps they weren't afraid of, of talking about it, or they wanted to confront it. At least one of them wanted to get their side out there once and for all in court. And I think that it was the right play, because if you put all 5 of them up, then of course there's always the opportunity that those don't line up, or one of them does a poor job in cross-examination, and that causes some concerns for the judge. And so I think having one of them testify was the right call. It's probably also all that was needed, because all of them are involved in the same event and in the same transaction. And then you've got the other statements from 2 of them, I believe it was, that from right after the event at the police station, and all of those things in conjunction paint the other side of the picture, which is often what happens here. There's one person's side, there's the other person's side. It's not supposed to be in criminal law competition between those two, and many of us who practice in this area understand that the truth typically lies somewhere in the middle. Not always. There's always going to be very obvious cases where there is a victim and there is an accused, and that accused has done something very wrong. But I think sexual assault law is one of those times where we get more and more into the gray, and this was a perfect example of that case.
Let me just ask you, Sandra, you are a lawyer. You are based in London, Ontario. I mean, have you seen anything quite like this in recent memory? The interest, the level of interest, the overflow rooms, what's it like as a lawyer, but also just as a resident of London, Ontario, and having so much of the focus around this trial?
Yeah, it's, as a criminal defense lawyer, as a law geek, for me, it's interesting. I find it fascinating. I think it's kind of cool, if I can put it that way. But obviously, it's not what London wants to be known for. We don't want to be known for, here's where you come and have a drunken good time and questionable things happen. So I know our community is really invested in it. I know the issues with the jury, the 2 juries that were discharged, just kind of, to me, that's indicative of that. I think that London has definitely shown an interest, and there's there's people on both sides supporting EM, supporting the accused. There's a lot of people who felt that these accused were, part of cancel culture and they didn't have a fair shot. And so much like the thought process of the rest of the nation, I'm sure, and the rest of the world to a certain extent, there's definitely people who fall on both sides or fall somewhere in the middle and they don't know who to believe or what to believe. But here in London, I can tell you that it just feels that little bit more punctuated because of the fact that we're here. I mean, I can't find a parking spot outside the courthouse these days. And there's the days that EM was testifying, and today as well, I had to walk in past a bunch of protesters, and that's fine. That's everyone's right to free speech, and I support that, and I believe in that 100%. But it's interesting. It's definitely something cool to be a part of, or different to be a part of.
Cassandra, good to speak to you. Thank you very much. Cassandra DeMello is a criminal defense lawyer in London, Ontario. And let's go to the CBC's Ali Chiasson, who's outside the courthouse in London. And Ali, you've covered this story extensively and have been there all day. What have you been seeing and hearing?
Well, Andrew, I just wanted to give you an idea of the scene so far as the judge has been reading out her reasonings for her eventual rulings here. So the EM supporters, actually, they left hours ago. They did leave up a banner that says, "We stand with survivors." Right now, most of the people you see out front are members of the media who are milling about. They are waiting for eventual scrums. They are also waiting to catch a glimpse of the accused hockey players as they leave the courtroom once Justice Maria Carroccia wraps up her rulings. We are hearing word that the EM supporters plan on coming back this evening after the judge makes her final decision, and likely after the defense attorneys start scrumming. At least two of the defense attorneys, one for Alex Formanton and the other for Cal Foote, say that they plan on scrumming, speaking with the media, but they don't intend on taking any questions. We've also learned that Megan Cunningham, the Crown attorney, will speak to the media as well. Maybe we'll get an idea of if this goes the way that people are thinking it's going with 5 acquittals. We'll have an idea. We'll at least ask Megan Cunningham, the Crown attorney, whether they intend to appeal the decision. So the EM supporters not here right yet. They plan on coming back a little later for a rally. We also spoke with the lawyer for EM, so we're expecting to hear from EM via a statement being read out by that lawyer. So that is some of the information that will come after the judge's official ruling. I know that we initially said it was going to take hours. It has been so far, but she has been reading through at a pretty decent clip. So we will be ready with the live breaking eventual ruling when those two come down. Back to you, Andrew.
And Ali, let me just ask you, you've been telling us a lot about what's been happening outside and what's going to happen. You know what's going on inside because our reporters there are obviously giving you the information. Can you just give us a sense of what's happening inside the courtroom, the level of interest, the heightened level of interest, the overflow of rooms that I was mentioning?
Well, actually, everybody is really hanging on to every word of Justice Maria Carroccia's rulings and the reasoning that she is given, or giving, I should say. There is a lot of going over testimony that we have heard, going over closing arguments from the Crown attorney and going over the closing arguments that were lobbied by the different defense attorneys as well. So there is, on one hand, repetition. We have heard a lot of this stuff before, but still, though, everybody, whether it's members of the media, whether it's members of the public who are just interested in this case, or members of the law community who have been watching along, they are listening to every word, just waiting for that final ruling. Back to you.
Ali, thank you. That is the CBC's Ali Chiasson live in London, Ontario. We will check in again with her very soon. So how could today's decision affect Hockey Canada? The CBC's Jamie Strachan has been following this trial closely and joins us now here in studio. So Jamie, Hockey Canada has faced a reckoning, I think you could say, since EM's lawsuit became public. What impact could today's rulings have on the organization?
I think a couple of things to kind of look at here. I think what's already happened to Hockey Canada. I mean, a lot of things were found out about what Hockey Canada was doing in terms of how it was going about handling these kinds of complaints involving sexual misconduct, how it was taking money from dues that parents like me pay every year for our kids to play hockey, and having a slush fund that was being used to pay out settlements in some of these cases. That's changed. I don't think we're ever going to see that happen again. And there's been transparency in terms of what Hockey Canada does with the registration fees that parents pay. For example, if you have a child that plays in the GTHL, which is the biggest hockey league in the world, you pay your fees to play with your club, but you also pay a registration fee of I think around $800, maybe a little more. And now there's a little bit more transparency in terms of where that money is going. In terms of its leadership, initially we saw the leadership of Hockey Canada try to weather this, say, listen, we've got this under control, we're going to make changes. We saw some of those fiery exchanges that leadership had when they were called to testify before Parliament. We saw a whole new board at Hockey Canada and promises to change. But I think you have to be clear on what exactly Hockey Canada has power, what it has purview over. It's a national sport organization, so it can make changes in terms of if you are playing on a team, on a World Junior team like this one, going forward, representing this country as a youth on an international team, you are going to get some kind of training around consent. There's formalized mandatory training that's gone in place there. In terms of what's happening across the rest of the country, where Hockey Canada can suggest, it can cajole, but it can't implement, I think suggesting that there's going to be this fundamental change in hockey culture is a little bit, naive, because it's still very piecemeal in terms of how different organizations choose to deal with things that exist off the ice. I mean, the way that we develop hockey players in Canada is an important part of this discussion. Unlike the other sports where, you are drafted into the professional system, after college, usually around 18 or 19 years old, in hockey, you have, kids that are drafted into the Canadian Hockey League, the OHL, the Western Hockey League, the Quebec Junior Hockey League. They're drafted 15, 16 years old. They go off to smaller towns across the country where they are lionized. They're legends and kings in the community. That's what hockey culture is. What those individual teams are doing to teach those kids about how to act properly, what consent means. There's no uniform system, module, speaker. A lot of teams are doing great work on this. Others aren't doing anything. But, some would argue that, is it the job of hockey teams to provide this kind of guidance for young people? Should that come from schools? Should that come from their parents? What role does junior hockey, does minor hockey have in talking to players about consent? But I think that it's become part of the conversation, a real part of the conversation, whereas, before, teams are focusing on what's going on the ice, developing hockey players, talking about the power play. But I think now when someone in the organization says, listen, this has to be a piece of what we are doing, I think that person is taken seriously. I think that's what this case has changed.
Yeah, absolutely, and it's a societal conversation, a whole of society conversation as well, of course. We've seen players return to their respective professional sports leagues after being acquitted in a court of law. We should mention that the judge has not released her decision yet, but there does seem to be a suggestion that it could be leaning towards an acquittal of these accused. Could that happen again in this case where these players could return to professional teams, maybe the NHL?
Unequivocally, yes. I think, one lesson that we have learned in looking at criminal misconduct, bad behavior amongst professional athletes, if you can shoot a puck, if you can shoot a basket, if you can catch or throw a football, if you can hit a baseball, there is a seat for you at the table. That's a lesson that we've learned. 99% of the cases, there is a road back. And I think in this case, if there's an outright acquittal, which is, that seems to be where this is going. You look at someone like Carter Hart, who was one of, the top goaltenders, in the NHL, there's a seat at the table for someone like that. There may be some reticence by some teams to bring a player into the fold. But I think, like I said, the lesson that we've learned when it comes to professional sports is if you are not incarcerated, if you have not done something that's egregious that was caught on video, and even in those cases, sometimes there's a road back. If you are good enough to help a professional team, there is a road back from you. I think that's what we've seen time and time again.
Yeah, would you make the distinction between a road back to a team in Canada versus a team in the United States? Given the high level of interest, these were former World Junior Team Canada players.
You know, for sure. I think some teams in Canada may think twice about signing one of these players. I mean, I think back to a player on the Toronto Blue Jays a number of years ago, a pitcher that they had that was accused of sexual misconduct. The Blue Jays said, you know what, you don't fit into this community anymore, and they traded him, but the Houston Astros took him because they thought that they could help their team. I think if some team out there, maybe not, you know, one of the teams playing in Canada, but one of the teams in the NHL thinks that one of these guys could be someone that can help their roster, I think there's no doubt that history tells us that there's a place for people that have had run-ins with the law, that have even had their cases come before the courts. There is a road back. We've seen that before.
Jamie, thank you. The CBC's Jamie Strachan. I just want to let our viewers know that I've just been told that they are on another 15-minute break as the judge continues to deliver her decision in court. This is the scene outside the courthouse in London, Ontario. The judge has been delivering her decision in court since around about 3 hours now, with a couple of breaks, but we are now on a 15-minute break as people gather inside and outside the courthouse in London, Ontario. For more legal analysis, let's bring in Laura Metcalf. She is a criminal defense lawyer and women's director of the Criminal Lawyers Association. She joins us from Centre Hastings, Ontario. Laura, appreciate you taking the time. Thank you.
Thank you for having me.
What do you make of the judge not finding, and saying this early in her remarks, EM's evidence credible?
So what I make from that is that the trial judge is essentially applying the rules of evidence as I would anticipate and hope that she would in a case where you have a video where the complainant's demeanor, the way she's acting, is fundamentally at odds with her evidence about why she says she was not in fact consenting. And that is very different, by the way, than a complainant who says, for example, I'd had some drinks, I hadn't really made a decision, I was uncomfortable, and I didn't know what I was doing. In that scenario, there is an absence of consent, and I would expect that element of the offense, one of the two elements that must be proven beyond a reasonable doubt, to be met. But in this case, you had a complainant who was saying that the very reason she's sure that she was not consenting is because of this fear and terror that was going on in her mind. And that is not only inconsistent with the actual video, where we see her demeanor quite differently, but it's inconsistent with other statements that she's made. So I take from the judge's decision to start and lead her decision with that critical information, i.e. the first element of the offense that needs to be proven, to essentially be signaling to the lawyers and the accused who have been on trial for and had this hanging over their head for quite some time, what the bottom line of the ruling is going to be before they endeavor on what at this point I think is 3 hours and 40 minutes.
Yeah, I mean, 3 hours and 40 minutes. They're on a break right now, and so this is taking a while. I don't know whether this is standard. I mean, there were, 5 players accused, so going over all of the testimony. But interesting, or you tell me, interesting that the judge kind of made that statement about the credibility or not finding the evidence presented to be credible at the beginning of her remarks in a trial as public as this one, where there's heightened interest. There's got to be a lot of pressure from the public. How do you think the judge has handled that so far in delivering her decision? She's not finished, but delivering her decision as we know it so far.
So I would say two things. The first would be that she's handling it remarkably. It is no small feature to have to be the presiding justice in these cases that we see every now and then where the entire public is watching. And when you have an intense pressure because of laudable social movements where the public, or a large part of the public, is expecting the verdict to go a certain way, that's an immense amount of pressure on the judge to sit there and actually apply these principles and bedrocks of our justice system that are so crucial to protecting against wrongful convictions. So I think on the aspect of starting out by saying I do not find the complainant credible and reliable at the outset, as opposed to explaining her reasons and then having the accused wait for the 3.5, 4 hours for the bottom line is quite courageous, frankly. And then I would say that in response to your note of whether this is usual or unusual, it is usual in highly public cases where we're all watching. We've had a couple over the past couple of years. And in those cases, I find that the judges take a lot of time to go through their reasoning in order to help the public who's not just interested in the bottom line, but who's fundamentally interested in understanding whether what occurred was right or wrong. They're taking time to explain principles that maybe in another case they would probably skip over and let their lawyer explain to the accused or client after the judgment. I think that's why you're seeing that lengthy judgment. It did not surprise me, but it is unusual in any other case that is not being watched with the close lens occurring in this case.
So, Laura, I think what you're implying, that maybe the pressures of the Me Too movement, and that you find that the judges making that statement right off the top to be a courageous move. Is that kind of what you're implying in your remarks?
It struck. I was certainly impressed, and that would be the part of the judgment that surprised me, that she started out by not just giving the bottom line, but by making a finding that the complainant consented. And that's quite different than in other cases where you might say, for example, in all of the circumstances, I'm just not convinced beyond a reasonable doubt that the Crown has established this element of the offense. To find as a fact that she consented is something where I think our last speaker was talking about whether or not these individuals end up playing hockey again. That's a factor that I find quite relevant, because this is a case where the version of events that has been told by the accused since day one has essentially, from what I can tell, I don't have the judgment with me, has essentially been agreed with by the judge. And that's quite different than saying something likely happened or probably happened, but I find because the beyond a reasonable standard is so high as it should be, I'm acquitting.
And we don't know that has happened yet. We haven't heard the judge's decision, but that's certainly what you would expect to happen, Laura, based on the statement that she made at the beginning?
Correct, although I don't have a glass ball. And so I'm quite interested, and I hope and encourage anyone that is interested in this verdict one way or the other, that before they make their final decisions on their opinion about our justice system, they have taken the time to read a very thorough written judgment that will get released to the public.
Since you brought up the justice system, maybe we can talk a little bit about the threshold and how high the threshold has to be to prove a criminal act beyond a reasonable doubt, and how challenging that may have been in this particular case.
Yeah, so the beyond a reasonable doubt standard that we hear about is is really, it's not a catchphrase. It's not something that lawyers just throw around. It's fundamentally the bedrock that underlies our criminal justice system. And so in Canada, what we've done is we have actually given the state the power to take away someone's liberty. We've given individuals the extraordinary power to put someone away in prison for up to life. But that power came with essentially a quid pro quo. There's a constitutional restraint to ensure that no one is wrongfully convicted. And that is this. Every single person in this country that is accused of any crime, even if it's sexual assault, is presumed innocent until and unless the Crown can prove and convince the trier they are sure of guilt. And so in a sexual assault case, that has two elements. First, the Crown has to prove beyond a reasonable doubt. The person, the trier here was a judge, but if it had been a jury, all 12 people would have had to be satisfied, sure, have no doubt that the complainant did not consent in this case. And I'll pause here to say, in this particular case, that's something where, had a defense lawyer done nothing, you would have problems already because of the video where she is almost simultaneously saying that she did consent. So that on its own could be doubt. And then even if you're satisfied that the complainant was not consenting, you have to also convince the trier beyond a reasonable doubt that the accused, that each of these 5 accused did not know or were not willfully blind or reckless to the fact that she wasn't consenting. And that's also difficult because of the number of times these individuals were asking if she was okay. It's difficult because of, you know, the complainant's own evidence is that she took on this persona of a porn star. And so she was saying things that to a person in the accused shoes may reasonably believe is her active consent. And so it's kind of within that vein where, in my view, this is not the case to be watching to wonder how in each and every case the beyond a reasonable doubt standard actually applies, because the facts in this case to start almost cried out for acquittals. I would say that the members of the public that are watching that are unsure or wondering about the justice system should be going to the London courthouse, for example, the Ontario Court of Justice next Wednesday or Thursday or Friday, and watching the regular ordinary trials. And there you will see people convicted all the time, as well as the standard being properly applied and resulting in some acquittals.
Laura, it has been really interesting to speak to you and to get your insight into all of this. Thank you very much. That is criminal defense lawyer Laura Metcalf. Let's go back to the CBC's Hilary Johnstone with new information as we look live at that courthouse in London, Ontario. What's the latest update, Hilary?
Well, Andrew, at this point, they have taken a break. Court has taken a break, but I do want to bring you what it is we're anticipating is going to happen as soon as that break is done. So leading up to the break, like we have been saying throughout the course of the morning and the early afternoon, Justice Maria Carroccia has been going back over the evidence, going over the testimony, going over the police videos. But now, leading into the break, she started to go into some of her reasoning, the legal tests, the legal bars that need to be met, like you were just speaking with Laura Metcalf about. The analysis that is going to come after this break is really what is so key here. It's really what we have all been waiting for throughout the day, because it is expected that Justice Maria Carroccia is going to go into why it is that she doesn't think that the complainant's evidence, EM, of course, as she is known, why why she doesn't view her evidence to be credible or reliable. And she will explain why, in her view, the Crown did not meet its burden of proof. I do want to show you a little bit of what she has gone over in terms of the principles, the legal principles that she needs to apply, and how she is thinking about what the Crown needs to prove here when it comes to sexual assault. So we can show you some of that here on your screen. In order to prove sexual assault, Justice Maria Carroccia says that the Crown must prove beyond a reasonable doubt three things. First of all, that there was touching, that the touching was sexual, and that the sexual touching was not consensual. So this is something that the judge was going through, explaining the bars that need to be met before this break happened. She says, with the exception of one of the accused, and that would be Cal Foote, that the first two questions, those first 2 points you're seeing on your screen, are not at issue because it was determined, in her view, according to the judge, that there was touching and that it was sexual. And just keep in mind here that Cal Foote's lawyer has argued that there was no sexual touching. That is why, according to Justice Maria Carroccia, it doesn't apply for Foote here. But the complainant, she says, must be aware that she has a choice whether or not to engage in the sexual touching at issue. No consent is obtained if the complainant expresses a lack of agreement to engage in the activity, or if the complainant, even if she consented, does not want to continue, according to Judge Carroccia. Intoxication is a factor to consider when determining the ability of a complainant to consent, is something that the judge added here. So it just gives you a little bit more insight, sort of what we were just hearing from your previous guests, that there are all these tests, these bars that need to be met, need to be proven in order to go one way or the other here. So like we say, a break, but when it comes back, that is really going to be the parts of it, her analysis, why she found EM's evidence not to be credible. That is, of course, what we will be listening in for.
Yeah, I think that's important to point out, Hillary, and I think you're doing that, but just to help our viewers understand. So what happened is, I mean, it seemed to be a surprise to some of the legal experts we've been speaking to some people in the newsroom, that the judge came out very quickly in her statement, in her public statement to the court, saying that she did not find EM's evidence to be credible, and then basically started going through the testimony, a summary, a review of the testimony, and that's more or less what we've heard. Other than that remark, right, Hillary, we haven't heard much of why the judge is seemingly coming to the decision that she's coming to.
Correct. So it started with that shortly after 10 a.m. Eastern, as we have been reporting, our colleagues in that courtroom, that there were gasps, that some of the family members of the players were crying as well when Justice Maria Carroccia came out at the onset and said that she did not find the evidence that the complainant had presented to be reliable or credible. As we've been hearing from legal experts on our programs throughout the day, it would seem that that is leading to a possible outcome of acquittal. Important to point out here, we do not have an official decision. We are still waiting for that. They have been on a brief break. We are anticipating in the next few minutes that that is what she's going to get into, her reasoning for why she did not find the complainant credible. And of course, important to point out, like we have been, that it is not usual that you would understand that reasoning, because this started out as a trial with the jury. That jury was then dismissed. There was a decision made that this was going to carry on as a judge-only trial. That is why we're getting this reasoning. If it had been a jury, juries in Canada are not allowed to discuss their deliberations, any of the thought process after the fact. So some of these legal tests, these legal bars, going back over the evidence, the testimony, that is something that we would not have heard if it had been a jury, so something that is quite unique to this. But as your guests have been saying, and certainly as our colleagues who are inside the courtroom have been relaying back to us, the judge here has really been going over before the break in detail these bars that she must meet. At one point, Andrew, she referred back to a case, the Supreme Court of Canada case, R versus WD, which for decades has been the leading case law on how to assess competing accounts in a he said, she said case, which is in so many ways what this is. And that principle that was established after that Supreme Court of Canada case, R versus WD, it's a principle that a judge should not just choose one version of events evidence, but should consider whether the accused story, even if not entirely believed to be true, is enough to raise a reasonable doubt about guilt. She went back over Hart's testimony, Hart, McLeod, and Formanton's police statements that were played in court. She went through her reasoning of what she heard and the bars that need to be met in either to order acquit or to convict. So that is something that has been happening before the break, kind of after we've had a bit of a recap, like you were saying, going back to the beginning, everything that was heard throughout the trial. Then she came to this, outlining those legal principles, those legal bars that need to be met. Then we've had this brief break, and we really are anticipating in the next few minutes here that we're going to get to the real sort of crux of this, how it is that she has applied all of that reasoning to her eventual decision.
And we will be back to you momentarily for that, I'm sure. Hillary, thank you. The CBC's Hillary Johnstone in our newsroom. Thank you for that important update. So I should just mention that court has just resumed. I've just been told by my producers in the control room for some more legal analysis of this case. Let's go back to Rishi Gill. He is a criminal defense lawyer and a former Crown prosecutor, and he joins us now from Vancouver. And so, Rishi, court has resumed. Is that what you expect? I was just speaking with our reporter, Hillary Johnstone. Is that what you expect now? We're really going to start to get into the reasoning behind the judge's decision?
Yeah, that's exactly what will happen. And it's important to let people know that what the judge has been doing to this point is just going over the evidence from either side. She's not necessarily making a finding this was correct or not. She's ultimately said, we know that she's not found the complainant reliable or credible. So we know that from the get-go. But her recitation, basically what she's been doing for quite a long time now, because there was a large body of evidence, is just to lay out either side's position. And now, as Ms. Johnstone, the reporter, just said, she is going to be going into what is the most important part, which is the analysis. You've got the facts. She's now going to go over a little bit of the law, and the leading case here is WD, with respect to reliability and credibility and how you reconcile different versions of events. But she will then go into how do you put the facts and the law together to get to the ultimate conclusion.
Rishi, we know this case goes back to 2018. How did that impact this trial? Would things have gone differently if the trial had taken place 6 or 7 years ago?
Yeah, I mean, the most obvious thing is that memories fade, and I don't think the longer it takes to get a matter to trial, the more difficult it'll be for the prosecution. It rarely will be a problem for the defense, and I think the defense on most criminal cases, if the matter proceeds, it takes an exponentially long time. It's not the worst thing in the world as far as actually running it. But another really important issue here is what the Crown was faced with was a lot of differing evidence from the complainant, different versions of the facts. There was her interviews with the police. There was also her civil suit, because she launched a suit in the civil courts, which is completely separate from the criminal proceeding, where in that case she gave evidence that could be then used later on. So the more evidence that's generated from the complainant or from the Crown side, where you've got numerous statements, it's rarely helpful, because there's always going to be problems with consistency moving over time, and especially when it's such a lengthy period of time.
Could anything have been done differently in this trial?
I think that they did the best they could with what they had, both sides. And I think that the Crown had a tough job. Like, I don't think anybody would say that the Crown's position was harder than the defense position. And that's always the case to a certain extent, because it's the Crown's burden to prove something. The defense could literally just sit there and do nothing. Rarely happens, but generally it's the Crown's obligation to prove what they need to prove. And in this case, I think that they did the best with what they had, and there was a lot of weaknesses with the Crown evidence that a very competent group of defense lawyers were able to take advantage of.
And so do you think this was a fair trial, or are there some fundamental flaws or limitations with the justice system?
No, I think this, look, I will say this, I don't think there was any problem with fairness. I think the matter was handled very well. It was a high-profile matter which had a lot of attention, so everybody's going to be, quote-unquote, on their best behavior, in the sense that they are going to be bringing their A game. And I think there was a very, very competent judge, there was a very competent Crown, and there's very competent defense counsel. So on that basis, I think that if the trial was fair. And I think I will also say, and I've said this numerous times, the Canadian system of justice, especially in the criminal context, is amazingly solid. And it's something that the public should be proud of as Canadians. We have a very, very tight and well-structured judicial system. And I think when we see what's going on to some neighbors in the South and compare and contrast our Supreme Court of Canada versus the U.S. Supreme Court of Canada, the U.S. Supreme Court, and the trials that happen at the American side versus the Canadian side, I think it's quite well established that we have a very stable democratic system that is under the underlying portion of that is that we have a good legal system. And I think the criminal justice system is first rate in Canada.
Rishi, appreciate your extra time. Thank you very much. Rishi Gill is a criminal defense lawyer and a former Crown prosecutor live in Vancouver. And this is the courthouse in London, Ontario, where Justice Maria Carroccia has been delivering her rulings. We have reporters and producers there bringing us all of the latest information. Let's go back to the CBC's Hilary Johnstone at the Breaking News Desk. And Hilary, can you recap what's been happening in the courthouse today? And we have just learned that court has in fact resumed.
Court has resumed. This was a brief break that they took. That was after a longer break that happened about midway through. Justice Maria Carroccia explaining, going through, starting to get into her reasoning leading up to the eventual decision. That is the decision, a ruling that we are anticipating should come fairly soon. So shortly after 10 a.m. Eastern time today, Andrew, is when all of this got underway. And of course, there are those 5 former Hockey Canada World Junior hockey players that have been on trial, each of them facing 1 count of sexual assault. And then that one player, Michael McLeod, who was facing that additional charge of being a party to an offense for his alleged role in facilitating this alleged sexual assault that took place, according to police, what they were accused of back in June of 2018. So what we know, of course, is that the complainant, who has been known as EM, because of a standard publication ban, not identified any further than by those initials EM, alleged that in June of 2018, there was a sexual assault, a group sexual assault inside a hotel room in London, Ontario. All of that, she said, happening after she had met one of the accused, Michael McLeod, at a bar called Jack's in London, Ontario, had gone back to his hotel room. That encounter was not what was on trial here. That was consensual, court heard. It is what is alleged to have taken place inside that hotel room after the fact. All 5 of the accused have always maintained their innocence. They all pleaded not guilty. There was a trial over 8 weeks in London, Ontario, starting at the end of April, and then all of that wrapping up in mid-June, leading to now. And the reason why we are anticipating, why we are waiting for this ruling, this decision from Justice Maria Carroccia and not a verdict from a jury, was because during that trial, the second jury was dismissed after one of those jurors approached the judge and said that they felt that members of one of the defense team had been mocking members of the jury. There was concern about how that could prejudice the trial going forward, and a decision was reached that they would carry on with the trial but judge alone. And that is why we're now waiting for this ruling, for this decision from this judge. Important to point out here that this reasoning, the legal reasoning behind it, going back over the evidence, the testimony, the police interviews, the reason all of that has been happening leading up to this moment is because it's a judge alone trial. Juries are not permitted in this country to talk about their deliberations, to talk about what went into a decision. But in this case, because it's a judge, there is. So starting after 10 a.m. Eastern time today, so about 4 hours ago now, is when Justice Maria Carroccia first came out and sort of right off the bat said that she did not find the complainant EM her evidence to be reliable or credible. When that happened, there were gasps in the courtroom. We also note that the family members of some of those players who have been there throughout the course of the trial were in tears, according to our colleagues who were inside those courtrooms. There's the courtroom where all of this is happening, Andrew, but there are also overflow rooms as well, where members of the media and members of the public have been allowed to be. Such interest in this that there was actually a delay this morning while they scrambled to find a second overflow room for additional members of the media and public. So over the course of the past 4 hours or so, the judge has gone back over the evidence, has gone back over the testimony, both of the complainant, of the one accused who testified in his own defense, of the other former teammates who were not charged in this case, but who also testified, the police interviews from that original investigation, and then all of this now leading up to what eventually will be a decision from the judge.
And I just want to let our viewers know in the moments that you've been speaking to us, we should say that as there was an issue when the judge returned back from the break, the judge says someone, this is according to one of our reporters inside the courtroom, the judge says someone in one of the overflow rooms that you were just mentioning, Hillary, has been taking pictures of the video monitors. That is illegal, and she has asked the court officer to find and remove that person and notify the police. So that is
a development.
Yep. Of what's going on in the courtroom. Don't know whether people are aware or not aware of what is permitted, what's not permitted, but that is clearly not permitted. Our cameras are not permitted in the courtroom, and that's why we have reporters in there giving you giving our reporters on the ground outside the courthouse information, and you certainly can't take videos, you can't take pictures of the video monitors inside the courtroom. So just a little detail there of what's happening as we speak. Hillary, can you recap what else the judge has said?
Absolutely, and there's even just another little update here, Andrew, that I'm seeing, that it's not up to the judge. This is in the judge's words, as she's now restarting her analysis after that brief interruption you just told us about. She is saying it's not up to the judge to look at the morality or propriety of the conduct of any of the persons involved in these events. The function of this court is to determine whether the Crown could indeed determine each of the charges beyond a reasonable doubt. And certainly that is something that I know your experts, so you've been on, who have been on speaking with you, have been talking about, that this is not about determining what people view as right or wrong. This is very much in a court of law, whether or not the Crown has proven their case beyond a reasonable doubt. And that was something at the very start that she had said when she said that she found EM's evidence not to be credible or reliable. Not necessarily that she found the complainant not reliable or credible, but the evidence not reliable or credible. Also had said that based on what she had seen, the Crown had not met its onus, those standards, those tests. I'm just seeing as we're speaking here, Andrew, that there's another update here. Yep. So if we can just go through this, the judge is now expressing her concerns with EM's testimony, saying that not all inconsistencies mean that a witness is lying, but it's something to consider. And right at the start, when she started going back over the evidence throughout the day, she started pointing out what she viewed as inconsistencies in EM's testimony, things that she told the police right after this alleged incident compared to things that she said in court. This update goes on to say that the justice points to a few answers that EM gave during her evidence and cross-examination that she says gave her cause for concern. One example that the judge is pointing to here is an answer that the complainant had given when asked about her weight. EM said it was 120 pounds, but had since remembered it was on her medical records as 138 pounds. The judge here was saying she was concerned that she had changed her answer. Several times the complainant talked about telling her truth in court. Her truth in court, not the truth, according to the judge, which blurs the line between whether she was talking about the objective truth. So in answer to your question about some of the other things we've heard from the judge throughout the day, it has been this sort of thing. She came off at the start like some of your guests have said, maybe a little bit surprisingly so, saying right at the start she didn't find all the evidence to be credible or reliable, and then started working her way back. And it would now seem that what's happening in court right now is she's going back over some of her concerns with some of the inconsistencies that she found in EM's testimony.
It is interesting to get these details, and I'm sure she will provide us with many more details as we start to understand the why behind the decision that she will let us know what it is. We don't know what it is, but it does seem to be pointing in a certain direction. But again, some important details that we're getting live from our reporters inside that courtroom. Hillary, thank you. CBC's Hillary Johnstone in our newsroom as we look at the scene live outside of that courthouse in London, Ontario. Let's bring in Sarah Lehman. She is a former Crown prosecutor and criminal defense lawyer and joins us from Vancouver. Sarah, the judge is meticulously going through the evidence, noting discrepancies in EM's testimony. And now, as you may have just been hearing, we're starting to hear some of the reasoning or some of the concerns that the judge says she has had or she has with EM's testimony. What stands out for you in that?
Forward on learning, the training should continue.
Sarah, can you hear me?
I can, yes.
Yeah, great.
Can you hear me?
I can hear you.
Great.
I can hear you. Great. So, Sarah, I was just asking, I just wanted to say that right now, as we're speaking, the judge in this case is giving reasons behind some of her concerns with EM's testimony. What do you make of that?
Yeah, well, I mean, this is something the judge is going to have to deal with and is dealing with. Clearly, the evidence that was provided by the complainant is going to be a central factor in her determination as she renders her verdict. She does need to consider that testimony against other pieces of evidence that it presented through the course of this trial, including some video evidence, including other statements that the complainant provided in the past to the police over the course of this investigation, and the evidence that was provided by other witnesses who were in the room, even aside from the accused themselves. So, I mean, it's not surprising that she's going through this. She's going to be pulling that evidence apart, assessing the complainant's demeanor when she delivered the evidence, assessing, how accurate it was when she compares it to the constellation of other evidence that's before the court. And so, again, it's not a credibility contest, certainly, but she does need to look at that evidence to make a determination with respect to the credibility as well as the reliability of the complainant's account.
So at the beginning of her decision, she said that she found the complainant was not credible or reliable. And now just moments ago in court, she says that not all inconsistencies mean that a witness is lying, but it's something to consider. And she says several times EM, the complainant, talked about telling her truth in court, not the truth, which blurs the line between whether she was talking about the objective truth. Can you kind of unpack that a little bit for us?
Yeah, absolutely. I think that's a very important distinction because we have our subjective beliefs or experiences, our lived experiences that we may feel or perceive to be the truth, but may not necessarily objectively be the truth. And so the court here has a very difficult job of unpacking all of the evidence and trying to make the determination about what the truth is. Of course, it's not going to be a perfect process, but the function of the court is that of fact seeking. And then once the facts are determined, they have to apply the law to it. I think this is a very important distinction, and it's very good that the judge has acknowledged it and is now drawing it out in order to distinguish between the truth that the complainant may believe and then the truth as it may have actually unfolded.
And then she gave an example. She says she points to an answer that EM gave when asked about her weight. EM said it was 120 pounds, but had since remembered it was on her medical records as 138 pounds. Carroccia was concerned that she changed her answer. I mean, is that the kind of, what do you make of that example that she kind of gave? Is that just so that the public can kind of understand tangibly where she is, why she has concerns that she has?
Yeah, I mean, I expect that one example is going to be one of many in terms of how she analyzes the evidence. I mean, it's not going to hinge on the complainant not remembering her exact weight. Again, she needs to assess this through the constellation of the testimony and what other evidence was available. I think that looking at video evidence, is also of central importance here, and I'm sure the judge will do that. And I think she's even gestured to some of the video evidence that was provided in court, including the infamous consent video, in assessing the complainant's demeanor at the time that video was recorded, and then comparing that to what the complainant testified to in court, noting that in the video she didn't appear to be slurring her words. She didn't appear to be impaired. She testified in court, however, that she was very impaired. And so again, that's going to be something that's going to factor into the determination that the judge is going to make in terms of whether or not EM can be credible. And we've already heard from this judge, she's made the determination that her evidence isn't credible and isn't reliable.
All right, Sarah, if you don't mind holding on, we're going to come back to you, but we've just got some major developments that are happening as we speak. But that's Sarah Lehman, as a criminal defense lawyer and a former Crown prosecutor. Our Megan Fitzpatrick is at the courthouse in London. She joins us now live, Megan, as we are getting more and more details of the reasoning behind the judge's decision. Tell us more about what we're hearing.
Yeah, Justice Carroccia is now into the analysis portion of her ruling. So much of the morning so far, Andrew, has been Justice Carroccia laying out the evidence that was heard at trial and kind of recapping that evidence and also summarizing the positions of both the Crown and the defense during this trial, also recapping the testimony of EM during the trial and of Carter Hart, who was the only one of the 5 accused who testified during the trial. So she has been reviewing a lot of the evidence, but we do know what she said off the very top of her ruling when court got underway this morning. And I'll just read it word for word. She said, "In this case, I have found actual consent not vitiated by fear. I do not find the evidence of EM to be either credible or reliable." She went on to say, "With respect to the charges before this court, having found that I cannot rely upon the evidence of EM, and then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me." So she kind of said that at the outset, Andrew, and then got into her decision. And now we're nearing the end of it, where she will explain why she accepted or rejected some parts, some of the evidence, or the evidence that was heard at trial. Of course, the onus was on the Crown to prove the charges beyond a reasonable doubt. And the Crown, in their closing arguments, had argued that they did prove the charges beyond a reasonable doubt and that the judge should not be left with any doubt. And of course, the issue at the heart of the case is whether the sexual activity that took place in that hotel room that night was consensual or not. The Crown and EM had testified that it was not consensual. The defense lawyers for the 5 accused had argued that EM was a willing participant and in fact had instigated some of the sexual activity. EM had testified, though, that she felt she had no choice, that she went along with what was happening in the hotel room because she felt she needed to, not because she wanted to. Now, the Crown had urged the judge, Andrew, to accept EM's testimony. Again, in their closing arguments, they had said that EM was reliable and credible, that she had been consistent in her claims about non-consensual sexual activity. They had said where there were any inconsistencies between her testimony or previous statements to both police and to Hockey Canada investigators, that those inconsistencies were minor and could be explained. But the defense had argued that EM was not credible, not reliable, and in fact had lied, that she had created a false narrative, they had argued, about what happened that night because she regretted the choices she made that night. That is what we had heard from the defense teams throughout this trial. So, and again, the charges that they were facing were each 1 count of sexual assault, with Michael McLeod facing a 2nd charge of being a party to a sexual offense. And the Crown had alleged he had facilitated the other alleged sexual assaults. In part, they were trying to prove that because of the text message that Michael McLeod had sent to his teammates, inviting them to the hotel room to participate in sexual activity. So we're still sort of waiting for the actual bulk of her reasoning, Andrew, and her actual decisions. She, again, has been going through the evidence that she heard and legal principles as well, which include that the onus was on the Crown to prove the charges beyond a reasonable doubt and the presumption of innocence. So she reviewed quite a bit of case law and legal principles as well, and now she's into the analysis portion of her ruling.
And Megan, just as we are speaking, I'm just going to update our viewers because we are getting new information from our reporters that are inside that courtroom and will continue to speak. But this is from the CBC's Kate Dubinsky, who's talking about Carroccia, the judge, saying regarding EM's testimony had a tendency to blame others. She's quoting the judge here. Some of her testimony was proven wrong when compared to the video evidence, saying that included how many drinks she had and who bought the drinks. So just some more kind of analysis of the judge's decision, of her of where her decision is taking her. Can you give us a sense of what it's been like inside the courtroom, Megan?
I wish I could tell you what it was like inside the actual courtroom. I did not get into it because it was so packed, Andrew, and so many media and other members of the public trying to get a seat in the courtroom, and I was not successful, so I was watching from an overflow room in the courthouse, one of two overflow rooms. They had initially set up one, and then there were so many people trying to watch that they set up an extra overflow room in another courtroom in the courthouse. So obviously a lot of interest in this case, and there has been from the very beginning. Earlier this morning, there were supporters of both EM and the accused outside the courthouse holding signs and showing their support. Some of those here to support EM said that they wanted survivors of sexual assault to see us, hear us, and know that they're not alone. They had also described EM as inspirational, but again, there were supporters on the other side as well here at the court. And inside the courtroom, though, Andrew, I do know there are many members of the accused families. And when the judge said at the outset that she could not find EM's testimony or evidence credible or reliable, there was reaction in the courtroom with the accused, sort of embracing their family members later when there was a court break, and their lawyers as well. I did see some of them in the hallway during that court break. I went up to outside that courtroom and saw Michael McLeod hug his brother who was there. He has other family members there as well. So that's just a bit of color in terms of what's been going on in the court. We do know we expect to hear from lawyers after this is all over and the judge is finished reading her decision. Both some of the defense lawyers and the Crown attorney, the lead Crown attorney, Megan Cunningham, saying they'll speak to us but not take questions. And that is expected to be happening right behind me near the front doors of the courthouse, Andrew.
Megan, thank you. That is CBC's Megan Fitzpatrick live in London, Ontario. Earlier today, a guest here on CBC News Network incorrectly suggested that the London Knights Hockey Club had not completed required gender-based violence training. The team tells us that is not correct. Alex Brown from the London Knights says that, in fact, the club has completed the mandatory training and that it was done through an approved provider and approved by the Ontario Hockey League. He goes on to say the training is done every year. It was also completed before recent team leadership appointments. I just want to bring our viewers up to date on some of the developments that are happening inside the courtroom. Again, this is the judge that is giving her analysis of her decision as she is laying it out in that courtroom in London, inside that courthouse in London, Ontario. And this is, I should warn our viewers that what I'm about to tell you does contain some graphic language, which I'm not going to use, but I just want to warn you, there is some graphic language. The judge says that EM has gaps in her memory and that she admitted to filling in those gaps with assumptions. This is according to, again, the CBC's Kate Dubinsky inside the courthouse. The justice also takes issue with EM often, EM is the complainant, often starting her answers with, I feel that, as it reflects an uncertain memory. Carroccia points out that multiple men testified or made statements about EM's sexual aggression, including calling the men an expletive and chirping them for not having sex with her. So again, that is just the latest from what is happening inside that courtroom, and we will continue to bring you the very latest updates as we get them from our reporters who are in London, Ontario, and as well as our reporters here in Toronto. So how could today's decisions at the hockey trial affect the governing body of junior hockey in this country? The CBC's Jamie Strachan has been following this trial closely and joins us now, and Shireen Ahmed. And Shireen Ahmed with CBC Sports is also here with me. Appreciate you both being here. So Jamie, just talk to us a little bit about that. Hockey Canada has faced plenty of questions since EM's lawsuit became public. So how do you think today's rulings could have an impact on the organization?
I think there's really kind of two things to look at when it comes to Hockey Canada. There's what has happened to it already and kind of what will happen to it out of this case, and then kind of what it is actually capable of doing when it comes to effectuating the change to what we keep calling hockey culture. Number one, I mean, when this all kind of played out, we found out that parents like me, part of the hundreds of dollars in dues we were paying for the rights for our kids to play hockey in this country were being diverted off into a fund to settle sexual misconduct, sexual complaints like that. That's now changed. There's more transparency around where our dues are going. That's changed. Leadership at Hockey Canada, they thought they originally could weather this. They went before, a parliamentary committee and said, don't worry, we got this. That didn't work out. There's been changes in leadership. In terms of what they control, if you are playing for a junior hockey team in this country, representing Canada at a World Championships or any international team, you are receiving some mandatory training around things like consent, sexual behavior, gender-based violence, those kind of things. In terms of the rest of the country, all the hundreds of thousands of other people playing hockey in this country, it's really kind of remains piecemeal when it comes to what kind of learning is happening, what kind of modules, what kind of speakers, whether it's mandatory, whether it's coming from the league. You just read a statement from the London Knights. I mean, in the OHL, one of the three major junior hockey leagues in this country, every team is doing something different, some more than others. In the Western Hockey League, the same. In the Quebec Major Junior Hockey League, the same. So it's very piecemeal. When you go down to even a lower level, 12, 13, 14-year-old, 15-year-olds, it's a different kind of training, a different level of training. And when you look at how hockey players are developed in this country, I think that's a really important part of the conversation here is hockey, unlike baseball, football, basketball, we draft these young boys when they're 15, 16 years old. You may live in a big city like Toronto, go off and play in a small town where you're a hero of that local junior team. What do you know about consent? What did you learn in school? What did you learn from your parents? What is the onus on these organizations to fill in the gaps? These are all questions that we need to answer going forward, I think.
Shireen, what do you think? Do you think it's shifted the conversation around hockey in this country, this case?
I think that this case is unprecedented in some ways, not in a legal context, but in the social context. These conversations, Andrew, have actually been happening in spaces, advocate groups, different media members, people that are more aware of what's been happening. It's not to say that sexualized violence and abuse hasn't occurred in hockey. We know that's not the case. But what's happened now is to be able to bring it to the forefront. And a sincere hope, and I think of many, not just myself in media, is that those questions continue to be asked. These conversations continue. The accountability piece is really important here. That was one of the problems with this particular NSO, that Hockey Canada tried really hard to brush it under the rug, and the transparency was lacking. Now we know what questions to keep asking in the forefront, and we're going to look to parents, different people in the hockey ecosystem, to be accountable for that, but also media members. Will they be brave enough to ask these players who may go on to professional careers? We don't know, pending the verdict, what happens. And I think that also is a part of moving forward with this conversation. It needs to keep going. It's not over. It's just the beginning.
Shireen, I know you've got a lot of other work duties today, so I only have time for a couple more minutes with you. But just on that, just to follow up on that, we've seen players return to their respective professional sports leagues after being acquitted in a court of law. Again, we should mention that the judge has not released her decision yet, but it could be pointing in that direction. Do you think that's a distinct possibility that these players could return, well, I asked Jamie this, to an NHL hockey franchise in North America, maybe in Canada versus the US, maybe not, I don't know.
Andrew, the precedent is already there for players to go back to after, an incident has occurred, allegations have happened. We know what the rates of conviction and we know what the rates of reporting are in this country. And there's a big distinction between being found guilty in a court of law and nothing happening. There's a difference there that some of the legal experts and advocates have been speaking about. I think it's fair to assume at this point, we don't know what the verdict is, but that is a possibility. And again, going back to what are the questions? What's the accountability piece moving over? What is not only Hockey Canada doing? My question is to parents of young kids. What are you doing? This toxic behavior and this culture doesn't begin when a young man turns 17. It is part of the sport itself. What is being done to eradicate this particular type of misogyny in hockey?
I think that's a really important point that Shireen just made. Like the way that this conversation has been shaped is, what is hockey doing? What is hockey doing? I think it's, you can't, if you have teenage boys and they're playing sports, you can't just say, turn it over to a hockey organization and said, you do the hard work here. There's a role for parents, there's a role for the school system to play in teaching people about how to behave, how not to behave, and not solely rely on the coach or the organization of whatever sport your son or daughter may be playing.
Jamie, just very quickly, I meant to say when I said, do you think there's a road back to a professional hockey team, an NHL hockey team in Canada versus the United States? My question was more, would it be less likely in a Canadian club than in an American club? I don't know.
I think it's honestly
because of the scrutiny on this case in Canada.
For sure. I mean, I think the hardest scrutiny has happened already. I mean, I think if the Toronto Maple Leafs signed, Carter Hart, some in the crowd would boo him initially, but I think we've seen in the past if an athlete can help a team, a lot of transgressions have been forgiven in the past. Not just from athletes who were accused and potentially found not guilty, but from athletes who have served actual time in jail and have been convicted of crimes. There is a road back in professional sports if you can help a team win. We've seen that play out time and time again. So I think whatever team should choose to sign one of these players, if they are free to do so, will face some initial scrutiny from the community, from their fan base, but I think that will dissipate over time. That's at least what we've seen in the past.
Jamie, thank you. The CBC's Jamie Strachan. I just want to give our viewers another update of what's been happening inside that courtroom. We're getting more information. We're getting more remarks from Judge Carroccia. She says that EM, the complainant in this case, exaggerated her level of drunkenness, saying that it is a factor to be taken into account. The justice says EM went to great lengths, and that's her exact words, to point out that she was, quote, really drunk, unquote, for most of the night. Pointed to some of the videos from Jack's Bar in London as proof. This is the judge saying this, she exaggerated her level of intoxication, and EM gave inconsistent evidence about how much she drank and how much alcohol gets her drunk. She goes on to say EM was never shown stumbling or trouble walking and having trouble walking in high heels. She does not appear drunk in the consent videos. This is the judge's remarks. As an example, Carroccia points to the complainant's testimony about being really drunk at Jack's Bar and leaning on the bar to steady herself. But during that time, she is also seen noticing that the bartender shortchanged her when she paid for a drink and was able to point that out. That's not consistent with someone who is so drunk that they can't stand up. This is, again, what Judge Carroccia has been saying in the courtroom just moments ago. We're getting that information from our reporters inside that courthouse that you're looking at in London, Ontario. Now, this trial has included disturbing details. If you need support, there are lots of resources available. You can see some of the contact information on your screen now, and we'll repeat it often. Crisis resources are available for adults and children, both locally and nationally. For more on this, I want to bring in Alison Forsyth. She is a safe sport advocate and the founder of Generation Safe. She is also a survivor of sexual abuse. Alison, thank you for taking the time. I appreciate this.
You're welcome.
What is going through your mind today as you reflect on what you've heard from the judge so far?
Oh, so much. You know, as a survivor, it's been challenging. Not only, I never pretend to speak for all survivors, but I have worked and advocated for and spoken to over 25 survivors of sexual assault within sport. So it's challenging. I also reflect directly on my 8+ years of criminal trial and civil processes. So I respect that I will see what is happening today through a different lens of someone who has taken the stand. So yeah, it's been a challenging day.
Tell me about why it's been challenging, and tell me about, when you hear the judge talking about her reasoning and saying that the evidence that the complainant has brought is not credible or reliable.
So really clearly for me, from my own experience, there's a huge difference between the criminal system and the civil system. With the words that I would challenge us all not to forget is burden of proof beyond a reasonable doubt, evidence. I'll reflect directly on my experience where I was asked continually around dates and times and locations by sex crime detectives, to which I wanted to scream all the time, everywhere. So the reality of what you need to try to recall to actually attain the level of evidence that is necessary as a survivor is very challenging. I'll also share something that I learned through lots of therapy and work that I did in research, which is disassociation and coercive control, which is largely has not been brought up in my understanding. And when EM uses the word fear, I think of coercive control, I think of manipulation, I think of people saying to me, well, Allison, why didn't you just leave and get on a plane? And what I share with anyone who may want to opinionate, who hasn't had lived experience, is it was just not possible. And I do not believe it was possible for her to leave. I also think there's a huge gap in, and part of my language here, but what we know as a rape response. Media and a lot of folks who haven't had the lived experience will think it's a fight or flight response. The most common that I know of is actually the freeze response, which is what happened with me. I'm very open, if you can't tell, to educate, which is a disassociation coupled with I can't move. So I think there's a lot of gaps in the criminal system with respect to coercive control, with respect to rape responses, and I think we're seeing that here. And further, I just have an incredible level, pardon me.
It's okay, it's okay.
Of empathy for what she's been through. I would not want anyone to walk away from this experience and out of a trauma-informed place of respect to opinionate in public, because 30% of women in this country have been sexually assaulted. So please, on behalf of us all, don't talk about it with people you don't know. And then I'll also just share, going through being put on a stand and cross-examined to the extent that she was. This is trauma that I have no doubt beyond the verdict that she will live with, and I have the deepest level of empathy and love for her experience. There's many survivor groups out here. I am in awe of all of them, and I do my very best every day in the world of sport to ultimately prevent what happened to her. I believe it happened, and to others. And I think the last thing I'll share is I'm scared. because I'm scared because this should never be taken as it didn't happen, in my opinion. And what I'm scared about as I work every day in sport around sexual violence and consent and other forms of maltreatment, that the verdict of this case would ever be taken as, well, we don't have a problem with the hockey culture, or it would ever be taken as frivolous. That really scares me because I think it could send us backwards in very, very important work and acknowledgement of what needs to shift in sport.
Well, tell me a little bit more about that. In your work dealing with teams and athletes, do you think there has been a shift in the conversation since this case came to national attention?
So I work extensively with soccer. I work extensively with probably 20, or if not more, of the national sports organizations. I've been listening in all day. And here's what I believe is really important for folks to understand. And by that, I mean myself, who is currently raising 2 elite hockey players in my own family, is yes, it is very challenging for a national sports organization to get to the grassroots level of change. And it is not impossible. Hockey Canada does have great folks who I know personally working within safe sport. However, I feel sometimes that I'm on an island out here literally going team to team, club to club, province to province. There is not nearly enough education overall around maltreatment in sport, including the most common forms we see around bullying, hazing, and social media. But as far as this goes, it takes everyone. And by that, I mean parents pushing their clubs to bring in education on sexual violence and consent and other aspects of safe sport. It takes national sports organizations to mandate. By that, I mean force their organizations to implement training. And it's not okay that that does not happen till these athletes are of the age of a national level. I speak to my children directly about sexual violence and consent. My son is a AAA hockey player and he's only 14 years of age. And the last thing I'll share, and I say this with a warning and a caution to parents in the sport of hockey who have athletes that may go to a junior level, may be billeted, may be sent off to teams within the WHL or the OHL. Peer pressure, cultural norms, cultural legacies, traditions will far override our parenting. And until we get to a place where athletes don't feel like they have to succumb to horrible things or do horrible things to fit in with their peers, we have a big problem. So we have to be incredibly mindful of what that looks like.
Can I just ask you, Alison, just before we let you go, since you mentioned you have 2 sons who have been, and I just want to let our viewers know that as I'm speaking to you, we have Justice Garcia has made her call for roughly 4 hours. Where am I? I'm seeing this. Carter Hart, the only one of the accused to testify, has been found not guilty. Hart was charged with 1 count of sexual assault. So that is just the latest news that is coming out of this trial. I just want to ask you, Alison, you mentioned that you have your sons who play hockey. You work to educate athletes. Are you hopeful when you speak with your sons and they speak to you about, and I know 14 is pretty young, about change coming?
I'm hopeful in that it is obvious to me. I sit my son and his buddies down on my couch and I give them the 5-minute pep talks. I do not think it's happening in enough places, but the last thing I'll say about that specifically is there is a deep ingrained cultural normalization in the sport of hockey. And it's children are children. We need to stop just saying they're athletes. We need to further stop saying they're elite athletes. They are kids. It starts with us as adults, as administrators, as coaches. And often what that requires, and I've had many coaches that have done this, is coming to terms with how they were coached, coming to terms potentially with things that they did as a player that they may not be proud of, forgiving us ourselves for that. I know this might not make sense, but people watching may understand, because It's not just an organization that tells people what to do, because if you don't believe it, it won't make change happen. So I challenge all coaches and all of us in hockey who love it, I do, or I would not have my sons in it, that we all need to take a deep breath and respect where the culture is and where it needs to go.
Allison, appreciate your time today and your insight very much. Thank you. Allison Forsyth is a safe sport advocate and the founder of Generation Safe. And as I mentioned, the judge has found Carter Hart not guilty of sexual assault. Let's go back to the CBC's Hillary Johnstone with the new information from the courthouse. Tell us more about what we've heard just now.
Well, Andrew, as you say, the judge has just announced her ruling as it relates to one of the accused, Carter Hart, finding him not guilty. He had been facing 1 count of sexual assault. I also understand that there is a new update coming as well here, perhaps even a little bit of insight into her decision that I can bring you. And Andrew, if there's something else that comes through on the wires, please step in and interrupt me here. But Carter Hart, who is now 26 years old, has been found not guilty of sexual assault. He had been accused of obtaining non-consensual oral sex from the complainant known as EM on the night in question. But Justice Maria Carroccia found the Crown failed to prove beyond a reasonable doubt that EM did not consent. As part of her decision, as it relates to Carter Hart, she discussed the charge, saying that, quote, EM was acting in a forward sexual manner. Hart, quote, asked for oral sex with the complainant, and the complainant indicated by her words and by her actions that she would engage. There was consent, but was the consent brought about by fear? Basically, what we're hearing here is that the complainant, or basically, did the complainant think she had only 2 choices, to either comply or face harm? That was what was being weighed here. EM testified that she didn't know the men were going to enter the room, and she was shocked and scared when they did. But the judge says she does not believe the complainant, EM, only complied because she was too scared. So again, the judge ruling here that she does not believe that the only reason why the complainant complied was because she was too scared. There was no evidence or threats of violence, the judge has said, and the men said she was smiling and she doesn't seem afraid in the first consent video. Of course, those videos that had been taken after the fact and were part of the evidence in this case. So once again, for viewers who might just be joining us, one of these men, Carter Hart.
Alex Formenton found not guilty of sexual assault. That is a 25-year-old. So now that is now two of the 5 former Team Canada World Junior players. I accept the Carroccia says, I accept his evidence that it was a mutual division to go to the bathroom. I guess a mutual decision. That might just be a typo there. You know, we're going to give you some of the details, but not necessarily all of the details. It is quite graphic, some of the details that we're getting. But that is now 2 of the 5 players. And this is the scene, I believe, live outside the courthouse. Is that right, control room? No. This is tape, sorry. This is tape. Okay, I wasn't sure exactly what we're seeing on the right there. So
it appears that was them as they were going in a little bit earlier on today. So Andrew, just once again,
earlier
now
today, correct? Yeah.
Earlier today. So now 2 of the 5. We do have these rulings now from 2 of the 5, Alex Formenton and Carter Hart as well. A couple other things just to point out here while we await further decisions from the judge, Justice Maria Carroccia, who has been going through her reasoning for many, many hours now, along with the 2 of them here. So we have Carter Hart, and we also have Alex Formenton. There are 3 others, of course, who we're still awaiting further details on. That would be Cal Foote, Dylan Dubé, and Michael McLeod. Michael McLeod, remember, is facing that additional charge of being party to an offense for his alleged role. All 5 pleaded not guilty. So waiting, of course, now for any updates about the other 3 men.
And so, Hillary, let's just kind of, go over. I think we got some indication early on, given that the judge, what she said early on, and then she went through the testimony, and now we have been getting the analysis behind the why. the why she is reaching these decisions. 2 of the 5 so far found not guilty of sexual assault.
2 of the 5 so far found not guilty. And as you said, Andrew, earlier this morning, so shortly after 10 a.m. Eastern time, when all of this started, Justice Maria Carroccia had come out and had said that she had found the complainant, EM, had found her evidence to be not reliable and not credible. And certainly that had started to point towards the possibility, the likelihood that maybe that this is where this would be heading, that there would be acquittals. 2 of the 5 men, 2 of the 5 former hockey players so far have been found not guilty. Those 2 were both facing 1 count of sexual assault each. So we are awaiting any additional details now because, as you've been saying, Andrew, so the judge came out and said that she had concerns about the complainant's reliability and credibility, but then spent a significant amount of time going back over the evidence, the testimony. There was a break. When she came back from that break, started to get into the legal bars that needed to be met. And now she is applying her own analysis to all of that. And that is what is now coming into us. So I'm not sure if you're seeing a further update here at any point, Andrew.
I'm refreshing as we speak and as I listen. So not as we speak, but that is the latest information that we have, that we can tell you that Carter Hart and Alex Formanton, 2 former 2018 Team Canada World Junior hockey players, have been found not guilty of sexual assault in this case.
And Andrew, please step in if there's another decision here, but just to sort of go over a little bit more of what we're hearing from the judge as she goes through her decision, talking about that group chat. And of course, we knew about that after this alleged assault, that there was this group chat. The judge here is saying that the hockey players group chat in the days after June 18th and 19th of 2018, when this is alleged to have happened, were not evidence that the men were trying to get their story straight. The Crown suggests that the players concocted the evidence. I disagree with this characterization. They were recounting their recollections. And also important to point out here that the complainant meets one of these men, Michael McLeod, in a bar in London, Ontario. What happened in that bar is not what this trial was about. She went back with him to his hotel room. They had consensual sex. That was not what this was about. It was about alleged events after that, when it was alleged that these other players came into the room. So just so we're sort of talking through the timeline of what was alleged to have happened, and what the judge is saying is that after that alleged incident, in the days after, the group chat that those hockey players had, in her view, in her ruling, was not evidence that the men were trying to get their story straight about what had happened. And she says that she disagrees with the Crown's characterization that they had concocted evidence. Instead, she says they were recounting their recollections.
Hillary, thank you. I know we're going to be speaking very soon again. The CBC's Hillary Johnstone in our newsroom in Toronto as we continue to update you on the very latest in this decision that is being delivered right now by a judge in London, Ontario, on this hockey trial. And another, in fact, Hillary, if you're still there, we are getting a third player that has been found not guilty, and that is, remind me, control him, Calfoot.
Calfoot, found not guilty of sexual assault. And remember here that it was Calfoot, who had been accused of doing the splits naked over the complainant's body. But Calfoot has been found not guilty of sexual assault. He was also facing 1 count of sexual assault. He has been found not guilty. So Andrew, of the 5 men who had been accused, 3 of the 5 so far up until this point
and
have been
this is
found
who we're
not
looking
guilty.
at. This is Calfoot. This is from earlier today. So sometimes we'll be showing you, as we're speaking about them, we're trying to show you the players as we speak about them, as these rulings are being delivered by Judge Carroccia in London, Ontario. So that's who we're looking at from earlier today, going inside that courtroom. So Hillary, I'm reluctant to say goodbye because I'm sure you'll be there, and we'll speak to you in a second. But
absolutely,
I've got Sarah Lehman. She is a former Crown prosecutor and criminal defense lawyer and joins us from Vancouver. And so, your reaction to hearing now 3 players of the 5 so far have been found not guilty of sexual assault.
Yeah, I mean, I'm really not surprised about this verdict, and I expect that the remaining 2 will be found not guilty momentarily as well. Given the fact that the judge came into the courtroom this morning and just said off the bat that she didn't find the complainant's testimony to be credible or reliable, and she also didn't feel that the Crown had met their burden of proof, I think that we were all just expecting to hear this, the not guilty verdicts being rendered. And the judge has been very thorough in her analysis of the evidence that was before the court, as well as her application of the law. But now we're at the point where I think we're going to hear the inevitable, which is not guilty for all 5 accused.
And tell me why, through the analysis that the judge has been giving to the court, why you think that is the case.
Well, I mean, for her to come in and say that the complainant is not credible or reliable from the beginning, I think that's a pretty strong indicator of where she was going, not to mention the fact that she said that the Crown didn't discharge their burden on the elements of the offense. I mean, we have to remember that it's always the Crown's burden. In a case like this, where consent is the issue, it doesn't shift over to the defense at any point. And so it's up to the Crown to prove all elements of the offense and to do so beyond a reasonable doubt. So for the judge to come in and say, Crown hasn't done that at the very beginning of her reasons is quite bold, and it is a strong indicator of what the result is going to be at the end.
Are you trying to say, Sarah, that maybe this case should not have been brought forward, or was it badly tried by prosecutors, or, you know, can you give me a sense of that?
No, absolutely not. I'm certainly not that the case never should have been before the court, and it's no the competency of any of the counsel involved. I think that everybody did a very good job with the case that they were given. We have to remember that the evidence in any given case is the evidence. And so defense lawyers, Crown prosecutors, they do what they can in terms of discharging their duties and their obligations to the court, the community, their clients, and so on and so forth. But you know, it's going to be the case is the case, and the judge has to analyze the case that's before the court in terms of how the evidence plays out in court. Sometimes we don't know. Sometimes it's impossible to know what the evidence is actually going to be until the person takes the stand and starts giving it. And so here, you know, the case is as it unfolds, and the judge is doing a very thorough job of analyzing the constellation of evidence before the court. We have a great deal of evidence in this case, which is different from many other cases of sexual assault. And so this is no small job for the judge. And I think she's doing a very good job of stepping through it and dealing with each thing in accordance with the governing legal principles at play.
The trial has seen significant debate about the so-called consent videos, with the complainant and the Crown saying they don't tell the whole story. So how do you think these videos influence the judge's view and the case overall?
Well, these videos are very interesting because I think one of the things we were really drawing attention to from the very beginning is that consent can't be given after the fact. Consent does have to be given at the time the sexual activity is taking place, and also considering the nature of that sexual activity in question and the identity of the parties involved. And so a consent video that's made after the fact may be of very limited utility in any proceeding. But here it appears that the judge looked at that to determine the credibility of the testimony that EM ultimately gave in court about her level of intoxication and about her apprehension of fear in the hotel room that night, saying that she didn't look impaired in that video. She wasn't slurring her words. You know, she didn't look fearful. So she used that video to assess demeanor. And that's a permissible use of that video evidence, and one that the judge, I think, will definitely consider quite thoroughly in the decision.
Sarah, what do you think this decision, as we're seeing it, and your expectation is that all 5 players will, in fact, be acquitted? What do you think that does to sexual assault cases within the Canadian justice system, given how high profile this was going forward?
Well, I certainly hope it doesn't have a chilling effect. I mean, we know that sexual assaults are notoriously underreported, and that it is difficult to get all the way through trial on cases like these. It takes a great deal of resilience and strength for complainants to come forward and see the trial process through. And so, I mean, I do applaud the complainant here for speaking her truth and coming forward in order to do that. Again, I hope it doesn't have a chilling effect, but it may. And I think it's important to emphasize that resources and supports need to be in place for victims of sexual assault in order to support them in coming forward. And really, the victimhood here can't hinge on the verdict. The verdict is the verdict at law. It's a different legal test.
And sorry to interrupt you. I just want to let our viewers know that a fourth player, Dylan Dubé, has also been found not guilty of sexual assault. So it is now 4 of the 5 players Justice Carroccia has found to be not guilty of sexual assault in this case. Sarah, you can continue.
Yes, I was just saying that the supporters of EM, of course, I'm sure will continue to support her as they should, but we have to remember that the verdict is rendered in our criminal courts, is just that. It's the highest standard of proof at law. And again, it doesn't diminish the lived experience of the complainant in any way.
All right. Sarah, appreciate your insight very much. Sarah Lehman is a criminal defense lawyer and a former Crown prosecutor. 4 of the 5 players accused have been found not guilty of sexual assault. This is the courthouse in London, Ontario, where Justice Maria Carroccia continues to deliver her rulings. We have reporters and producers there bringing us all the latest information. So, thus far, the justice has found Carter Hart, Alex Formanton, Cal Foote, Dylan Dubé not guilty. Hillary Johnson is here to talk to us about those rulings and what we're still waiting for. Hillary.
Well, at this point, Andrew, the only one that we're still waiting to hear on would be Michael McLeod, who, remember, is also facing that additional charge of being a party to an offense for his alleged role in facilitating what was an alleged assault. But just to go through what we do now know, and please hop in if we do hear any more. We do know that 4 out of these 5 men have now been found not guilty of sexual assault. The most recent ruling coming in involving Dylan Dubé, who is now 27 years old. Remember that these men were between the ages of 18 and 20 at the time that this was alleged to have happened. Also, Dylan Dubé, remember here, had been accused of obtaining oral sex from the complainant EM, and separately of slapping her on the behind while she was engaged in a sexual act with someone else. We'll go through some of the others here, Andrew. So Cal Foote also has been found not guilty of sexual assault. He is now 26 years old. He had been accused of assaulting the complainant by doing the splits over her face, above her face, while she was lying on the hotel room floor. The judge here, so Justice Maria Carroccia, finds that he did do the splits, but the Crown did not prove there was contact with the complainant's face or that the splits were sexual in nature. Alex Formanton has also been found not guilty of the 1 count of sexual assault he was facing. He is now 25 years old. He had been accused of penetrating in a sexual way the complainant in the bathroom of the hotel room without her consent. The judge, as part of this ruling, has written, quote, "Consent can be communicated by words and conduct." In this case, the judge found EM, quote, expressed a willingness to engage in sexual activity with Alex Formanton. She goes on to say, quote, "I accept his evidence that it was a mutual decision to go to the bathroom." And then Hart, so Carter Hart, also found not guilty of the 1 count of sexual assault that he was facing. Remember that Carter Hart was the only one of these 5 men who testified in his own defense during that 8-week trial. He is now 26 years old, has been found not guilty of sexual assault. He had been accused of obtaining non-consensual oral sex from the complainant EM on the night in question in June of 2018, but the judge found that the Crown failed to prove beyond a reasonable doubt that the complainant EM did not consent. And while we're waiting for that final update here, Andrew, I have not seen it come through. If it has, please interrupt me. Just important to point out that we are anticipating at some point, fairly soon, really, this afternoon, we are are likely to hear from some of the people involved, including, according to the complainant's lawyer, and according to EM's lawyer, a statement that lawyer will present as well. We're told that that the complainant here, who was 20 years old at the time, has been watching today's proceedings via a video link.
And we also should point out that we are expecting to hear from a couple of lawyers, I believe, representing the former players. Right. That is also something that we expect to happen outside of that, likely outside of that courthouse in London, Ontario. As we wait, and I'm just making sure, all right, it still looks like we're still on 4 of the 5. Let's
Correct.
talk a little bit, Hillary, about how this day went with the justice coming in and delivering some remarks very early on, and then going through the testimony. And now in the last hour or so, hour and a half or so, she's been going through an analysis of the reasoning behind leading to the decisions that we've been telling our viewers just moments ago.
That's correct. And like I say, please hop in and interrupt me. But starting shortly after 10 a.m. Eastern Time this morning, Justice Maria Carroccia, after a brief delay because of how many people were in the courthouse, but started to go through
And
her
now,
reasoning.
Hillary, sorry to interrupt, but Michael McLeod, the 5th player, found not guilty of sexual assault. So now it is all 5 players of the former, this is breaking news coming into our newsroom right now, all 5 former Team Canada World Junior 2018 hockey players accused of sexual assault, now acquitted, found not guilty of sexual assault in this case.
Now, and I will just point out that there's one more count that we are still waiting for, Andrew, I believe. So do hop in, because remember, these 5 men had all been charged with 1 count of sexual assault. Like you say, they have now all been acquitted of that. But Michael McLeod was facing that additional charge of being a party to an offense for his alleged role in facilitating this alleged assault. So we're still waiting on that. So if you see anything on that, please stop me. But like we say, starting at 10 a.m. this morning, came out, the judge did, and said that she did not find the complainant, known as EM because of that publication ban, her evidence, did not find her evidence as being reliable or credible. And that certainly set the tone for what we were anticipating we might hear over the course of the day. The judge went back through in great detail everything that we heard over the course of that 8-week trial. We heard her recount what we had heard from the complainant on the stand. Remember that she had testified for more than 8 days and then had been cross-examined as well. Went back through that, went back over what we had heard from Carter Hart, who testified in his own defense, went back over what we heard from some of those other former teammates of these men who had not been charged, but had also testified during this trial, had gone back over the police interviews from that original investigation back in 2018, pardon me, which had been closed in early 2019, had gone back all over that. Then the judge had come over and had sort of walked through the high legal bars that must be met and that exist in order for her to come to her decision. And it is just in the last little while that she has really started into her analysis. So taking everything that was heard over the course of that 8-week trial in London, Ontario, applying the law, those high bars, and then through her analysis coming to this decision. And remember, this is unique that we're hearing this legal reasoning behind all of this that would not have happened if this had carried on as it started, which was a trial with a jury who would have delivered a verdict. That was stopped because there were concerns. A juror had expressed concerns that members of one of the defense team had been mocking the jury. That jury was dismissed. It was decided they would go with the judge alone. And now here we are waiting for that final count, a decision, a ruling from Justice Maria Carroccia on that final count. So if we see that, we'll bring that to you. But once again, all 5 being found not guilty of sexual assault.
And so this case, and I'm not going to leave you yet, Hillary, because I have a feeling we're going to learn that information very shortly from now as we await for that final charge on one of the 5 players and to find out what the judge's decision is in this. this. But as she indicated early, it looks like a full acquittal. We'll see on that final decision. That is a distinction from what the other players faced. All 5 players faced charges of sexual assault, but there was that additional charge that you mentioned, Hillary, that we're waiting to hear about. But
Still waiting.
We're
still waiting.
We can say that all 5 former Hockey Canada players have been found not guilty of the sexual assault charge. That we can say. And so, this came back, as I was mentioning earlier, this trial has had intense interest from Canadians. Hockey. I mean, it's so part of the culture in this country, and we've been talking with our reporters from London, Ontario, saying that it was actually delayed a little bit in the morning because they had one overflow room and they needed another overflow room to accommodate all of the media interest in this story, an important court trial in this country that has gotten the attention of Canadians watching it intensively.
Has gotten the attention of Canadians, and remember, when you go back over the timeline, because of course this has now played out over more than 7 years. Remember that back in 2022, it was also the subject of parliamentary hearings as well. And I'm just being told that Michael McLeod has been found not guilty of that additional charge that he was facing, not guilty of being a party to an offense for his alleged role in facilitating the alleged assault. So Andrew found not guilty, Michael McLeod, on both of the counts that he was facing. Those other 4 players found not guilty of the sexual assault count charge that they were facing. So the 5 hockey players, former members of that 2018 World Junior Hockey team, have all been acquitted of the charges that they were all facing.
Important information. This is perhaps what many expected, given how the day started. Not what many would have expected necessarily, but given how the judge laid out her reasoning. But the breaking news, Hillary, as you rightly point out, the 5 former players of that 2018 Team Canada World Junior team have been acquitted of all charges that they faced in a London, Ontario courtroom. We're learning that information from our reporters inside that courtroom. Hillary, we'll let you gather some more reaction. We'll look ahead rather to listening to the defense lawyer for the complainant, who we expect to be speaking outside of that courthouse, perhaps momentarily, as well as at least 2 of the defense lawyers for the 2 of the 5 former World Junior players. We also expect that to happen. They'll be delivering statements. That's our understanding. They won't be taking questions, but we'll see how all of that unfolds. And when it does, we'll obviously bring that to our viewers live. But for now, thank you, Hillary Johnstone, in our newsroom. For more, let's bring in Laura Robinson. She is an investigative sports journalist and author of Crossing the Line, Violence and Sexual Assault in Canada's National Sport. She joins us from, are you in London, Ontario?
Yes, I'm in the London courthouse.
You're in the London courthouse. Okay, so you're in the London courthouse. So thank you very much. Just, first of all, your reaction to this acquittal of these hockey players.
I wasn't surprised. I thought it would go this way. The very first case I examined was in 1992, and in that case, the players said, she begged for more, and the complainant said, I begged them to stop. So there's a very similar circumstance in what the various witnesses say. And between 1992 and today, I've investigated a lot of alleged group sexual assaults in junior hockey, and it's always the same tension. What the complainant says happened and what the players say, because we have multiple witnesses on the defense side. So I'm not surprised at all that the story is that the judge accepted their story.
Laura, can you tell me, were you in the main courtroom, were you in the overflow room? Can you just tell me a little bit about some of the reaction that you saw and what you heard as the judge was delivering her decisions?
Well, I was in an overflow room, and what was interesting, because we were here quite early, but not early enough. to get a seat in the regular courtroom. I have to say that this includes CBC media. The public were allowed to sit in the courtroom, and the media weren't in the place that we normally sat in. We weren't allowed in. The public was allowed in. So that a lot of media ended up in the overflow rooms. There were 2 overflow rooms, and generally there's the same kind of tension in the hallways. There were a couple of breaks, and people are very tight. Some people are very tight-lipped, so you can't really tell, whose so-called side are they on. You just know that there's a great deal of tension here, and there's perhaps in many, many people's eyes, this was a fait accompli decision, but that doesn't mean that they are not continuing to support EM. I think we saw that this morning with so many people out at the front of the courthouse. I believe 15 women's organizations were here this morning.
And I just want to say that the 5 are free to go. The judge says that the 5 they've been acquitted, they've been found not guilty, so the 5 are free to go, and that the Crown has 30 days to file a notice of appeal. So that's just information that happened just seconds ago. What's your take on the judge's ruling regarding EM's credibility, especially in the context of sexual assault trials?
Well, it's very difficult. When people are very drunk, whether it's a complainant or the defense, in this case, all of them were very drunk, it's also 7 years later. And I have to say, there was a time in cross-examination of EM where Daniel Brown said, "Who's to blame? Who's to blame?" And I have to say that we have to put some of the blame on the London Police Services, who, as far as I can see, didn't do the kind of thorough investigation that should have been done. They got the video from Jack's Bar. They never looked at it. They never, if you go to Jack's Bar, you see that people get table service, people get service when they're dancing. So the fact that we didn't see EM getting drinks bought by the players at the bar doesn't mean that those drinks weren't bought, but the police never investigated to that level, and that was very disappointing in my eyes. The other thing is, who's to blame? I think we also have to look at Hockey Canada. We're ready to just let this go, not even let the defendants know that they settled a civil case on their behalf, and nothing would have changed if that was the case. And I think in many ways we have to say that EM was also failed by a system that was supposed to be there to listen and doesn't seem to be listening very well. Of course, memories fade over 7 years. And so in terms of the credibility, it's understandable that someone who has been traumatized would make mistakes in their evidence. And it's also understandable that so would the hockey players not remember correctly either. So it's a very complex and very harsh situation here now, I would say.
You've been covering these stories for decades. Are you surprised that in 2025 we're still having some of the same conversations about consent and hockey culture?
I am not surprised because Hockey Canada did not, when my book came out in 1998, Hockey Canada and Sport Canada, which is the federal funding body, did not pay any attention to the fact that, I chronicled, and so did the CBC when we did On Thin Ice together on the Fifth Estate. We chronicled many counts of alleged gang sexual assault. Hockey Canada and Sport Canada have never even acknowledged that that was a sort of a phenomena that was occurring. And so I'm not surprised then that we're still having to do this decades later.
This case has sparked renewed public debate about how we handle sexual violence in sport. What do you hope we see next, whether from the justice system or Hockey Canada?
Well, I think there's a lot to be expected out of Hockey Canada. We'll see if that comes. I'll definitely be asking some some, I think, important questions about how they handled this. And in terms of the justice system, yeah, I think that this case is a good example of what happens when young women come forward with allegations of sexual assault. The reason that we know a lot about it is because it's such a high-profile case, you know. But I spent quite a couple of decades in courtrooms where very similar occurrences happened, and it was me and the local court reporters. So I really hope that we take this far more seriously, and we look at how everyone, whether it's young women or young men or girls and boys, understand consent. I think that's a very important issue that we need to unpack.
I don't know whether, you know, this question is kind of more of a Canadian cultural question, I guess. You know, why do you think there was such intense interest in this case? And what do you think that intense interest, I think a lot of people are probably watching, they're reading about this decision. What do you think that could do to conversations around sexual assault?
Well, this comes after Me Too.
Yeah.
And I think Me Too is pivotal. I think that we may be disappointed now that Me Too didn't do what many people hoped it would do. But I do think that the conversations, for instance, I started speaking with a man in the hallway. He had come from Peterborough. He has 2 daughters. He's been following this case, and he said, you know, I'm in tears over EM. So I think we need those kinds of discussions happening. I think we need to look at, you know, how do we teach what, you know, we used to call sex education? How do we really teach that now in school when young people are getting practically mainlined with pretty violent pornography? And how do we reconcile then what consent should mean, what the Crown I think very thoroughly argued what consent was, and what young people see as consent in the larger media culture.
Laura, appreciate your insight and analysis. Thank you. That was investigative sports journalist Laura Robinson.
Thank you for having me.
Thank you. Our Megan Fitzpatrick is live outside the courthouse in London. She joins me now. So Megan, take us through the rulings and what we heard from Justice Carroccia.
Yeah, and I'm keeping my eye on the courthouse behind me, Andrew, because we are expecting plenty of reaction now that Justice Carroccia has finished reading her ruling, which began hours ago here in London, around just before 10:30 this morning. And it took her several hours to lay out her ruling. I'll sort of take you through how the morning and afternoon have unfolded. Justice Carroccia saying right at the beginning, virtually, when she started reading her ruling, that in this case, I have found actual consent, not vitiated by fear. I do not find the evidence of EM, who is the complainant, to be either credible or reliable. Justice Carroccia going on to say, with respect to the charges before this court, having found that I cannot rely upon the evidence of EM and then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me. So that kind of set the table, Andrew, for the next few hours. But it did take the judge time to go through. She recapped some of the key pieces of evidence that were heard at trial, including the testimony of EM, including the testimony of Carter Hart, one of the accused. He was the only one of the 5 to take the stand. She recapped those so-called consent videos that were introduced as evidence at trial. So she was going through all of that through her ruling, and then she kind of got into the analysis of that evidence and basically determining what evidence she was accepting and what evidence she was rejecting. And ultimately, Andrew, I mean, the onus was on the Crown here, right, to prove the charges beyond a reasonable doubt. And there were 6 charges here. There are 5 accused, each charged with 1 count of sexual assault. Michael McLeod facing that 2nd charge of being a party to a sexual assault. Now, it all boils down to the judge saying she was left with reasonable doubt At issue here was whether the sexual activity that occurred in that hotel room that night was consensual or not. The Crown and EM testifying it was not consensual. The defense lawyers for each of the 5 accused saying that EM was a willing participant in the sexual activity and that at times, in fact, she was instigating it. Now, the judge was saying because she was left with a reasonable doubt about consent, the next sort of step in her analysis and what she had to weigh and determine was whether the consent was vitiated, meaning was it sort of canceled out because of other factors like fear. EM had testified that she was scared in the hotel room. She had testified she did not know that other men were going to come to the hotel room, and she was surprised when they started arriving. She had gone back to Michael McLeod's hotel room. The two of them engaged in consensual sex. It's what happened after that when the other players arrived that was at issue here in this trial. Now, the judge saying in her ruling that she essentially did not find any evidence that EM was truly fearful in the hotel room. And she pointed to one of the consent videos as part of her reasoning for that. There were 2 videos shot throughout the night. On one of those videos, EM can be heard saying, "I'm okay with this." And in another, she says it was all consensual. The judge saying she did not find that EM looked intoxicated or sounded intoxicated in those videos, or scared or fearful. So she rejected that evidence from EM that she had been scared. So in the end, again, she was left with reasonable doubt. She was not satisfied that the Crown had proven each of the charges beyond a reasonable doubt. The Crown had argued in her closing arguments that they had proven each case. They had urged the judge to find EM reliable and credible, saying she had been consistent in her version of events throughout, and where there had been any inconsistencies, they described them as minor and said EM had explanations for them. The defense had urged Justice Carroccia to find EM not reliable, not credible, and they had accused her of lying. They had accused her of fabricating her version of events, in part to support the civil lawsuit that she had later filed years after the alleged incidents. And I should note, just in terms of the timeline of all this, Andrew, the allegations date back to June of 2018. That is when the junior hockey team, World Junior Hockey Team, was here in London for a gala event to celebrate their World Championship win earlier that year. After the alleged sexual assaults, a police report was filed. There was a police investigation, and the case was closed with no charges laid. Then in 2022, news broke that a civil lawsuit had been filed by EM against Hockey Canada and unnamed players. That lawsuit was settled. Then London police reopened the case in 2022, and they laid charges in early 2024. That's how we arrived here at this trial in 2025, the trial starting in April and lasting 8 weeks. As we know, I won't recap all of it right now, but there were a lot of twists and turns in this case. It had started out as a jury trial. That first jury dismissed, a new jury chosen. Then that one was discharged, and it became a judge-alone trial. There were a lot of procedural issues that were dealt with within the trial. For example, pertaining to certain pieces of evidence that, well, the Crown wanted it entered as evidence, certain text messages, and they were not allowed. So there were several delays throughout the trial, but it finally did wrap up a couple of weeks ago, and the 5 accused have been waiting for a couple of weeks until today to learn their fate. Near the end of her ruling, she did sort of go through each of the allegations against each of the 5 players, and then again stating that she was finding them not guilty. At the very end, she sort of summarized all of the counts on the indictment, and again stated that she was finding them not guilty of the charges they were facing. And then she said right at the end, Andrew, the accused are free to go. So now the question will be, does the Crown appeal, right?
And she also said
do they
you
appeal
have 30
these
days, right? 30. You have 30 days to make
That's right.
to
The
appeal.
Crown has 30 days to file a notice of appeal. Yeah, but when they do that, they'll have to lay out sort of what what grounds they're going to try and argue for the appeal. They will have to try and identify what they will argue were errors made by the judge throughout the trial. So they can't just say, we're appealing. They have to have some solid, they have to lay out their reasons for appealing and identify those areas of appeal in order to try and overturn these acquittals. We are told the lead Crown attorney, Megan Cunningham, will speak to reporters, Andrew, so that'll be the first question to her.
Absolutely.
Likely, if not the second. One, reaction, and two, are you going to appeal? And we are also expecting to hear from some of the defense lawyers as well. They've given us a heads up that they don't intend to take questions from us, but they will make brief statements. Each of the 5 accused had their own defense teams. And I'll tell you, in the courtroom throughout the trial and again today, they sit row upon row in the courtroom. Michael McLeod in the front, because he's the one facing 2 charges, and then the other 5 accused were all sitting behind him. They had family members in the courtroom with them. I was not in the actual courtroom, unfortunately, to witness it. I was in an overflow room. Huge interest in this case. A lot of people showed up here to try and get a seat in the courtroom, so they had to set up an extra overflow room for those that wanted to observe the proceedings, and we did so on a screen within those overflow rooms. During one of the breaks, because she took a break, this ruling again took several hours, I did see some of the defendants in the hallway with their family members. I saw Michael McLeod, for example, hugging his brother, and we know from our colleagues that were in the courtroom when Justice Carroccia actually said at the outset of her ruling that she did not find EM's evidence credible or reliable. There was reaction from the players and their families. And again, we're awaiting any scrums from them. We know there were supporters of both EM and the players, members of the public, kind of supporters here earlier this morning. And we know some of the EM supporters plan on holding a rally here this evening as well.
And I should just, as you've been speaking, Kate Dubinsky, CBC's Kate Dubinsky inside the court says court is now adjourned. The men did not initially react as Judge Carroccia was ruling not guilty on each count. Then there were fist pumps and hugs among the accused men and their family members and lawyers. As you mentioned, Megan, the Crown and EM's lawyer are expected to speak. EM is the complainant, are expected to speak in about half an hour outside of the courthouse. And as you mentioned, defense lawyers are expected to make statements in about an hour. So that is also from the CBC's Katie Nicholson. So there we go. So that's some of the information. Megan, you gave us a little bit of color, if you will, of what was going on inside the courtroom, inside the overflow rooms, as you say. Can you just give us a sense? We're looking at the barricades. We're looking at the people gathering outside of that courthouse. Can you give us a little bit more of a sense of what it's been like there?
Well, I've got to tell you, Andrew, because I was trying to get a seat in the courtroom, I got here fairly early this morning, and there was already a long line, mostly of media that I know some of the ones that were at the very front of the line got here at around 6 a.m. this morning. The courthouse opens at 8:30 to the public, by the way. So people did get here early, and then, as I was mentioning, those supporters of EM who have been at the court on other occasions, namely when EM was testifying. She testified, by the way, by remote video link. She did not testify in the courtroom with the accused. She spent about 9 days on the stand, and those supporters of her were here those days to show their support for her, and they were here again this morning. They're not here right at this minute, Andrew. I think they've left, but again, we know they are planning on coming back later. There are barricades set out in front of the courthouse. That's not usually the case. Usually you can park right in front of the courthouse, but I think police did that again today as a sort of crowd control measure in case there were sort of people spilling over onto the sidewalk and into that driveway there. But I do see some security officers outside the court. That's, again, not usual, but this was a long trial. It was nearly an 8-week trial. So there were not supporters or protesters or people like that here every day of the trial. But of course, given that this was the day that the judge was going to give her decisions, there's extra interest. But again, I'll mention that there was 2 overflow rooms plus the courtroom itself, and just demonstrating that, well, it was packed. And so you couldn't get a seat in the main courtroom. The overflow rooms on the main floor of the courthouse. And then once we learned, some of us in the media, that we couldn't get in the actual courtroom, they did set up quite quickly, actually, another overflow room in another courtroom. So, and there were lots of people in there. You could hear sort of some murmuring and some reaction when the judge, again, at the very outset said that she was not finding EM's evidence credible or reliable. And I know from our colleagues that were in the actual courtroom, there were audible gasps when the judge said that. So a bit more of the color I can give you. I wish I had been in the courtroom myself, but I didn't squeeze myself in there, unfortunately. But yeah, that's a bit of what the atmosphere is like. Again, the players' families are here, and we don't know who everybody is, if they're friends or related to them. But throughout the trial, some of their family members had been here through the whole thing. Again, we're not expecting to hear from the players directly, Andrew, but we will get those statements from at least 2 of the lawyers. Those were ones that I spoke to during that court break in the hallway. Dan Brown, who represents Alex Formanton, and Juliana Greenspan, who represents Cal Foote, told me that they would speak to us afterwards.
Megan, thank you. We will get back to you soon. That is the CBC's Megan Fitzpatrick live in London, Ontario. For more analysis, let's bring in Brandon Trask. He is an associate professor of law at the University of Manitoba and a former Crown attorney in Nova Scotia and in Newfoundland and Labrador. He joins us live from Winnipeg this afternoon. Brandon, appreciate you taking the time. Thank you.
Thanks, Andrew.
So tell me about your takeaway, what, given the judge's ruling and what she had to say, a full acquittal on all charges.
Yeah, I'm not, frankly, not surprised by the ultimate acquittals. I was a little bit surprised with that statement basically right away this morning that found, EM to not be essentially credible or reliable. In a lot of sexual assault cases, even if there is going to be an acquittal, typically judges will go to great lengths to try to say, look, this isn't sort of a competition between the complainant and the evidence of the accused. So to see essentially straight out of the gate the comments about the finding of not being credible or reliable, that was surprising to me. But like I said, ultimately the acquittals are not surprising based on the evidence that was presented. But yeah, I think, also interesting the comment that Justice Carroccia made about finding that there was actual consent and that this was not vitiated through fear or anything else. I guess the other thing that sort of leaps out top of mind that I found interesting, and the Crown may potentially try to pursue this with a possible appeal, were the comments that Justice Carroccia made regarding the quote-unquote consent video. Typically at law in Canada, consent videos made after the fact or even before are essentially useless because of course consent has to take place contemporaneously with the acts. And even if something begins as consensual, there can be a change sort of mid-act, and if consent no longer exists, then obviously the act has to stop. So like I said, typically these consent videos are essentially worthless, but Justice Carroccia looked at essentially the state that EM was in those consent videos, and did seem to place a fair bit of weight in saying, look, there was essentially no appearance of intoxication or being scared or fearful, and so that became important as part of Justice Carroccia's findings of fact. So that's an interesting angle. We'll see if the Crown pursues that on appeal, but the Crown has a really narrow ability to appeal in a situation like this. So, unless they can point to errors of law, essentially, it's going to be a real uphill battle for the Crown going forward.
And 30 days, right, to file that notice of appeal if, in fact, they make that decision. Maybe we'll hear about whether or not they are going to do that momentarily when we do expect to hear from a Crown prosecutor. You described this case as, and this is the scene, by the way, excuse me, outside of the courthouse where we expect to hear, again, from a Crown prosecutor as well as a couple of defense lawyers. You described this case as an onion. Can you expand on what you meant by that?
Yeah, I guess, yes, it's very, very complicated, like significant layering in this case to sort of unpack everything. And so, I think first and foremost, it's important for everybody to recognize, yes, just because there were acquittals here, right, all that means is that the Crown was not able
Sorry
to
to interrupt. We're going to listen to lawyers outside of the courthouse.
Good afternoon, everyone. A successful prosecution is not measured solely by whether there are guilty verdicts at the end. The Crown's goal throughout this proceeding has been to see a fair trial, a trial that is fair to the men charged, and one that is also fair to EM. A fair trial is one where decisions are made based on the evidence and the law, not on stereotypes and assumptions, and where the trial process respects the security, equality, and privacy rights of the victim, as well as the accused persons. We want to thank EM for coming forward and for her strength in participating in this process. We have received dozens of messages from people across Canada and abroad asking us to pass along these messages of thanks and support for EM, and we've done so. We will carefully review Justice Carrossia's decision, and as this case is still within the appeal period, we have no further comments to make about the decision at this time. Thank you very much for your time.
All right. Okay, that is, you were just listening to a Crown attorney there saying that the Crown's goal in all of this was to have a fair trial to the men charged and as well as to EM. EM is the complainant in this case, that this is a case that should be based on evidence and law, not on stereotypes and assumptions. She thanked EM for coming forward, and whether or not there will in fact be an appeal of this decision by a judge in that courthouse in London, Ontario, she says we have no further comment at this time. The CBC's Hilary Johnstone has been following along with me and joins me live. So we have an answer to that. We don't have an answer to that key question on whether or not there will be an appeal. 30 days to file a notice of appeal. Hilary.
That's correct, Andrew. So the Crown has 30 days to file that notice of appeal, in which case, if they were going to do that, they would have to set out legal flaws in the judge's reasoning here. So I think that would probably explain why what we heard there was that they're not going to make any further comments at this point while they review everything, while they review this decision from Justice Maria Carroccia, because they are still within that window, that 30-day window for a potential appeal. And as you said, what we heard there was that their goal from the outset was a fair trial, one that was fair both to the men who were accused and also to the complainant, EM. She said that a fair trial is one where decisions are based on evidence and the law, not based on stereotypes or assumptions, a trial that respects the privacy rights of victims and of the accused. And she thanked that complainant, EM, for coming forward. She said she thanked her for her strength in the process. Remember that all of this dates back to an alleged incident from 2018, so more than 7 years ago now. At the time, the complainant was 20 years old, and what we just heard there was that they have received dozens of messages from not just Canada, but also from abroad, messages of support to the complainant, EM, that people have asked them to pass along to her, and then also saying there that they have no further comments at this time since they are still within that 30-day appeal window.
So it should be pointed out, Hillary, that what that Crown Attorney said was that this is our goal, this is what we want, that it be based on evidence and law, not on stereotypes and assumptions, not at all indicating whether or not that Crown Attorney feels as though that's what happened today. And I guess that's part of holding back and maybe thinking, well, we'll see. We're going to take some time to kind of think about this and whether or not there will be an appeal based on all kinds of reasons. I know you're not a legal expert, but
that was my read of it too, though. Just based on simply what she just said, that she put out there, what her version of a fair trial would be, what her thoughts are on that, but then did not offer a lot of other insight onto that. So, of course, that is something that we'll be waiting for more details on. We are, like you've been saying, Andrew, anticipating that we'll hear from the lawyers of some of these men, and then also the lawyer of that complainant, EM, also expected to deliver a statement. So that is that would be why you're watching these crews. Some of them are colleagues, of course, still setting up, working on the technical side of things, because we're still anticipating further comments. Yeah, exactly. And it was also interesting, I mean, just something to point out, that as after the Crown Attorney delivered her remarks, there were some cheers there, to the remarks from the crowd gathered there, because as we've been talking, Hillary, there has been intense interest in this case right across the country, internationally as well. But that when there are no media actually in the actual courtroom, or very few, I don't think, because they had one overflow room, then a second overflow room, that there's interest in this decision. Absolutely. So 2 overflow rooms. There was actually even a brief delay at the start of the morning because they were scrambling to find a second room where they could put people. And as you were saying, Andrew, interest not just across this country, but worldwide as well. And I'll say that as I've been sitting here speaking with you over the past few hours, I'm subscribed to various news outlets from around the world and was receiving breaking news updates on this story from the BBC, from CNN, from the New York Times. So certainly, yes, a lot of interest here in Canada, but the international media as well. And then the supporters. Of course, we know at the morning before this all got underway, there were people there who were there to support the complainant, EM. We also know that there were people there to support the 5 men who were accused, and we're anticipating that at some point later on this evening, that some of those supporters will come back as well. All right, Hillary, we will speak to you again. The CBC's Hillary Johnstone in our newsroom here in Toronto. That is the scene outside of that courthouse in London, Ontario. If you're just joining us, the breaking news is that all 5 former World Junior hockey players from the 2018 championship Team Canada hockey team have been acquitted of all charges, including the 5 counts of sexual assault in this case. For some more legal analysis of this case, let's go back to Rishi Gill. He's a criminal defense lawyer and a former Crown prosecutor. He joins us now live from Vancouver. So all 5 players, they've been acquitted. What do you make of the judge's rulings?
The acquittal's not a surprise whatsoever, and I think most legal observers would not be surprised of that. I have to say, I was surprised in a large part by the judge's comments with respect to the testimony of the complainant. I want to be measured here, but it's for a judge to go the extra distance she did to basically comment on what is clearly, I don't want to use the word lies, but clearly testimony that the court found was just not confused or not a question of even being reliable, but actually saying this did not happen that way. And a specific example would be when she referred to the testimony of Mr. Formanton, who said that it was mutually decided that they would go to the bathroom together. He was one of the accused, the only one I think that actually testified, where she said she preferred his version, that his version was correct. And then when she went on to say, make comments about the complainant's, how she had tailored her testimony to a certain extent, those are, I don't want to, again, be measured, and I want to specify that I was not part of this trial in any capacity. I can't say that I was sitting there every day and observing anything, but I have followed it, so I don't know the day-to-day. But oftentimes in trials like this, especially a high-profile trial, judges want to be careful because they don't want to go too far in their findings, any farther than they need to. And really all the judge in this type of case would need to say is, at worst, I don't know who to believe here, or I can't say beyond a reasonable doubt, and leave it somewhat at that. I do think some of her findings of fact that she's made, I still think it would be a hard appeal. I think she's given the Crown more to think about than I thought of this case when an hour or two ago, before getting her real specific reasoning on the complainant's testimony. But that's not to say that this is an appealable case. I think if I was the Crown, I certainly would have been listening very intently to how she analyzed the complainant's testimony.
And I want to get to that in a second, but what did you make of what we heard there from a Crown attorney outside who just, she just says, she stated what is true, that the Crown's goal is a fair trial for the men charged, to EM, the complainant, that's based on evidence and law, not on stereotypes and assumptions, and thanking the complainant for coming forward, and that there was no further comment on whether or not there will be an appeal, that decision has to be made within the next 30 days to file a notice of appeal. What did you make of what the Crown said, and in terms of suggesting, not suggesting, that there could be an appeal?
Nothing. I don't mean that disrespectfully to your question, but I would say that Crown has to be extremely, like you say, I'm trying to be measured, and I'm a defense counsel, we have certain obligation. Crown's in even a much more narrow pocket as how they have to conduct themselves. What she would have said, I almost can guarantee you the exact same thing if the evidence would have shown, the judge would have been somewhat more measured in her assessment and they were still acquitted. It would have been the same issue, that she would have said that, yes, we're going to have to consider this carefully. That's what they would have to do. So I don't really make much of anything of what she said, other than the Crown obviously has to make a statement. They wanted to be as disclosive as they possibly could within the circumstances, and that's what she's done.
Rishi, the justice said EM, the complainant, testified about her truth as opposed to the truth. What do you make of her remarks towards the complainants? You got into a little bit, but that's another example. She said there were discrepancies, for example, in remembering her weight. Let's listen. This is let's listen to it. This lawyer here.
Advice for the last number of years. She's asking me to speak on her behalf today. She hasn't been here today. She's been watching on Zoom. I've spoken with her today since the verdict, and she's obviously very disappointed with the verdict and very disappointed with her Honor's assessment of her honesty and reliability. She's really never experienced not being believed like this before. I'm going to come back to that, but right now I'd like to take the opportunity on her behalf to thank a number of people, really all those who have supported her. She is extremely grateful for the outpouring of support by the community. It gives her great solace to know that she is believed by so many. She has asked me to extend her heartfelt gratitude for all the support she has received from organizations and individuals who showed up for her in any way they could, either in person at the courthouse or through the many letters of support. To quote her, she said, "Your kind words mean so much to me and have helped me through this process more than you'll ever know." She also wishes to thank Crown's Megan Cunningham and Heather Donkers for their tireless efforts in this case, as well as Detective Ryan Lindsay and Inspector Catherine Dan for believing her and supporting her. Thank you as well to Lisa Hewitt, her VWAP worker, who helped get her through those 9 days of testimony. On a personal note, it has been my honor to represent and assist EM through this process. She is a remarkable person and truly a hero. Despite her feeling like this was the hardest thing she's ever had to do, she chose to persevere and continue with the process of seeking justice. She knew there were no guarantees for guilty verdicts, and that even if she decided not to testify, that decision would have been accepted. Despite her feeling like this is the hardest thing to do, she knew there was no guarantees for guilty verdicts, and she decided not to testify. That decision would have been accepted, but she felt that it was important to see the process through to the end, even if it meant opening herself up to intense scrutiny and unjustified criticism. Her purpose, which was always at the forefront of her mind, was to stand up for herself and for others who have had similar experiences. She felt that the sexual violence she experienced should not be concealed. She felt there needed to be accountability, but her choice to testify came at a great personal cost. 9 days of testifying was more than she ever expected. Her treatment during cross-examination at times was insulting, unfair, mocking, and disrespectful, none of which was necessary. Yet she maintained her composure and kept her emotions in check, only to be criticized for not acting enough like a victim. I expect many people understand that when a person summons the courage to disclose their story, the worst possible outcome is to feel disbelieved. It's a gutting experience that no one deserves. That's why today's verdict is so devastating. EM did everything in her power to recount her experience honestly and to the best of her ability. She agreed to do everything asked of her by the criminal justice system. She spoke to the police whenever requested. She reviewed her evidence. She prepared her testimony. She answered every question. She spoke with intelligence and from her heart. Yet it was not enough. Now she questions what more could she have done? As her lawyer, I can tell her there's nothing more she could have done. But that said, the justice system must do better. It's important to understand that this case, the criminal justice system worked the way it's designed to work, to aggressively protect the rights of the accused. It's based on a concept that 10 guilty persons should walk free before one innocent person is wrongly convicted. So today, the accused have been declared not innocent, but simply not proven guilty beyond a reasonable doubt. And while the accused's rights are important, those protections should not come at the expense of the survivor's well-being. Reforms that prioritize protecting survivors from unnecessary re-traumatization and harm must become embedded in our systems. The justice system continues to fall short on identifying and eradicating myths and stereotypes. It struggles to understand complicated social interactions, such as victim responses to unpredictable, threatening situations, such as that described by EM. These and other problems continue to act as significant barriers to justice in cases of sexual assault. I am hopeful that the verdict today is not the end, and I know that EM very much wants some good to come from this case. So to those other brave souls who are willing to do whatever it takes to pursue justice, we hope you do not give up. In a country where only 6% of sexual assaults are reported to the police, courageous people like you are important. Without you, there is no criminal accountability at all. But the justice system must do better for you. Change is also necessary outside the justice system. To those in institutional leadership roles, this case should be a wake-up call that more is needed from you to prevent sexual violence. The impact you can have on this issue cannot be understated. But for today, despite the verdict, we can marvel at EM's courage and be grateful for her willingness to endure this process for all the right reasons. We are all proud of EM because she shed light on issues that need our attention. She has fostered a nationwide conversation about sexual violence, entitlement culture, bystander responsibility, valid consent, coercion, and responses to threatening, unpredictable situations. We look to this case as a turning point to do more to prevent sexual violence and to make reforms to afford survivors better treatment by the justice system. I stand with EM, and we stand resolute that together we can and must demand better. Thank you. BELLEHUMEUR. Thank you, everyone.
You've been listening to Karen Belhumeur. That is the defense attorney for the complainant, EM, in this case, saying on behalf of her client that she is very disappointed with the judge's assessment. She said she has never experienced not being believed at this level. She says that she is extremely grateful, though, for the kind words of support that have come from so many. She knew there were no guarantees for a guilty verdict, but she felt as though she needed to bring this case forward. And her purpose was to stand up for herself and others that she says have experienced sexual violence. She talked about the 9 days of testimony, saying that the 9 days of testimony were often insulting, unfair, mocking, disrespectful. What more could she have done? She asked rhetorically, Belhumeur did. She says, nothing more. The justice system must do better. I'm hopeful that the verdict is not the end, and to victims of assault, sexual violence, Belhumeur said, we hope you do not give up. And to society at large, this case should be a wake-up call. For some more legal analysis on this case, let's go back to Rishi Gill. He's a criminal defense lawyer and a former Crown prosecutor. What did you make there of what we heard there from EM's lawyer?
Well, I think what I had said before we had to cut away is validated by what her lawyer said, and I'm not saying that with any judgment. Clearly, the flavor of that judgment was very obviously that there was not just a question of the judge didn't know, it was uncertain, which is a very common route that the judge gets to an acquittal, but it went much further, of basically calling the complainant untruthful in some respects, and that's quite serious when a judge is moving into those areas. As I said, I think the Crown certainly has a bit more to look at now, without conceding that there's more grounds of appeal, but there's something that was very obvious on the face of that judgment, and I think what the complainant's lawyer has stated verifies that, absolutely.
Is it unusual? Well, is it unusual to hear that kind of language coming from a complainant's lawyer after what is, in her words, a very disappointing decision?
I completely respect the role of counsel for a complainant in a private matter, because the complainant doesn't have a lawyer on criminal proceedings. The Crown doesn't represent the complainant. The Crown represents the public interest. They're the Crown, and a lawyer for the complainant is in a different position. With that said, I mean no disrespect to her counsel, who I'm sure is extremely capable and is doing what she needs to do for her client. That was relatively incendiary language, and that has, I think, opened the doors to, rightly or wrongly, I'm not going to judge that, but certainly those kind of comments are basically really calling into question the integrity of the criminal justice system. I will say, as somebody who's seen things from both sides, as a Crown and defense, and work quite closely with my Crown opponents when I'm on the defense side, as I said before, I think we have a really solid criminal justice system, and I guess it's not felt as uniformly as I would hope amongst some lawyers.
Yeah, and Rishi, I mean, she said that. She said the justice must do better. And she went into some more details about that. I mean, what did you think of that?
Look, I'm just going to be honest. I completely disagree with that. And I have no personal disrespect to the complainant or professional disrespect to the complainant's counsel. I don't believe that the justice system could have done better. The principle of criminal justice, which I think you've heard from various lawyers who commented throughout your coverage today, is that the burden on the Crown is there for a reason, because misuse of the state power to bind somebody criminally should always be curtailed. If somebody had to choose between a finding they're bankrupt or that they breached a contract for rent or something, versus having a criminal conviction, I think 99.9 times out of 100, they're going to take the bankruptcy finding rather than a criminal conviction. Not just about the reputational damage, but it curtails your liberties. And I'm not trying to be high-minded and abstract about this. The preservation of the individual's right against the state and all the resources of the state is paramount.
Sorry to interrupt. We're going to listen. We're going to listen to a lawyer here.
Mr. McLeod has asked me to deliver this brief statement on his behalf. Mr. McLeod will not be speaking to the media, and I understand the other players will not be speaking to the media. I will not be taking questions, and other counsel who come to address you, they will not be taking any questions. Mr. McLeod had confidence in the justice process, and he welcomes Justice Carrossia's decision confirming that he and his co-defendants are not guilty of sexual assault. Justice Carrossia's carefully reasoned decision represents a resounding vindication for Mr. McLeod and for his co-defendants. Justice Carroccia found that the complainant's testimony was incredible and was unreliable. For years, public perception was shaped by a one-sided narrative from a civil lawsuit that went unchallenged, in large part because Hockey Canada settled the claim without first informing or consulting the players. The decision was made unilaterally, and the players were only told of the lawsuit and the settlement after the fact. Had they been consulted, they would have refused to settle, and they would have vigorously contested EM's allegations. That version of events dominated headlines and created a lasting and a false impression of guilt. It was only through this criminal trial that the allegations were fully and finally tested. The court compared the complainant's 2018 statements to the police, which rightly resulted in no charges, with the later conflicting civil claim. Key elements of EM's story were contradicted by the evidence, exposing serious falsehood and leading to today's clear and just verdict of not guilty. Justice Carroccia rejected EM's claims of fear and her claims of non-consent. That should be the takeaway from today's judgment. The damage to Mr. McLeod's reputation and his career has been significant. But today's decision begins to restore what was very unfairly taken away from him. Mr. McLeod is deeply grateful to his family, friends, his agent, and everybody who stood by him. Thank you. As I indicated, we're not taking any questions. It could be an endless process. So I've promised my colleagues that I would finish my comments and give them their turn. That's what I'm going to do. Thanks. Yep, it's David Humphrey and Anna Zhang, counsel for Michael McLeod. Thanks.
Right, you have been listening to the lawyer representing one of the 5 former junior hockey players, Michael McLeod. Megan Fitzpatrick is outside of the courthouse and listening in, and we heard there from the lawyer representing Michael McLeod saying that he wouldn't take any questions. And none of the players are going to speak or take questions. Remind us there of what we heard there.
Yeah, and just interrupt me if the other lawyers start coming out. Andrew, that is the first of the 5 sets of lawyers that we expect to hear from. We think all of them are going to talk to us, but as you mentioned, they don't intend to take questions. So that was David Humphrey, who was the lead lawyer for Michael McLeod. He was the one of the 5 accused that was facing 2 charges, 1 count of sexual assault, 1 count of being party to a sexual assault. And David Humphrey describing today's ruling by Justice Carroccia as a, quote, resounding vindication. He was saying, by the way, that he is speaking on behalf of Michael McLeod. Someone else coming out?
Yeah.
Okay.
Here's Carter Hart's lawyer.
For vindication. Here it is. It is both gratifying and unsurprising to hear an impartial and fully informed decision maker accept Mr. Hart's testimony about what happened on June 19th, 2018 as unshaken, credible, and true. The public narrative of this event was, until this trial, one-sided and untested. Now the criminal process has shown it to be false. To anyone who is surprised or angered by today's outcome, it is the direct result of the media's ongoing failure to publicize the weaknesses in the prosecution's case as it unfolded. The office of the Crown Attorney knew what today's verdict was likely to be. And the evidence at trial came as no surprise to them or anyone with full knowledge of the investigation. Almost every single feature of the evidence that Justice Carroccia identified today as fatal flaws for the Crown was known to prosecutors and to police from 2018. Today's outcome was not just predictable, it was predicted. The Crown Attorney did not have to take this case to trial. Mr. Hart, in particular, was willing to engage in a restorative justice process. He was willing to be publicly named and prepared to use his public platform to teach other athletes about how to ensure that their sexual encounters are responsible and thoughtful. Instead of pursuing restorative justice, the Crown forced a distressing and unnecessary trial to the detriment of Mr. Hart, his co-defendants, the complainant, and the Canadian public. Mr. Hart regrets that it took a criminal trial for the truth to come out, but he has learned from the experience, and he is committed to sharing what he has learned with others in his personal circle and in his professional life. He will be taking time today to process today's outcome and is grateful to his family, his friends, and his supporters for standing by him during this profoundly challenging time. Thank you.
Okay, that is the second lawyer for one of the former junior players that we have heard from there. The CBC's Megan Fitzpatrick also listening in, some strong language we're hearing from these lawyers, both for the lawyer for the complainant, EM, but also for the defense.
Yeah, I don't have a screen in front of me, Andrew, but I think that was Megan Savard
Sorry
speaking.
to interrupt again, Megan. Here we go. We're going to go. Alex Formanton's lawyers.
Hockey career that came to a screeching halt on June 18th, 2018, after what was meant to be a night of celebration with coaches and teammates. For the last 7 years, he's lived under a dark cloud. The public now knows what Alex has always maintained, that he is completely innocent of this false allegation. But only after his case has erupted into a massively publicized social cause. Alex's face has appeared on millions of screens and newspaper pages, and there can be little doubt that an untold number of people out there believed he was guilty simply because he was accused of a crime, long before any evidence was presented in court. This rush to judgment, to believe the worst of people, is one of the most regrettable of human traits. so too is our reluctance to change that opinion, even when it's proven wrong, after a full and fair trial. Notwithstanding Justice Carrossia's unequivocal exoneration of Alex today, there will inevitably be those who will still believe he committed a crime. Nobody in room 209 that night has emerged unscarred from this event. The criminal court process is a bruising experience for everyone, but never more than when a case as high profile incorporates such high stakes. In Alex's case, he was condemned and felt banished from society. This experience for him has been crushing. Nonetheless, the impact of this case has changed Alex as a person, and he's matured well beyond his years. It is inevitable that some people will not forgive Alex for what he was accused of doing. Others, however, will understand that this tragic matter rightly comes to an end today. Alex has never minimized his role in the sexual encounter or denied engaging in consensual sexual activity with the complainants. He fully cooperated with the police investigation and provided investigators with a complete account of his behavior back in 2018. Alex's narrative isn't conjecture. His police statement was corroborated at trial by several Crown witnesses, by video evidence, and was even supported in large measure by the complainant's evidence herself. Even Justice Carroccia said today that she accepted that Alex told the truth in that police statement. And while no police investigation is perfect, the London police got it right 7 years ago when they decided it would be a mistake to charge Alex. The evidence always demonstrated that he didn't commit a sexual assault. However, political and media pressure brought this allegation back into the spotlight in 2022, and the Crown attorney knowingly forged ahead with a hopeless prosecution. Besides the human toll to everyone involved, this lengthy legal process exhausted valuable resources that could have been deployed elsewhere in the justice system, but were lost here. Alex, his family, and his defense team are grateful to Justice Carroccia for her careful consideration of all the evidence that was presented at this trial. She's reached a just and correct verdict that must be respected. Nobody disputes that sexual assault is a terrible societal plague, and Alex sincerely hopes that this prosecution doesn't stop the quest to combat sexual violence and to bring genuine offenders to justice. However, an accusation is just that, an accusation. This case stands to the fact that we must never lose sight of the fundamental right to be presumed innocent. Now more than ever before, a fair response to sexual assault claims requires a balanced perspective and public trust in the decision-making of the courts. Anything less only harms the justice system and the cause of eliminating sexual violence. Thank you.
Can we get your name? Sorry, can we get your name?
It's Daniel Brown.
How can you say it was a complete account in 2018 when it two subsequent accounts?
That was Daniel Brown representing Alex Formanton, talking about the experience for him has been crushing, but that this tragic matter comes to an end today. And the CBC's Megan Fitzpatrick is standing by, and chances are I may interrupt you again because we may get, we're just going to leave that shot up, and we see some people coming at the door, so let's just wait and see some more people coming to the microphone. We expect that to be another lawyer representing one of the players. Let's watch.
Good afternoon, everyone. I'm Lisa Carnelas. Thank you for your patience. I know it's hot out. We are going to make a very brief statement today, and we are not taking any questions. This is Julie Santa Rosa. She'll be speaking on our behalf.
Thank you. For Mr. Dubé, this has been a long and difficult process. He is relieved by the outcome, and he is grateful that Justice Carroccia decided what she did and did so fairly and efficiently. Throughout this trial, Mr. Dubé was impressed by the fairness and impartiality demonstrated by Her Honor. This decision comes as a result of careful deliberation by Her Honor. She engaged with the evidence in a thoughtful, methodical, and principled manner. Her reasons reflect not only a command of the legal principles at stake, but also a deep sense of responsibility in assessing the evidence, applying the law and demonstrating a strong commitment to justice. Mr. Dubé has always maintained his innocence. He is thankful for all of the unwavering support from his friends and family who have also believed in him. For all of you that have been by his side throughout this period of time, you know who you are. We thank you. Mr. Dubé is hopeful that everyone can move forward from this in a positive manner. He is requesting privacy during this period of time. In view of the court's decision, Mr. Dubé will not be making any further statements at this time. Thank you.
Thank you.
All right, so that was the lawyer for Dylan Dubé. So we have now heard from the lawyers of 4 of the 5 former hockey players who have all been acquitted today in the sexual assault trial. The CBC's Megan Fitzpatrick is in London, Ontario, and we may again have to break away, and we'll just kind of go with that if we need to. But let's talk a little bit about, and the door is opening, and so here comes probably the final team.
That will be Juliana Greenspan.
Right, here we go.
I promise I'm the last one. We are the last ones. Juliana Greenspan, and this is Lauren Crawford, and we were counsel for Mr. Foote. Just have some brief comments that I want to say at this time. At the start of this trial, Cal Foote walked into this courthouse, an innocent man, and he walks out today exactly that. Cal never lost faith that justice would be done, despite the clamor of external pressures and agendas outside the courthouse doors. Criminal investigations and the trial process must always be free from these influences. On behalf of Cal and his family, we appreciate the court's careful and thorough consideration and for the just verdict delivered today. 7 years ago, Cal was 19. He is now 26. That is a significant part of a young man's life. He is still young. He has a wonderful future ahead of him, and he is eager to embark on his next chapter. Thank you. Not answering any questions, but thank you.
Well done. Okay, so now we have heard from all 5 lawyers for the former junior players, as well as the defendant, the complainant, EM, and a Crown prosecutor. The CBC's Megan Fitzpatrick is in London, Ontario. She joins me now. So let's talk a little bit about what we heard there from some of the lawyers representing the players.
Yeah, well, I thought that was a pretty strong statement from that last lawyer there, saying that her client, Cal Foote, walked into that courthouse an innocent man when this trial began, and he's walking out of it an innocent man, she says. That sort of reminds me of what Justice Carroccia said at the very end of her ruling, Andrew, after she had declared all 5 men not guilty of the charges they were facing. She said the accused are free to go. And they are walking out of that courthouse, Andrew. I saw Dylan Dubé walk out a few minutes ago and get into a car with his family and drive away. He was being heckled as he did that. There are some supporters here of EM, and they were yelling at him as he left the courthouse. But what we're hearing from his lawyer and the other lawyers is a lot of gratitude. They're expressing that they are grateful for Justice Carroccia's ruling. Some of them saying it is a just ruling, it's the right ruling. And I think it was Dan Brown, the lawyer for Formanton, Alex Formanton, who said it should not be challenged, I think is what he said. And that I wonder if he is referring to the Crown, who does have the opportunity to appeal these not guilty findings if they choose, and they have 30 days to file that notice of appeal if they choose to. One of the lawyers said the London police got it right 7 years ago. After the alleged assaults, which now the judge has found, she's found the accused not guilty of the alleged assaults, there was a police complaint made. London police did launch an investigation, and after several months, they closed it with no charges. It was then reopened in 2022 following news that EM had filed a civil lawsuit against Hockey Canada. And then they reopened it and they laid the charges in 2024 and then the trial this year. So some of the lawyers saying essentially that this case never should have been brought, or the charges never should have been laid, Andrew, and saying that this outcome was predictable. They said there were flaws in the Crown's case that should have been, known earlier, were known, and yet the Crown chose to proceed anyway, is essentially what they were saying. They were talking about the toll that this has taken on their clients. That last lawyer there, Juliana Greenspan, noting how her client is now 26 years old. He was 19 years old at the time. This happened back in 2018, and described that as a significant part of his life. He has a future ahead of him, though he's still young and he's eager to move on, which is what we heard from some of the other lawyers as well. Quite a few of them, Andrew, talking about how their clients are requesting privacy. I do want to get to some of what we heard from the other lawyers as well, though. So we have heard now from the lawyers for all 5 of the men, but we also heard from the Crown and from a lawyer representing EM. I think we have the clip of Crown Megan Cunningham. If we do, let's play it now.
A successful prosecution is not measured solely by whether there are guilty verdicts at the end. The Crown's goal throughout this proceeding has been to see a fair trial that is fair to the men charged, and one that is also fair to EM. A fair trial is one where decisions are made based on the evidence and the law, not on stereotypes and assumptions, and where the trial process respects the security, equality, and privacy rights of the victim, as well as the accused persons. We want to thank EM for coming forward and for her strength in participating in this process. We have received dozens of messages from people across Canada and abroad asking us to pass along these messages of thanks and support for EM, and we've done so. We will carefully review Justice Carrossia's decision, and as this case is still within the appeal period, we have no further comments to make about the decision at this time. Thank you very much for your time.
So, Andrew, we heard the Crown there thanking EM, and when we heard from a lawyer who has been representing EM and gave a statement on EM's behalf, she thanked the Crown lawyers who worked on this case. And then she also described EM's reaction to the verdicts, or to the decisions, calling them devastating, and saying she's very disappointed, not just in the judge's decisions, but in the judge's evaluation of EM, because we know at the outset of the ruling, Justice Carroccia saying she did not find EM's evidence credible or reliable. Let's take a listen to a bit more of that lawyer who represents EM.
Choice to testify came at a great personal cost. 9 days of testifying was more than she ever expected. Her treatment during cross-examination at times was insulting, unfair, mocking, and disrespectful, none of which was necessary. Yet she maintained her composure and kept her emotions in check, only to be criticized for not acting enough like a victim. I expect many people understand that when a person summons the courage to disclose their story, the worst possible outcome is to feel disbelieved.
So she was talking about EM's courage, saying she's proud of EM, and also about the impact of this case, Andrew. She said that EM fostered a national conversation on many issues, including the concept of consent. So talking about sort of the broader impact of this case. And again, we had heard the Crown thanking EM for bringing her complaint forward. So we have now heard from all the lawyers pretty much involved, but again, no questions. The outstanding question, again, is whether the Crown will appeal any of these decisions from Justice Carroccia. Again, they have 30 days to decide that. When we heard from Megan Cunningham, she said they will be carefully reviewing the justice's ruling. Can I just tell you, there's still like a bit of a crowd outside, a lot of media here, as you might imagine. There were supporters here early this morning of EM, as well as some supporters of the players as well. But there's still some people here. They're holding signs in support of EM, and there's some messages written on the in chalk on the sidewalk saying, "We believe EM, we believe survivors." So there's those, that just giving you a bit of color about what it's like outside the court. Not expecting to hear from anyone else at this point, Andrew, but we will be watching for any more of the players to leave. Again, we've only seen Dylan Dubé leave the court, so we're watching for any of the other players to leave.
Yeah, it's interesting. So we've heard from the Crown prosecutor, who just sort of laid it out very straight, not really kind of indicating what the Crown prosecutor is going to do. Then we did hear, I think, how you could characterize as some strong language from the complainant's lawyer and some strong language from the defendants, who said that they were thankful of the judge's decision. But one of the lawyers, I just took note, said it was political and media pressure that brought this allegation forward. It never should have been brought forward. So that's what we've heard from the lawyers. But let's now go through, Megan, the judge's ruling.
Yeah, so the judge, again, it was a lengthy ruling that began around 10:30 this morning in front of a packed courtroom, 2 overflow rooms as well. And Justice Carroccia saying at the very outset, Andrew, that in this case, I have found actual consent, not vitiated by fear. I do not find the evidence of EM to be either credible or reliable. With respect to the charges before this court, having found that I cannot rely upon the evidence of EM, and then considering the evidence in this trial as a whole, I conclude that the Crown cannot meet its onus on any of the counts before me. And of course, the onus is on the Crown to prove the charges beyond a reasonable doubt. And essentially, the judge went through all the evidence that was heard at trial, or key pieces of it, and gave her assessment of those pieces of evidence. And what it boils down to, Andrew, is her saying that the Crown failed to prove its case on each of the charges, that she was left with reasonable doubt about the issue of consent. Of course, during this trial, that was the key issue, whether the sexual activity that occurred in the hotel room here in London was consensual or not. And the judge saying she was left with reasonable doubt, but then the next step in terms of consent was for her to assess whether consent was vitiated. And EM had testified that she was scared in the, just seeing Dan Brown, Alex Formanton's lawyer, leave. Off he goes, Andrew. That she had been fearful in the hotel room, and so she had gone along with what was happening because she felt she needed to, not because she wanted to. And we heard the judge say in her ruling, she essentially rejected those claims that EM was fearful. So she rejected EM's testimony. She was highlighting parts of it that she found troubling, she said, Andrew, and sort of laid out her reasons. We will get more detailed written reasons in a little while, but she sort of went through all of that, and that on each charge she declared each of the 5 accused not guilty, and then, as I mentioned before, she said at the end that the accused were free to go.
And when that was happening, our understanding is from our reporters inside the courtroom is that the former players initially didn't react, and then there were fist pumps and there were some hugs with the players and the family members that were inside that courtroom. Megan, thank you so much. The CBC's Megan Fitzpatrick live in London, Ontario. For more analysis on the ruling, let's bring in Balfour Durr. He is a criminal defense attorney and former Crown prosecutor. He joins us live in Calgary. Appreciate, Balfour, you taking the time to talk to us. Thank you.
You're welcome.
What do you make of this judge's rulings?
Well, it was seemed to be a scathing indictment against the complainant and her credibility. I heard someone say that this, should spark a national conversation about sexual assault and, the attitudes. What occurred to me was that there ought to be a national conversation about how charges that are doomed to failure even get off the ground. Not every complainant who comes forward in a sexual assault case is telling the truth. And that's why we have a system of justice that has a very high standard of proof. And the high standard is to protect the rights of accused persons and to ensure that people are not wrongly convicted. But here, it seems that the responsibility, with the police, the prosecution, those who are supposed to be the gatekeepers of whether the charges go ahead or not, may have failed. And what your audience may want to think about is to look at it from the side of these players. These are young men who were presumed innocent. That's our law, and so it should be. But they apparently took leaves of absences. Their pay lasted as long as their contracts, and then they were not paid anymore. Their names were dragged through the mud in the media. But they were all in it, as it turns out, innocent, and at the time presumed innocent. It is what people may not understand is how hard it is on someone who's accused of a crime. It's the loss of reputation. It's the cost to them personally to have to fund a defense. It's the future loss. Can they ever play hockey? These particular players, will they be able to play again? They've lost, 3 years, prime years of their careers. Before people get put through that, there should be a hard look at whether there's even a reasonable prospect that the prosecution could be successful.
So are you saying, Balfour, that the Crown prosecutor should, that the police, the Crown prosecutor should never have brought this case forward in the first place?
Well, look, I'm not privy to all of the information they had at the beginning. I'm only privy to the comments that the judge is making. And the judge was saying that this complainant's evidence didn't stand up against hard evidence, that is, videotapes, prior statements. That hard evidence was in the hands of the authorities all along. It didn't come as a surprise during the trial. So they could have, I guess, critically looked at that and say, look, before we put these players through all of what's going to follow, we better be sure that there is a reasonable prospect of a successful prosecution.
One of the lawyers, and I've lost track, but one of the lawyers for one of the former players said it was political and media pressure that brought these allegations forward. Never should have happened. What do you make of that assessment?
Well, he may not be wrong about that. Just think of this. When the police originally investigated, no charges. They did not feel there was enough evidence to lay a charge. Yet when the information comes out about the Hockey Canada payoff and it hit the media and the suggestions that there was a cover-up, the London police said, well, okay, we'll relook at it. And apparently they say there was some new evidence. I haven't heard what that new evidence was that changed their minds. But you can just see how there is that type of pressure on them to say, okay, let's just have a trial so we can air this out. Let's just have a trial. And the point I'm trying to make is they don't consider the impact that's going to have on these accused persons. I mean, it's fine for people out there to say, well, let's just have a trial, but we shouldn't be doing that to accused. It's not fair. And we have to, your audience should understand that just because someone is charged doesn't mean they're guilty. Far from it. But here, that change in attitude by the police, how they go from there isn't enough evidence to all of a sudden there is evidence, is curious.
Balfour, good to talk to you. Thank you. Balfour Durr is a criminal defense attorney and former Crown prosecutor. The CBC's Hilary Johnstone joins me now. And Hilary, we've also heard from the London police. What did they have to say?
That's right, Andrew. They have released a statement on behalf of the Chief of London Police, who I should note only became the chief in 2023. So after that first investigation was closed. And they are saying here that they are acknowledging the decision today. And then they also go on to say this, and we can bring part of this to you on your screen here, saying, quote, as a police service, our role in the justice system is subject to the legal standard of reasonable grounds to believe that a criminal offense has been committed. This is the standard upon which arrests and charges are laid in Canada, not the higher threshold of reasonable prospect of conviction, and not the standard that guilt be proven beyond a reasonable doubt as applied by the courts. A little bit there of what we're hearing from the Chief of the London Police Service. The Chief goes on to commend what he calls the outstanding courage and strength shown by EM, the complainant here, in coming forward. Also goes on here to recognize that incidents of sexual violence continue to be underreported, often because survivors may fear or experience additional trauma within the justice process itself. This includes fear of judgment within their communities and beyond. And finally here, saying that this chief, the Chief of the London Police Service, does remain committed to investigating alleged incidences of sexual violence. But that is what we've heard from the London Police Chief just a short time ago. In some cases here, even addressing, Andrew, some of what we've heard from some of our guests throughout the afternoon. But that is what we've just heard here from the London Police Service in reaction to today's acquittals.
Yeah, interesting update. Thank you, Hillary, the CBC's Hillary Johnstone. Let's bring back Brandon Trask. He is an associate professor of law at the University of Manitoba and a former Crown attorney in Nova Scotia and in Newfoundland and Labrador. He joins us from Winnipeg this afternoon. Brandon, first of all, I just want to I understand that you were just listening to my previous interview with Balfour Durr, and do you take issue or do you have a disagreement in terms of his analysis or his assessment of what has happened today?
I mean, I guess what I would comment on is, and actually really interesting timing with that London Police Chief statement, which is entirely accurate, by the way, saying that the police have a certain standard, but that's I basically describe this to my students as like a funnel, right? So the police are the widest brim of the funnel. And they simply ask, look, are there reasonable grounds to believe that a criminal offense has been committed here by this individual? So that's very, relatively speaking, quite broad. And then the funnel gets narrower at every step, right? So the next step is the Crown figuring out, hey, do we meet our prosecution standard in order to proceed with the case here? And Ontario, interestingly, has a lower standard, a lower threshold to proceed than a lot of other provinces. So in Ontario, every Crown has to ask themselves two questions for every case. First question is there a reasonable prospect of conviction here? But in Ontario, unlike some other provinces that have even the same wording for that part of the test, in Ontario, reasonable prospect doesn't mean that you have to believe there's a greater than 50% chance of a conviction. In Ontario, it basically just means you have to have a reasonable chance, right? It could be less than 50%. But in other provinces, for instance, BC, New Brunswick, even Manitoba, the wording is slightly different, and it's been interpreted as you have to have a greater than 50% chance of a conviction in order to proceed. And so that's interesting. Again, Ontario has a lower standard than other provinces. So, perhaps this is a situation where in Ontario, a case like this goes ahead, but, in BC, it wouldn't go ahead. So I think people need to realize that, yes, the criminal code is the same across the country, but, how those prosecution standards are set and how prosecution policies are made, those are made at the provincial level. So those differ from province to province.
That is very interesting, Brandon. I did not know that at all. I think a lot of our audience didn't know that either, that there is that we do have one criminal code, but that the province's threshold is a little different in terms of whether or not cases should be brought forward. What do you make, though, of what we've heard from the complainant's lawyer who said that the justice system must do better? Then we also heard from some lawyers for the former players who said that it was political and media pressure that brought these allegations forward that they never should have been. It's kind of interesting to hear criticisms from both sides.
Yeah, I mean, I think it's really important for everybody to realize, look, no one case, no one verdict should ever be essentially an overwhelming verdict about the quality of our system. The criminal justice system is much larger than one individual case, right? And so, is every trial perfect? No, but the Supreme Court of Canada has made it clear that there's no such thing as a perfect trial. To use a hockey analogy, right? There's no such thing as a perfect game. There are always things that could be improved upon. All that really matters, though, at the end of the day, is was there a fair trial? And so that's what the focus should be on. Now we're in a situation where the Crown is going to have to decide if it's going to try to launch an appeal. They've got 30 days to try to figure that out. But they will, obviously have to make the case that there were errors of law made by Justice Carroccia. There are a few things they may be looking at specifically, considering that. But as far as treatment of witnesses, yes, you do need to make sure that essentially people play by the rules, counsel play by the rules, but also, the Supreme Court of Canada has also made it very clear that trials have a lot of different issues that are live at different points, and it's not always clear, what angle a defense lawyer may be taking on a particular topic that comes up on cross-examination. So, there does need to be some leeway granted, but you do not want to sort of cross the line. And so it's the trial judge's job to make sure that everything sort of stays on the tracks, right? And, I think people on all sides can debate whether that happened in this case, but, ultimately the goal is making sure there's a fair trial. That's an overarching consideration of our justice system for sure. It's pursuing the truth. That's a major goal, but also making sure that things are fair. And sometimes those two goals come into conflict. That's why the judge is there, guided by our laws, to figure out, what should be permissible and what should not be.
Appreciate your insight, Brandon. Thank you. That was Professor of Law at the University of Manitoba, Brandon Trask. Now, this trial is stirring a lot of conversation about the issue of consent in sports culture. For an in-depth look at this, we are joined by Landon Kenny in Cambridge, Ontario. He is a male allyship educator at the Sexual Assault Support Centre of Waterloo Region. Part of Landon's role is educating hockey players about consent rules. He has done this with the Kitchener Rangers junior hockey team and is taking part in a similar program with the OHL. Landon, what is going through your mind as you reflect on the judge's decisions?
Yeah, it's been a tough day for a lot of people in this industry, or within these kinds of organizations. But at the same time, no single organization that I know and work alongside is surprised by this outcome. Conviction rates are incredibly low amongst sexual violence cases. It is a difficult. Justice Carroccia even noted within her statements today that when it comes to sexual assault cases, it often becomes a trial of credibility, as it's one person's word against another, or in this case, one person's word against several. And in cases like that, it becomes very difficult to meet that very high burden of proof. It is a facet of the justice system that can make this work hard and make coming forward for survivors difficult as well. And as a result, we are all just trying our best to be there and support survivors and show up in solidarity with them.
And I understand you were at the courthouse earlier today. Can you tell us why did you feel it was important to be present there? Can you describe the atmosphere there?
Yeah. Me, as well as several of my coworkers, have been at the courthouse several times over the past few months, showing up, always for the same purpose, to show up in solidarity with survivors. When cases like this one make national news, when they're part of this kind of very large conversation that's happening everywhere, organizations like ours see a large uptick in the amount of calls that we receive, in the amount of intake forms we receive for our counseling and support programs. Survivors are affected by these stories very, in a very real and tangible way. And very often that is linked to the fact that they see how these stories are portrayed, and they know that if they were to come forward, they might get met with that same kind of disbelief. And so we showed up there simply to tell survivors, we are here with you, we hear you, we believe you, we are on your side and in your corner, because we think it's important for that perspective to be heard by them as well, to show that they aren't alone in this kind of situation. And I believe that was very much the energy here at the courthouse this morning, and then also throughout the afternoon. In the morning, it was very high energy. We had come in with high spirits and hope, but like I said, very few of us were surprised by this outcome. So even then, it became an atmosphere of support, of solidarity, of being there for each other, and saying, it's hard work, but we have to do it, and we have to continue to show up for people.
Landon, you do sexual consent training for hockey players. Programs like this have been embraced by the OHL, the Ontario Hockey League, and other hockey leagues. You want to remind us why mandatory sexual consent training is necessary?
Yeah, and even just outside of hockey, I think it's necessary for everybody. I think sexual consent is one of those things that it is just kind of, there's this weird societal expectation that everybody knows what to do, that everyone, but that there's also this kind of taboo about asking questions about. Nobody goes into these things knowing exactly how to navigate all of these boundaries and spaces. This consent training and education and having conversations about these things opens the door to normalizing conversations around consent and challenging a lot of the kind of harmful myths and misconceptions that many people have in regards to not just sex, but also sexual violence. And then when it comes to hockey culture, we specifically bring it to, youth teams. We have a partnership now with the OHL in order to try to facilitate these trainings with all of the OHL teams. The OHL Onsite program has been happening since 2016, and I've worked for several years in a row now with the Kitchener Rangers in order to deliver that training that focuses on not only engaging them in conversations around what is authentic consent, and what does that look like, what does it sound like, but also in helping them realize that very often when conversations like this are had with a focus on players like this or anything, it's done in a very kind of accusatory way. You have to know all about consent so that you don't harm anybody. I think it's equally important that we let people know about consent so that they can navigate these situations in their own safety and their own well-being and their own comfort. One thing that we saw, I think, plenty of in this trial was that many of the players, whether they were part of the accused or not, were very quick to say, I was uncomfortable in that situation. But many of them, I guess, in many people in situations like that, in many rooms outside of this one, find themselves in situations like that and don't realize that it's also within their power to, enforce their consent, set those boundaries, navigate these situations in ways that will alleviate that discomfort and keep them and everyone else safe.
Landon, thank you. That's Landon Kenny with the Sexual Assault Support Center of Waterloo Region in Ontario. And you are looking live at the courthouse in London, Ontario. We've been bringing you special coverage of the decision in the Hockey Canada trial. The judge acquitted all 5 accused players on all charges. We will update you on another story making news today right after the break. You're watching CBC News Network.